Good morning, everyone, and welcome to the 2024 Employment Law Seminar. Welcome virtual attendees joining us online via WebEx. At this moment, I'd like to invite the Executive Director of the Tennessee Human Rights Commission for opening words, Director Muriel Malone Nolan.
Thank you, Jacob. Good morning, everyone, and welcome to the 2024 Employment Law Seminar. My name is Muriel Malone Nolan, and I'm the Executive Director of the Commission. We are excited to have you today, whether you are joining in person or online. We're excited to have you today. My role as Director of the Commission is to oversee the agency and ensure that we meet our mission of safeguarding individuals from discrimination through education and enforcement. One of the most effective ways to safeguard individuals from discrimination is to ensure fair and equitable employment practices. Through employment, individuals gain the capacity to support themselves, their families, and pursue their life goals and dreams. It is paramount that as attorneys and human resources professionals, employment law professionals, we stay up to date with the latest practices and latest policies and best practices in employment law. This seminar will bring together experts to discuss some of the most pressing matters in employment law. We will hear from a diverse range of speakers on a variety of issues, including artificial intelligence, new technologies, workplace investigations, political disputes, harassments, pregnant workers' rights, and more. With each presentation, you will learn about best practices for some of the most difficult and challenging issues that we face today in employment law. We hope that you use this time to gain insight from our speakers and experiences and learn useful practices to implement in your places of work after you leave here today. Together, we can ensure all workers and employers, no matter their background or abilities, have an equal opportunity to succeed. I'd like to thank our partners with the United States Equal Opportunity Commission for being here today, and the State of Tennessee Department of Human Resources. They have been our partners the last several years with this seminar. It has grown tremendously in person and virtual. And I'd like to just thank them for their support for resources and planning this event. Thank you to the speakers who have agreed to share their professional insights and educate us. And thank you to the members of our board who have joined us today. Please enjoy the presentation we have scheduled for you today and take information you've learned today back to your places of work and professional communities. Now we will hear some welcoming words from our program partners. First, I'd like to welcome our partner and head of the regional office of our federal sister agency. Please welcome Delner Franklin Thomas, District Director of the EEOC Memphis District Office.
Good morning. I'd like to thank Muriel and Commissioner Juan Williams. We've collaborated to put together this seminar, and also like to do a loud shout out to the Planning Committee for all of the work that they've done in putting together the seminar. As Muriel said, my name is Delner Franklin Thomas. I am the District Director of the Memphis District of the United States Equal Employment Opportunity Commission. Whenever I stand, I make sure that I say the United States Equal Employment Opportunity Commission is the premier anti-employment discrimination agency in this country. What we do impact how folks eat, sleep, where they send their kids to school, and it is important, and the fight is still at hand. One of the things that I am very proud to say, come July of 2025, this agency will celebrate 60 years of operations. Earlier this year, we celebrated with the Tennessee Human Rights Commission in their 60th year celebration. I am proud to say more than 40 years, we have collaborated as partners to prevent and remedy unlawful employment discrimination. Today, as we gather here, it is important to know what you saw 60 years ago is not what you're seeing today. It is important that we keep our hands on the pulse of how things are moving, and this is what this seminar brings to you. 60 years ago, one person could impact whether an individual got a job or a promotion. Today, we have AI. Things could be programmed and one computer could impact hundreds, thousands. That is what the seminar today brings to you, making sure that your hands are on the pulse of how we need to show up and be effective in ensuring equality of opportunity for all. Again, thank you to Director Muriel Nolan. We look forward to your learning and participating with us today.
Okay, well, good thing I know Commissioner Williams because I don't have my glasses. Our next, we'd like to hear from Commissioner Commissioner Juan Williams, who is the Commissioner for the Department of Human Resources. I'd like to take the opportunity just to thank him for his partnership and support of the Commission. When I took this role in 2022, he has been supportive of the agency, the staff, our transitions in several of our programs. He's lended his staff to be supportive. I just want to take the opportunity to thank you since I can't read what's on the thing. So go ahead.
Good morning. Hope everyone is doing well this morning. First of all, I want to say welcome to the 2024 Employment Law Seminar. I'm sorry, I'm thinking of another labor event that's happening. From the Department of Human Resources, we are honored to be in partnership with the Tennessee Human Rights Commission, as well as the U.S. Equal Employment Opportunity Commission to put on this seminar and support. First of all, I want to thank the presenters. Really excited. Thank you for being here. I know you'll be sharing some good knowledge and sharing your expertise today. In addition, I want to thank you. I think about all you do and what you're doing to navigate these unprecedented times. And then having the ability to continue to learn and take time to understand what's going on in our world as things are changing, as the Director Franklin Thomas talked earlier, as well as Director Nolan. You're enhancing your knowledge, you're enhancing your skills. Also, you're facing unique challenges. So thank you. This annual event, it provides relevant information and tools to support you in your daily operations. The goal is to address current issues and situations in employment that you as leaders are facing or will face. Again, I mentioned it earlier, but I'm really grateful for the speakers because they're here to share their invaluable insights. But I'm even more excited that you're here and you will apply what you learn. Whatever you learn today will enhance your workplace and make a difference in your areas of influence. In closing, as leaders, you embody the vision, knowledge, and experience essential to guiding us into a brighter future. You are our greatest asset today as well as tomorrow. And your support and leadership is vital to achieving your goals or our shared goals. Finally, two things I ask of you. I ask that you be present, and also during the breaks, take the opportunity to enhance your networks. So thank you and have a great seminar.
Before we begin the seminar and the program, we have a short film presentation. We recently celebrated our 60th anniversary this past July 2nd. It was held at the African American Museum of Music, and we celebrated on the actual 60th anniversary of the signing of the Civil Rights Act of 1964. So if you were not in attendance, you missed a really great evening and celebration, panel conversation. We discussed, we reflected on how far we've come. We talked about current event issues, and we looked forward to the future and what the next generation of civil rights and issues will be. So at this time, I'd like to show the film. It talks a little bit about what the last 60 years for the commission has looked like. Some of our staff and previous commissioners will be speaking. So enjoy, and after that, I will welcome Jacob to present our first panel. Thank you. The start of this nation, we've always had differences and issues concerning civil rights. Our agency is important in Tennessee to make sure not only that we protect individuals when they have been wronged or treated unfairly, but to educate employers about what the laws are. Originally, we were the Tennessee Human Relations Commission. We got started in 1963. Our mission is to safeguard individuals from discrimination through education and enforcement. And here at the commission, we investigate employment discrimination claims, housing discrimination claims, as well as public accommodations.
When I was at the Tennessee Human Rights Commission, I began there as an executive assistant. So I would do things like support the Board of Commissioners, support the executive director and his staff, all those things, helped with the cases that were coming in. And then I moved into the position of Human Resources Director. I got a firsthand look at employment applications that were coded, and some of them would have like 40 plus. You can't discriminate against people over the age of 40, so would have that, or would have WL for white female, or BM for black male, things like that. And so I had an opportunity to see how it really worked, and then to tie that to the work that the investigators were doing and, you know, the mission of the commission.
I worked for the election of Governor Winfield Dunn. And I think in appreciation, I was a patronage appointment to the Tennessee Human Rights Commission. I think I was the only person that gave him an event that was racially integrated, so he probably thought I might be a good candidate for the commission. I was so flattered to get to do this, and it was very exciting for me. We had a director at the time named Cornelius Jones, and he explained to me when I got on that our mission was to try and help eliminate job discrimination. And I said, how does it work? And he said, well, we use persuasion. And I learned that all the states in the union except 9 had laws. New York had an anti-discrimination law against employment as early as 1945. In 1964 was when the federal government had the 1964 Civil Rights Act. Title VII of that act dealt with employment. So I quickly learned that we need a law. If we're an agency and we're using persuasion as a method of trying to get fair employment practices, that wasn't going to be terribly effective.
I worked for still work for the Tennessee AFL-CIO. A lot of issues that come up in the unions with discrimination and so forth. So I wanted to expand my knowledge into that field on how to resolve some of these issues. And if we couldn't resolve it through a grievance procedure, what was the next step? And so the Human Rights Commission allowed me to be able to help those individuals to go to another area.
In 1978, we became an enforcement agency. And so now we have the power similar to federal agencies of HUD and the EEOC to actually investigate and bring appropriate litigation whenever there's evidence that there is discrimination has occurred.
Housing always was a big issue. There was always cases with discrimination in housing and people being put out because of dogs or whatever the case may be. So I thought those cases were very interesting. The commission the staff did a great job of resolving those and coming to a conclusion.
Individuals or families would try to go rent an apartment or maybe rent a house that somebody had on the market, and how they would face these challenges, being told that it's not available when it is available. Maybe, and it could be something as simple as, they weren't married, or it could be something like they were a couple, but they weren't of the same race. It could be something like that. It was a number of things. So those were the issues I was exposed to. And again, it helped me to realize that these things were happening, but more than that, I began to think, how can I make an impact in this small place, in this big world, but this small agency, this small commission? How can I learn this stuff and realize what's happening and help in the way that I was hired to help?
Being able to work with the staff, that was the biggest gift to me. To be able to call them up and say, hey, what's going on? Just daily talking with them and see how well they work together.
We started as of a staff, I believe, of 2 or 3 individuals. We have grown tremendously. We could probably use twice as much staff. We are an agency now of 33 individuals across the state.
I would love to see the commission expanded, get bigger, and have a lot of different coverages in the area. And in particular, the rural areas. I think that a lot of times in the rural areas, people don't always hear about the commission. And I think that if we can expand and get into some of the other counties besides the major counties, we would be really welcome.
In the next 60 years, I still see this commission here and relevant. As long as we have a Civil Rights Act, we have a nation, we will have a need for this agency and agencies like this.
I hope to see more interest and people knowing that this is one commission out of many. There are a lot of things happening here in Nashville and in Tennessee that are important, but this one is important because it has the potential to impact everybody. Some people are oblivious, to discriminatory practices because they just haven't experienced it. But because of how we're made and how things have changed so much, I hope no one ever experiences, but there's so many ways you can experience it directly or indirectly that I think it's important.
We are the only state agency that actually has enforcement powers when it comes to housing discrimination and employment discrimination complaints. I would like for our agency to be at the forefront of whatever the problems are, kind of before it becomes an issue in the state. I want us to continue to train, become knowledgeable, informed about what's going on in the nation so that we can be ready to assist citizens. The start of this nation, we've always had differences.
I think I was the only person
All right. Well, first off, really proud to show that video with you all, as that's something, as the Director Nolan had stated, that the Commission worked really hard on and got many contributions from former THRC staff, as well as former THRC commissioners. My name is Jacob Aparicio, and I am the Communications Director with the Tennessee Human Rights Commission. A lot of you are probably familiar with my name, as I've been blasting you with emails over the past few weeks and months about the Employment Law Seminar, so I'm very excited to have you all here today. Before we jump into our first presenter, I did want to give a few housekeeping notes for everybody, both in person as well as virtual. So for in-person attendees, as you all registered, you were given a red tote bag with some materials inside. In that tote bag, there are the programs for the ESL. So within that program itself, you can find the agenda for today, when our breaks and presenters will be speaking. You also will find some documents that we'll bring back up at the end of the seminar, including the CLE attestation forms, HRCI credit information, as well as our evaluations. So just hold on to those documents to the end of the seminar. But if you'd like to learn more about the agenda today and our speakers, you can find that information in the programs. Also, food, we will be having lunch at 11:20. Right now, currently, we have some continental breakfast items and coffee outside. So if you want to grab a snack, feel free to step out in the hallways, and we will have lunch at 11:20. One last thing for in-person attendees, bringing it back to our 60th anniversary. If you look around the room, you will notice that there are these large blue panels. This is actually an exhibit that we made and we showcased at the 60th anniversary. It is a 6-panel exhibit highlighting 60 years ago, the founding of the Civil Rights Act of 1964, as well as what was going on in Tennessee in civil rights and the civil rights movement in the state. So when you have moments during the break or during the lunch, I encourage the attendees to go around, read the panels, learn about our history of civil rights and anti-discrimination. For online virtual attendees, if you have any questions, there is a chat function. Please submit any questions you have or comments to the panelists on the chat using the chat function. They will have access to the presenters throughout the day and be able to submit any questions you have to the presenters on your behalf. Also, for virtual attendees, there is a closed caption function. So if you want to have a better sense of what the speakers are saying on the webinar platform, there is a closed caption function with a button. It's kind of like a speaking bubble with double C's. Feel free to submit a question to the panelists if you need directions on how to access the closed caption. With that said, those are my housekeeping items for today. I would like to next up invite one of our members of the Planning Committee, Mr. Andrew Puryear, Senior Associate Counsel with the Tennessee Department of Human Resources, for the introduction of our first speaker. Everybody, please give a welcome to Mr. Puryear.
All right, a lot of applause for someone who's not presenting this morning. Good morning, everyone. For those who are in here in person, also to all those folks, a lot of folks joining virtually, we really appreciate your interest, your passion for employment law, and the evolving landscape as we see it today. For those of you who I haven't had the opportunity to meet, my name is Deborah Puryear with DOHR. Many of you know me probably because I've copied you on various emails, so it's nice to put a face to a name. And this morning I have the honor of introducing our first speaker, Ms. Melissa Thomas. I want to give a little background on her work with DOHR. She's currently an HR administrator with HR Business Solutions team, and in that role, she leads a dedicated team of HR and talent management business solutions folks, and they support cabinet level agencies, boards and commissions across the state. A little fun fact, apparently Melissa has wanted to be an attorney since she was a child. I can only imagine those arguments with the parents. She discovered her passion for government while taking public administration's classes. By working with the state, her goal and her passion was to merge those two loves of the law and public service. And outside of work, her and her husband are apparently giant Beatles fans, as she's gotten to see Paul McCartney live in concert. And today she'll be speaking on a topic that's both fascinating and timely in the legal and employment law landscape, AI in the workplace, from automation to regulation. So with that being said, please give a round of applause for our first speaker, Ms. Melissa Thomas.
All right, good morning, everybody. Thank you. Thank you for that welcome. I am really excited to be here today to talk to you all about a topic that I'm incredibly passionate about and slightly knowledgeable about. So it should be fun to talk to you about this. To give you a little bit of an introduction, I'm going to show you who I am, but this gives you a little bit of background. Andrew gave you some more information about me, but I am the the program administrator for the HR Business Solutions team in DOHR. I lead a team of HR and talent management business partners that support 15 agencies, boards, and commissions across all of state government. So we have a lot of appointing authorities that we support, including the Human Rights Commission is one of our customers. Something not about the screen, I've got a whole bunch of information up there, my strengths and things about me. One of the things that's not up there is that I am incredibly passionate about AI. And the future of AI in the workplace. And so that's how I've gotten selected to. I volunteered myself for the HR conference to talk on this topic, and it's just grown over the last several months. So that's a little bit about me. I found out a little bit about you when we did the survey for the conference or the seminar, and I asked you, how many of you have been using AI already in the workplace? How many? And overwhelmingly, you all said no. So I think we're going into it today with a pretty blank slate on this is a new topic for us. This is the future. This is where we're headed, and we're all interested in learning a little bit more about AI. So I'm going to do a little icebreaker here, and what we're going to do is just show of hands. I'm going to ask you a series of have you ever questions, and you just raise your hand. So we're going to get to thinking about AI. So for the first one, how many of you have used an AI chatbot? That could be ChatGPT. You might have used the chat feature on Amazon when you're shopping or any kind of virtual platform. So raise of hands. How many of you have used an AI chatbot? A lot of you. All right. Next, how many of you have streamed from a recommendation algorithm? So say, for example, you're on Netflix, you finish watching a TV show and it pops up and it says, hey, you might like this show. And so you click on it. Raise of hands. Most of you. How many of you have interacted with a voice assistant, such as Siri, say it slow so she doesn't, or Alexa, or maybe Google? Yeah, pretty much everybody. How many of you have used facial recognition to unlock your phone or another device? Yeah. Encountered an AI-powered hiring process? Maybe a little less, but you probably have and you didn't even know that you had encountered it. And last one, have you received targeted ads online? You're scrolling through Facebook and it's telling you things that you're in your head going, did I even say this out loud? Like, I'm pretty sure Facebook is now a mind reader. So targeted ads. The point of all of this is to tell you all of these things are AI, every one of them. And it is all around us, and we are interacting with it every single day already. AI is not the future, AI is the present. We are already here, and it is continuing to rapidly evolve every single day. Here's our roadmap for this morning. I'm going to give you a basic understanding of AI. I think it's important, especially for us that are not IT techie gurus, to have a basic understanding of the terms that those IT folks will use around us. And it's important because you should go into it knowing what these things are so that you can challenge it, so that you're well informed. And when they are using words like an algorithm, you know what an algorithm is and why it matters. We're going to talk about legal and ethical considerations. I'm going to tell you all the ways it can be done wrong, or some of the ways. There's a whole lot more. But we're going to talk about ways that AI can be misused in the workplace, intentionally and unintentionally. I'm going to bring it back around after I scare you. We're going to talk about how AI actually fits in the workplace. Where does it make sense in the workplace? And then I'm going to talk about your role as an employment law practitioner. Speaking of, so before we dive in, I want to start with this question for you. This will be rhetorical. I want you thinking, what role do you believe that employment law practitioners, so this could be any of you, really, if you're in this room, you're probably practicing employment law in one form or fashion. This could be HR professionals, in-house counsel, employee relations managers, for example. What role do you play when it comes to the implementation of AI in the workplace? So let that sit in the back of your mind as we're talking through what AI is and what the legal ramifications of it are. Let that sit in the back of your mind. And we're going to come back around and revisit that here at the end. So this isn't our first rodeo with AI, or with a major technological change in the workplace. If you think way back, I'm going to throw us way, way, way back. When computers were first introduced into the workplace, that was a major technological shift that we had to overcome. We had to learn. It was scary. It was unknown. And so we navigated that change, and look where we are today. We can probably imagine life without computers in the workplace now, and that's where we're headed with AI. This is another major technological change for us, and we're going to be looking back in a few years going, wow, how did we ever live without it? So first, let's start off with what is AI? I think a lot of us think of this as a brand new term. This is new. This is something in the future. We don't really know what it is. It seems like maybe it's apocalyptic, right? It's the end of the world type of situation. That's not what AI is. AI, artificial intelligence, this is the technical term. It's the development of computer systems that can perform tasks that typically require human intelligence. Things such as learning, things such as reasoning, problem solving, perception, and even understanding our language. AI is what makes it possible for machines to mimic human cognitive functions and to make decisions based on data. So we're going to talk more about data here in a minute, but that's an important part of what artificial intelligence is. I'm going to give you a really brief history because, like I said, we think of AI as something, this is new, it's not. It's not new. It's not new at all. It's been around for a very, very long time. I'm going to throw it all the way back to 1950 with the Alan Turing test. This is when they started talking about if a machine can trick a human into thinking it's human, that it has intelligence. So that's kind of where we start, is 1950. 1956 is really when we talk about the birth of AI. John McCarthy, he introduced the term artificial intelligence. So we have actually had the term artificial intelligence since 1956. Long time, what's almost 70 years that we've actually been talking about artificial intelligence. 1964, Weizenbaum, he introduced something called the chatbot. It was Eliza, and it was actually kind of a basic chatbot that was capable of holding human conversation. 1997, IBM's chess playing computer, Deep Blue, defeats the world chess champion. 1999, Sony launches Aibo, and this is the very first robotic pet. We've seen them go a long way since then, but Sony introduced Aibo, and this was a robotic dog that could actually start developing a personality. So it would start out with one thing, and its personality would evolve over a period of time. 2002, that little device that we all love that keeps our floors clean, the Roomba, it was first introduced 22 years ago. Roomba was there. And so Roomba used AI to create autonomous mapping of our houses, right? And so to do that task that none of us want to do, that sweeping and that mopping, we have that since 2002. 2011, Apple introduced Siri. That's when it came about, 2011. Also in 2011, IBM's Watson defeated human contestants in Jeopardy. 2014, Amazon finally got with the program what Apple was doing, and they introduced Alexa, which is the intelligent virtual assistant capable of completing tasks like shopping, and it's completely evolved. It powers my house. It seems like now my lights come on automatically because of it. So we jump ahead from 2014 to our next big one, which was 2020, when OpenAI introduced GPT-3, which is a powerful tool for generating human-like text. And then 2022 gets us to where we are today. And this is when OpenAI launched ChatGPT, and that's what got us all talking about AI, ChatGPT. And it became available for public testing, and ChatGPT was the first thing to really show us what the future could be like. And so we're going to talk more about that. Told you I was going to give you some key terms. So I want us to have a basic understanding that when we sit down with our IT people that are saying, hey, you can automate this using AI, you have an understanding of the terms that they're using. And the first one, what I think is the most important term that you should know, is what's an algorithm. This is a very technical term, and it has some pretty important ramifications when we talk about AI. It's a set of rules or instructions that a computer follows to perform a task. Algorithms are the foundation of AI. It's what makes AI work. And this enables machines to make decisions and solve problems based on data. So that's what an algorithm is. I'm going to show you a video at the end of this section that's going to give you a little bit understanding of why algorithms matter when we talk about AI. The next term is machine learning. This is the type of AI where computers learn from data without being explicitly programmed. So you put something in, and it learns from the output of that, and it develops new content, or it develops new data from the data that you've put into it. Machine learning helps systems improve over time by recognizing patterns, making predictions, and adapting based on new information. The next one is natural language processing, and this is AI that enables machines to understand, interpret, and then generate human language. And examples include virtual assistants like Siri and Alexa, and language translation tools. Generative AI, this is the term everybody's hearing now. This is what we're really talking about. And this is AI that can create new content, such as new text, images, and it can also create music and videos. These are tools like ChatGPT, and they use generative AI to actually produce original work. That's what comes out of AI, or the generative AI. Prompt engineering, you'll see this in a video towards the end. This is a really important part of being able to use AI well, is how you talk to it. And that's basically what prompt engineering is. It's how you talk to the machine to get the outputs that you are looking for. And so it's how you have that conversation with it. Predictive analytics is the technique that uses data, statistical algorithms, and machine learning to predict future outcomes. Open source versus closed source. This is really important, especially as you are practicing employment law and you're having conversations with your workplaces. This is really important. Open source, these are AI models and tools that are openly available for anybody to use. Think about Wikipedia, for example. We have actual encyclopedias that go through vetting processes, and they make sure that the data in them is good, it's verified. And then you have Wikipedia, which is an open source, and anybody can edit it, anybody can access it. And that's kind of what this is when we talk about AI, is the ability to who gets access to it and who gets to put into it. And so that is what OpenAI is, or open source. Closed source, on the other hand, uses secure data, and only certain data goes into it, and only certain people have access to it. Companies like Google and Apple, they keep their particular AI models closed, and in state government, our own organization is looking towards how can we implement AI, but do it in a way that is closed source. So our data stays our data. We only put into it what we want into it, and only our people can access it. Deep learning. This is a subset of machine learning that we learned about, and it uses what's called neural networks. These are many layers that analyze vast amounts of information. And deep learning powers advanced AI application tools like facial recognition and autonomous driving. Speaking of neural networks, this is a type of machine learning. It's modeled after the human brain. So think about all those like synapses and all those things in the human brain where you see the branches. These are used to recognize patterns, classify data, and make complex decisions. And then the last one is algorithmic bias. I'm going to show you a whole video that's going to talk about algorithmic bias here in a little bit. But that is the concept that in an algorithm, the data that goes into it, the success definitions can create biased outcomes. All right, Jacob, our first video. While he tees it up, this is a very short, it's like 2-minute video to give you a little bit better understanding of what an algorithm is and why it matters.
I worked as a mathematician and then as a quant in finance. I saw the worst of finance. I went into data science and I was struck by what I thought was essentially a lie, namely that algorithms were being presented and marketed as objective fact. A much more accurate description of an algorithm is that it's an opinion embedded in math. An algorithm is a very general concept. It's something that we do actually in our heads every day. To build an algorithm, we need only 2 things, essentially: a historical data set and a definition of success. So I build an algorithm to cook dinner for my family. The data that I use on a daily basis is the ingredients in my kitchen, sometimes the time I have, the ambition I have for that dinner. And then I assess the dinner after the fact. Was it a success? I define that because I'm the one who's building the meals. I'm in charge. I have the power. So there's always a power element here. So I get to decide a meal is successful if my kids ate vegetables. My kids, if they were in charge, would have defined it differently. And it matters because as we optimize over time, we optimize to success. The succession of meals that I cook from month to month is a very different path of meals than if my son were in charge. So we do that every time we build algorithms. We curate our data, we define success, we embed our values into algorithms. So when people tell you algorithms make things objective, you say no. Algorithms make things work for the builders of the algorithms. In general, we have a situation where algorithms are extremely powerful in our daily lives, but there's a barrier between us and the people building them. And those people are typically coming from a kind of homogeneous group of people who have their particular incentives. If it's in a corporate setting, usually profit, and not usually a question of fairness for the people who are subject to their algorithms. So we always have to penetrate this fortress. We have to be able to question the algorithms themselves, especially when they're very important to us. We have to inject ethics into the process of building algorithms, and that starts with data scientists agreeing and signing to a Hippocratic oath of modeling. But we have to stop blindly trusting algorithms to be fair. They are not inherently fair, and start looking into what they're actually doing.
So just to kind of sum that one up, this is why it matters, because what an algorithm is not just, oh, the computer took care of it, the computer makes it fair. That's not true. The computer's only as good as who programmed it, right? The data that goes into it and what somebody said was a success outcome. And if either of those 2 things are not fair, if they are discriminatory, you are going to get discriminatory outcomes out of it. You just are. It's not inherently fair. And so I hope my point of showing you that was that you have enough understanding now that when these conversations come up, you can say, well, what data is going into it? What does success look like? What have you programmed to be success? So you can question the algorithm, and that's important. I think that's an important part of what our role is supposed to be in the workplace. So next up, we're going to talk about legal and ethical considerations. And in your pre-seminar survey, I asked you, what do you think are some things we should be thinking about? What keeps you up at night regarding AI? And this is what you said. I had to kind of sum it up and give it some themes, but overwhelmingly, confidentiality. That was an important thing. Y'all said this is weighing on us. Bias. We're concerned about those biased outcomes that may come out of AI. Misinformation and accuracy. Is what AI is giving us, is it even accurate? Is it even legitimate? And that's a really good concern to have. Compliance. How are we ensuring that we are following rules and laws and regulations that we are supposed to be following? And we're going to talk a lot more about that when I give you some case law. Privacy, copyright, hallucinations. Talk about them here in a second. Oversight, empathy. We had a few responses about, hey, are we taking the people part out? Like, how do we ensure empathy in what we do? To tell you a little bit more about the risk associated with AI. So there's several different buckets. There's a lot of conversation around risk. There are a lot of risk when we think about the implementation of AI in the workplace. So the first that I want to talk about is bias. And so this happens when AI systems, as we talked about, can reinforce harmful stereotypes. An example could be facial recognition system that's less accurate in identifying people of color, or when language translation systems associate certain languages with certain genders or stereotypes. The next one is hallucinations. This is an interesting phenomenon when in an AI system, especially like a large language model, that means lots and lots of data going into it. It's common and not completely rare that generative AI chatbot or other computer tool can perceive patterns and objects that are actually non-existent or imperceptible to human observers. And it picks up little bits and pieces and it thinks that that's actually there, and it drives the outcome that comes out of the whatever the prompt is. And so I'll give you an example. Obviously, I had to use AI, right, when I was creating this information back in the summer when I was doing the presentation for the HR conference. Why not? And so if we're going to do a presentation on AI, let's use some AI. And so I asked it to, gave it the prompt of, give me some cases related to the AI in the workplace, give me citations and a case summary. So it gave me a whole bunch of potential cases and said, here are some really great information. These are some cases, gave me some actual citations. And I did what any good attorney should do, especially if you're using AI. I went out and vetted the information that came out. And so this is a good starting point for me. And I looked up the cases. So I had found one. I said, ooh, this is right on point for what I want to talk about. I searched the citation. And when I pulled it up, I started reading the case. I'm like, this is not what that said. This is not that case at all. It wasn't even remotely related. The year was even wrong. And so that's a hallucination where it thinks it's real. It thinks it's giving you real data, and it's not. And so that's the importance of verifying the information that comes out of your AI chatbots, your AI systems, is making sure it's actually good information, that it's valid. I still use it despite it giving me bad information, right? Like I'm gonna still use AI, I'm just gonna verify the information that's in there. The next one is privacy and security. So AI can sometimes, people fail to give users control over how their data is used. And there's something we call opaque data practices. And this is where we're just not transparent with what's going in the system and how is it being used in making decisions. The next one are ethical dilemmas, and there is a whole list of ethical dilemmas related to AI. A few of those include the transparency and accountability. Like this thought that AI goes into this black box and it's just there and nobody really knows what's in it, how to get anything out of it, what's even there. The next one is autonomy and control. As AI systems become more autonomous, there's concerns about the potential loss of human control over it. Job displacement, us in the workplace, we're thinking about that. What does that look like for us as we transition and thinking about upskilling employees? And how do we navigate those waters similarly to what we did when computers first entered the workplace? Security and misuse. AI, there's the potential that AI could be used for malicious purposes. There are bad actors out there that want to get control of these systems and use it to do harm to other people. Accountability and liability. We're going to talk about that in the case law of who's responsible. If you get a discriminatory outcome out of an AI system, who's responsible for that? Like, who do you point the finger at when it's a system that's making the decision? And then the other one I want to hit, let's see, there's AI in criminal justice. There's been the use of AI in predictive policing. That's a concern, potential for AI to be used in warfare. And then bias and content recommendations. The AI-driven systems can reinforce existing biases and potentially filter your bubble based on what it thinks that you like. So it just controls the content to what you want instead of giving you more diverse thought. So there are a whole host of risk and ethical considerations that we need to be thinking about. And then there are some legal and regulatory challenges as well. So potential violations of intellectual property rights. If it pulls you information just out of the web and it puts it in there and pretends that it's real original content, it's probably not original content. It's taking somebody else's content and made it new content. How do we navigate those waters when we're talking about intellectual property? Data privacy issues, both in relation to the general data protection regulations as well as other consumer privacy acts. Violations of employment regulations, inappropriate usage of copyrighted data, disputes concerning contract law when generative AI is used, consumer confidentiality and issues with personally identifiable information, PPI, and how that goes into the system, and then inaccurate usage of generative AI outputs. Just to list a few. All right, so next up, Jacob, I've got another video. So this next video, while he gets it teed up for us, this one's called The Discrimination Dilemma. Netflix, a few years ago, released something called The Social Dilemma, and it really talks about, if you've got kids, I really encourage you to watch it. It's kind of scary, but talks about social media and the impact that it's having on society. But then the discrimination dilemma kind of takes it a step farther to really talk about what is AI and what does that look like in terms of discrimination. So really good video.
And if there are ads, apologies. Try to tee them up.
Probably be an ad.
Yeah, it looks like there would be one.
Algorithms are not objective.
AI and a lot of these emerging technologies are perpetuating bias.
They don't predict the future, they cause the future.
I spend a lot of my time thinking about bias, but that's just who I am. And also the lack of government understanding on these issues that result in the lack of regulation and laws to really help mitigate some of the problems that we're already seeing with AI.
Algorithms are not objective. Algorithms are optimized to some definition of success. It uses historical data to predict future success. People blindly believe that algorithms are inherently fair and objective, and partly because they believe in that fairness, they don't question the algorithm. And so when the algorithm ends up being as racist as the data that we put into it, is perpetuating exactly the patterns that we wish that we could transcend.
Systems are ingesting tons of information without context, without the history, without even the political and economic and social implications. And so you have a greater likelihood of an AI system embedding those biases or even making them worse.
There are 4 categories of algorithms that I think are being misused and that could cause serious harm to society. The 4 categories are financial. These are algorithms that decide whether people get insurance and how much they pay, whether they get good credit cards, whether they get mortgages, whether they get housing. If you go to a credit card website, you don't get information about credit cards. You get sized up and sussed out, and they show you the credit card they think you deserve. The second category is liberty related. How are you policed? How long do you go to prison? Do you get incarcerated awaiting trial? The third category is livelihood stuff. Your job. Do you get an interview for this job you've applied for? Do you get the job? Do you get a raise? What hours do you work?
One example that got a lot of media coverage was a hiring algorithm that disproportionately favored individuals whose names were Jared and played lacrosse because the majority of individuals that performed well in that company had those 2 facts in common.
And then the fourth category is information itself. How do we get information? What do we believe? Political information in particular. All those things are algorithms now, and often they're unfair, and often they're illegal, but we have not figured out how to enforce our anti-discrimination laws. The dystopia that I worry about is that we don't put a stop to opaque, harmful algorithms. Hey, we profiled you from birth. We noticed that you grew up poor in a neighborhood where lots of people don't succeed, and we're going to predict that you're not going to succeed. And not only are we going to predict you're not going to succeed, we're going to make sure you don't succeed. So you're not going to get into a good college. You're not going to get a good job. You're not going to get a good loan, because that's what algorithms actually do. They don't predict the future, they cause the future.
Scary, huh? I mean, to me, it is that, it's really kind of telling of the situation that we're in. 2 questions at the end.
Question.
I was going to do them at the end.
Oh, yeah.
Yeah. Make sure we get enough time to get through all the content. So please save your questions. So that with this one, this is actually about 3 years ago that this was released. And since that time, the government actually has done quite a bit to start to address the concerns that AI is causing in society. There we go. I'm going to talk really briefly about the first 2. So we're going to talk about executive order on AI and what we say will come out the White House, the blueprint on an AI Bill of Rights, and then we're going to spend a little bit more time talking about the regulatory agencies that we interact with in the workplace so that we know and talk about what they're doing and the guidance that they're issuing. The first one is President Biden's landmark executive order on artificial intelligence. This came out, was signed by him on October 30th of 2023, so it just hit its kind of 1-year anniversary. And it provides a strategy to promote the development and the use of AI technologies. The order directs federal agencies to prioritize AI research and development, promote education and workforce training on AI, as well as establishing guidelines to ensure that AI systems are ethical, secure, and trustworthy. And the key objectives coming out of this executive order are to foster public trust, protect privacy and civil liberties, and ensuring that AI benefits all Americans. So that was the objectives of what they're hoping to achieve with that one. The next one is the AI Bill of Rights, and this was proposed by the White House. It represents an effort to safeguard the public from the potential harms of artificial intelligence and automated systems. The initiative is part of a much broader strategy to ensure that AI technologies are developed and used in ways that promote fairness, accountability, and transparency. So there are 5 main areas from the AI Bill of Rights. The first is to ensure that AI systems are tested and that they're monitored to be safe and effective. This includes preventing harm to individuals and communities by maintaining high standards for performance. The next is that it prevents AI from exasperating or creating discriminatory practices. And this principle emphasizes the need to identify and mitigate biases in algorithms to ensure that they don't lead to unfair treatment of protected classes. The next is that it safeguards personal data and ensures that individuals have control over their information. And this includes implementing robust data protection measures and providing transparency about how data is collected, how it's used, and how it is shared. The fourth is that it requires individuals to be informed about how AI is being used in decisions that are going to affect them. And this means not putting little bitty fine print at the bottom of things, making it actually something that is understandable by the lay user, making sure that the terms that we're using are not using terms like an algorithm or something that's vague and you don't know, but being clear and transparent with how this is being collected. And then the fifth, and this is when you're doing research on the AI Bill of Rights, this one comes up as being a little bit more talked about because they say it shouldn't be at the bottom of the list. We should put this one at the top of the list, is how do we create human alternatives for AI systems? So if you're a part in, you found yourself stuck in an AI decision-making process, how do you opt out? How do you say, give me a human, right? Like if you're on the phone trying to reach Comcast and you're just in this cycle of I'm never getting my question answered because I'm not asking the right question, and you're screaming, going human, human, human. How can we make that accessible for individuals in these AI processes and making sure that humans are still an important part of it? our regulatory agencies. Spend a little bit more time talking about them. So I'm going to start with this joint statement on enforcement related to civil rights, fair competition, consumer protection, and EEO laws. So over the past few years, federal agencies have been coming together and issuing joint statements regarding AI. This started several years ago with just, I think, 3, maybe 4 agencies coming together. And as of April of this year, the newest statement that they released had 9 federal agencies a part of it. And so this included federal agencies such as the Federal Trade Commission, the Department of Justice, the Consumer Financial Protection Bureau, the EEOC, just to name a few, and there are more. The updated statement underscores the collaborative efforts of these agencies to address the challenges posed by AI and automated systems, particularly those that relate to civil rights and ensuring fair competition. This new statement, it said a few things. So the first is the protection of civil rights. The statement emphasized that automated systems, including AI, must be designed and used in ways that don't discriminate against individuals based on protected characteristics. The agencies reaffirmed their commitment to enforcing civil rights laws and holding entities accountable for discriminatory practices enabled or exacerbated by AI technologies. The second is the promotion of fair competition, and the agencies through this joint statement stress the importance of maintaining fair competition in the marketplace, and they caution against using AI systems for anti-competitive practices such as price fixing, market allocation, and other forms of collusion. The next is consumer protection. They emphasize protecting consumers from unfair or deceptive practices. This is another key function of the statement. The agencies highlighted the potential for AI to mislead or harm consumers through unfair advertising, predatory lending, or other exploitative practices. And they committed to using their enforcement powers collectively to address these risks and safeguard consumer interests. And then the last one is equal opportunity. And the statement reiterates the importance of ensuring equal opportunity in areas of employment, housing, and credit. And it calls for robust measures to prevent AI-driven systems from creating or perpetuating barriers to access and opportunity for marginalized groups. They give a few examples in the statement of ways that we can do this that included algorithmic accountability, transparency and explainability, and collaboration and stakeholder engagement, really engaging the community and making it's not just the federal agencies that are rolling this out, but we're all in this together. All right, let's dig into a couple of our agencies. We're going to talk about Department of Labor and EEOC and what we're seeing come out from them. The first is Department of Labor. They are the agency that enforces labor standards and workers' protection rights. The DOL enforces laws related to wages, hours worked, occupational safety, and health, and they ensure compliance with laws related to family medical leave and the Fair Labor Standards Act. The DOL this year recently issued new guidance to address challenges posed by AI in the workplace, particularly those concerning the FMLA and the FLSA. In late April, the administrator for the Wage and Hour Division released its bulletin. So this is something that goes out to all staff to kind of give guidance on things that they should be looking for. And it focused on a few key areas. And so first I want to talk about examples of AI and FMLA and where they say their folks should be vigilant in looking for these problems. And the first is automated leave requests. AI systems that automatically approve or deny FMLA leave requests based on predefined criteria, they can potentially lead to non-compliance with the law. So for example, an AI system might deny leave based on a lack of specific medical documentation without considering broader context. And that could potentially violate the FMLA. The second is monitoring and tracking attendance. And so there are AI tools out there that can do these things. They can monitor attendance. And Department of Labor is saying that there's potential for AI systems to flag excessive absences, inadvertently penalizing employees for taking FMLA leave. And that the AI system doesn't properly account for protected leave, that it may run afoul of the FMLA. And the last one is return to work decisions, that AI systems that automate return to work after FMLA leave may fail to consider necessary accommodations that may need to be made in the workplace, or phased return to work plans, for example, and that could potentially lead to a violation of the FMLA. Some examples of AI and the Fair Labor Standards Act include overtime calculations. They say that AI systems can calculate overtime pay may not always take into consideration all compensable hours. So for example, when you walk into the building and you are at work, that time between getting there and maybe getting your computer system booted up is still compensable time. And so if the AI system doesn't know you're working because you're not sitting at your computer, it may not be calculating that period of time as hours worked, even though it is compensable time. Misclassification of workers. AI algorithms that are used to classify workers as employees or independent contractors could potentially misapply legal standards, resulting in misclassification or denial of rightful wages or benefits. And then the next one is meal and rest breaks. These are very state law specific as to what's required for meal and rest breaks. And if an AI system doesn't know that an employee maybe in another state has a different law related that governs them, it could potentially run afoul of the meal and rest breaks. And the key takeaway here from Department of Labor is that they emphasize that while AI certainly can streamline your operations, make things more simple for you, and improve efficiency in employment practices, that it must not be done so in a way that undermines workers' rights. We still have to keep that. And then they really stress the importance of human oversight. And that's kind of the underlying theme of most of this, is that humans still play an important role in making sure that AI systems are being used and used in a way that is appropriate and fair. Let's talk about the EEOC, our sister agency for us today. The EEOC is the federal agency that enforces laws related to employment discrimination, as you know. And they have actually been increasingly focused on the implications of AI in the workplace, particularly how AI and algorithmic decision-making can impact equal employment opportunities. They have been issuing so much stuff on their website, so much guidance for employers and workers alike, putting lots of information out for us. The EEOC has emphasized the importance of ensuring that AI systems are designed and used in a way that comply with federal anti-discrimination laws. And they really have warned that employers need to be vigilant about the potential for AI to perpetuate or even exacerbate existing biases in employment practices. The Artificial Intelligence and Algorithmic Fairness Initiative, this came about in 2021. The chair of the EEOC launched this initiative, and it aims to ensure that the use of AI and other algorithmic decision-making tools in employment practices respect civil rights laws. The initiative focused on a few things, and this included raising awareness by educating employers, employees, vendors about the potential for a bias in AI systems. Really just that understanding of, hey, it's there. The possibility is there and you need to be aware of it. The second is providing technical assistance. They are providing guidance to employers so that we can comply with anti-discrimination laws when using AI. I'm going to show you just a few on the next slide of some of the things that they've put out. And then they have been developing guidance. They've been issuing technical assistant documents to help employers navigate the complexities of AI in employment. I'm not going to talk about all of these, but I wanted to give you just a few examples. These are actual documents that you can go out to the EEOC's website and you can pull. They are issuing all sorts of information, such as how to address visual disabilities in the workplace, ensure compliance with the ADA as it relates to AI, how to use AI in testing and selection for the hiring process, and other practices to prevent discrimination, harassment. If you have not yet gone out, I really encourage you, go to the EEOC's website, search artificial intelligence, and start pulling up their documents. There are lots of great resources out there available for you to utilize. All right. Now for the attorneys in the room, we're going to talk about some case law. So there's actually not a lot of cases that have actually resulted in good case law for us to use because this is a rapidly evolving topic. Most of the cases that are out there are cases that have been settled and didn't actually result in a decision from the court. And so we pulled together what we can get, and they're rapidly evolving. I'm going to give you one that's of just a couple of months ago. Jacob, the battery is running low. We're off to a great start. Okay. This first one, since we're on EEOC, here we go. Okay. We're going to talk about iTutor. So iTutor is a system where they're an organization that employs people all over the world virtually to do English translations or English tutoring services. In this case, so the EEOC filed a lawsuit against iTutor for discriminatory practices. What's interesting with this one, it's pretty blatant. What they did was iTutor plugged into their system that we want to automatically reject women over the age of 55 and men over the age of 60. I mean, that's pretty blatant discrimination. There's no data set that it's pulling from. They plugged in specific factors and said, exclude this group of people, these two groups of people. And we know that that's discrimination, right? And so what's interesting about this case and where it really starts, there's some good information that's come out of it. It did settle out of court, but if you know anything about the EEOC, they do not waste an opportunity to make a public example out of you if you have to settle a case with them. And so they issued a statement following this case. And this is what the EEOC chair said. She said, age discrimination is unjust and unlawful. Even when technology automates the discrimination, the employer is still responsible. And I included this because what iTutor was trying to do was say, we didn't make the decision. We didn't exclude those applicants. Our automated system did. Well, you're the one that plugged it in. You're the one that told it to discriminate. And guess what? By the way, you're responsible for the systems that you implement. It's nothing new. We already knew this, right? You're responsible for the technology that you implement in the workplace. And so that's the important piece that came out of this one, is that you're still responsible. If you plug it in, you can't hide behind your AI system and say that, well, we didn't make the decision, the system made it. The next one, this is new. Mobley versus Workday. We have, it's still working its way through the court system. There's still an active lawsuit out there. And this was actually filed in February of 2023. Mobley, he's an African-American man over the age of 40. He also claims that he has some mental health conditions as well. And he claims that he was discriminated against based on his age, his race, and his disability through the use of automated systems. He said that he was automatically rejected more than 100 times through automated systems, and he's alleging that, hey, this system can infer, because I went to a historically Black college and university, that they can infer my race. They know what my age is because they made me put my birthday in, and they may know what my race is, or they know what my, they're doing intelligence testing or personality testing so they can determine that I have a condition, and they're automatically rejecting. Now, whether or not there'll be a finding based upon that, what's important in this case is that in July of this year, Workday filed a motion to dismiss, and the court denied it. And the court said that there is no meaningful distinction between software decision makers and human decision makers for purposes of determining coverage as an agent under anti-discrimination laws. So what they're saying again is you are a responsible employer. If you utilize software, you utilize AI, and it creates discriminatory impact, directly or indirectly, you are responsible for the software that you implement. So that's the important piece that's really already come out of Workday. If I were to guess, I'd say it'll be settled, especially knowing that the court has said we're going to go to court. The next one, I'm going to take you way, way back. You can see the year on it, 1971. Let's talk about this case. Attorneys, you learned about this one in law school, and it's an important case. It was important then, and it is still important now. It is still good law now. This is Griggs versus Duke Power Company. This was a landmark Supreme Court decision in 1971. So what happened in this case? Duke Power had implemented an across-the-board practice of if you are going to promote or you are going to transfer in this organization, you must have a high school diploma and you must pass some standardized intelligence test. Across the board, everybody, didn't matter, you know, if you were male, female, what your race was, what your age was, everybody had to comply with it. So this one ended up going to the Supreme Court, and the rule of law that came out of this one is disparate impact. It's a term we all still know, we still talk about it, right? And that is where you may not have plugged in and you may not have made a decision that was specifically discriminatory, like what iTutor did when they discriminated against women over the age of 55 and men over the age of 60. That's very blatant. That is discrimination on its face. Disparate impact says you've implemented a practice and that practice has had a disproportionate impact on a protected class. And so that is what came out of this law, and it's still good. And really, this is the foundation for where we see AI going wrong. Most of us are not going to go into an AI system and put a discriminatory practice in there, right? We're not going to tell it to exclude certain applicants. But what we're going to do is we're going to put data into the system, and we're going to say, hey, this group of employees has been super successful for us. They stick around, they promoted, and we want to use that data to determine what a successful candidate's going to look like. Well, if that data was discriminatory, if your population you put in there, like the video said, was those that are successful are Jared and play lacrosse, you're going to get Jareds that play lacrosse that come out of it, and that may not be the right output for you. And so that may actually be a discriminatory outcome. And so this is where it really matters, and this is where it comes in. So continuing to think about, it's not just, are we putting in something that's discriminatory on its face into these systems, but really verifying that we have good data in our system to begin with. We have good non-discriminatory data. The next one I want to talk about is the EEOC versus Facebook. This is a few years ago. Facebook, if y'all do any hiring, you know, is that 10? Okay, good, thank you. So we have, Facebook a few years ago implemented where you could post jobs. They have a job board now. And what Facebook was doing was allowing employers to basically target their audience. They could decide who they wanted to target ads to for jobs. And which is fine in some things, like you probably want certain demographics targeted. But the thing that they allowed employers to do was deselect certain demographics, including women, including older individuals. And so those are discriminatory practices. So the EEOC brought the lawsuit against Facebook. They settled out of court, and Facebook agreed to remove those characteristics. But making sure that we are also paying attention not just to the systems that we control, but the systems that we are utilizing. So even through Facebook, utilizing things of that nature to make sure that we are not inadvertently discriminating based off of what other systems have available for us. All right, that's all of our case law. So now that I've talked to you about all the ways it can go wrong, or some of the ways it can go wrong, I wanted to talk about where it fits. So Jacob, I want to be help with the last video. So this one's short. This is coming from the Today Show. The Today Show brought in the, I think it's the CIO for LinkedIn. Yeah, LinkedIn. And he's talking about where does AI actually fit in the workplace? Where does it make sense?
We're talking about one of the hottest topics, artificial intelligence. It is already changing our everyday lives. But this morning, we're going to focus on how AI is impacting our jobs and the workplace. Here to share some insight is LinkedIn editor-in-chief Dan Roth. Dan, good morning.
Good morning.
Do you have any moves, first of all? Can you put down?
Yeah, so we could talk about that instead.
He's going to help us figure out how to padam our way into AI. So first, just set a baseline for all of us. When we're talking about artificial intelligence, what does that look like in our workplaces?
Sure. So we are dealing with AI all the time, every day. If you use Google or Siri, or if you have a spam filter, that's AI. But what has gotten people really excited recently is generative AI. And that's this idea of giving the machine a prompt and something novel coming out. It could be written communication or video or an image or a spreadsheet or code. And as people have started to play with this at work, they are realizing it is going to change how they work, all new ways of doing their job. And like with any technological advancement, it brings real opportunity and also just real change that you have to start figuring out.
Yeah. I love that we're talking about that because there's been so many negative stories about how AI is taking over, but there are positives to it as well. So how is this being used in our everyday life?
Number one, people are thinking about this as a tool. People who are thinking about this right are thinking about it as a tool.
Like a calculator.
Yeah, it's like having an assistant. It's like a super calculator. It's like having an assistant who can do all the routine tasks that you don't like doing. So if you're a real estate agent, let's say, you could have the AI write your listings and draft documents and schedule your meetings. And that gives you time then to go network and show houses. So we ran a survey recently on LinkedIn. 40% of people said they are already using this in some way at work. And the way they're using it falls into kind of two buckets. One is to fight the blank page problem. So let's say that you have to write a deck, or you want to write an email to a supplier, or you've got to draft some document. The AI gives you that first draft. And the other one is to solve some kind of problem that you run into, like you don't understand some lingo, or maybe you have a sticky situation at work. The AI can kind of tell you how other people have gotten around that same problem.
I know someone who just used AI to get a business idea, like a name for their business. They just put it in and it spit out all the
amazing.
Business plans.
We'll have to do a whole nother segment on how to do that because I feel like you're at a disadvantage almost if you don't understand it. But on the other side of it, there are going to be people who are watching this morning and they go, there goes some of those jobs. You know, they worry about the technology almost being invasive. What would you say to that?
Number one, it's still very early, so we're still figuring this out. It is going to change for sure how we work. So there's going to be an increased emphasis on efficiency. You can already see that playing out where companies are saying these tools should make you more efficient. It is going to change the kind of skills that are in demand. And then, like with any technological advancement, there are going to be changes to certain roles are going to disappear and other ones are going to be created. There is no doubt that that is going to happen. But what they are, I think it's still too early.
Dan, speaking of those skills, what are some things we can do to sort of brush up and understand, maybe play with this technology so that we're not so far behind when it comes right into our office?
Well, the good part is this is kind of an accessible technology. So the first thing to work on is prompt engineering, which is a really fancy way of saying just learning how to talk to the machine so it spits out the kind of results.
Machine? Like, I'm like, is this like, am I Googling?
It's Google all over. Yeah, so there's ChatGPT has a standalone app you can get. That's a great place to start.
Bard also.
Yep, absolutely.
So they're apps or you Google them?
You Google them and you literally put in, in, please write me a business plan for Chanel Jones from the Today Show, and it will spit it back out.
Absolutely. Yeah, and it's starting to show up in all kinds of apps also. So if you use, Google Docs or Microsoft Word, it's showing up there. Adobe products now have this generative AI built into it, so you can be like, well, fill out, I don't know what's in the background of this picture. I want this to look like I'm in Bali, and suddenly it looks like you're in Bali.
Wow.
But learning how to use the tool, even inside other tools, is a skill, and that's prompt engineering.
It's interesting because it's saying, like, sort of take the AI and use it the best way you can, right? So,
Absolutely.
like, it's here. So how do we use it and make it better for our lives?
Don't run away from this. Use it to help you do what you can exclusively do. Like, we are humans. There are things that only humans can do. So one of the things that we've been seeing is, we just talked about the hard skills, but what we know employers want more of now is the soft skills. Leadership, learning how to communicate, being able to deal with change, teaching others about how to do things. All of those kind of negotiating skills and how we interact with each other are what make us who we are. And you kind of unload all this other stuff out on the machines and we become much more human. That's the way to excel.
That's a good way to put it. And the thing is, that's priceless.
Yeah.
Right? And then as new things come in, we can adapt to the technology.
AI cannot make us Padam Kylie Minogue songs, that's for sure.
Thank you, Dan.
Thank
So helpful.
Hey, thanks.
So what I love about this video is, one, it kind of brings it home, right? It brings it back to, we talked about all these things that can go wrong, but really AI is the future. It is also here, and trying to figure out this balance between how can we use AI, use it in a way that makes sense in our workplaces. And I love what he said was, there are things that only we can do that are exclusively human. There are things that AI will never replace, and it's those soft skills pieces, right? And so using AI in a way that makes sense to automate some of our rote tasks, to take some of that burden off of us so that we can be more strategic, we can be more human, as he said. So I love how this just brings it home for us. And then the last thing I want to leave you with is coming back around to this question of, what is your role? what is your role? Now that you've kind of heard all the things that can go wrong, where AI fits in the workplace, think about your role. And so think about how we have, just like with the computers entering into the workplace, and we adapted to new challenges, from protecting employee data to ensuring fair access to technology. Similarly with AI, our role is to guide the integration in ways that reduce risk, ensure compliance, and promote fairness. But there's also a broader opportunity here. We can help our organizations innovate responsibly. I mean, that's what we're talking about, and that's what I think our role is supposed to be. We're supposed to be that advocate, that champion, helping our organizations move forward, not being the ones to just tell them all the ways that can go wrong, but tell them how to be thoughtful and mindful with how we implement AI systems into the workplace in a way that makes sense. We can strike this right balance. We can foster innovation while also safeguarding workplace culture, and we can ensure that AI becomes a tool for growth and not just a source of conflict in our workplaces. So I hope that has helped maybe shift and define out some of your perspective on AI in the workplace, and then to just bring it home, just to bring it back around. This is where we've been. I hope you now have a basic understanding of what AI is. You can speak the IT lingo when you're with your IT folks on talking about automating processes. I hope that you question the algorithm. When you are in these conversations, I hope one of your takeaways today is to ask what is going into the system, what data is in there, what did you put in as a successful outcome, and ensuring that those are not discriminatory practices. I hope that you are and also advocate for being a champion of human oversight. Don't blindly follow the AI systems. I hope you are questioning it. I hope you are promoting questioning it in your workplaces. And then lastly, I want to leave you with balancing. What I hope you do is proceed with a balanced curiosity. I hope you're excited about the future. I hope that you are championing the future. You want to learn more about it, but I hope you do it with a balance that it has risk, and how do we mitigate those risks? How do we balance them to make sure that we are moving ourselves forward? We're being innovative, but we're doing it in a way that is responsible. Thank you.
So we are going to give some extra time, allot some extra time for Q&A for this session. So I'm going to open up the floor. If anyone in person has a question, please raise your hand. Michael here has a microphone. And if you can stand up and ask your question loudly into the microphone. And then if there are folks online, if you have a question, please submit them to the panelists, and Michelle will read them out for Melissa to share her responses. Thank you.
The informative lecture. So question, so given the methods of using historical data to predict future outcomes, do the negative and biased outcomes of AI differ, like in a homogeneous society, like maybe like Switzerland or Finland?
It's a really good question. I wish I had an answer. I don't think I know enough about that, but I think it could depend. I mean, it all goes back to what's in the system. So if we have discriminatory practices, I'd say it even varies, not just culture to culture, right? But it's going to vary organization to organization. Whatever that data set that's going into it is going to differ no matter where you're at. It just all goes back to that data. Yeah.
Are there any questions in the chat online?
It was so thorough. Awesome. All right. Thank you so much. Oh, go ahead.
Oh, hold on one moment and wait for the mic.
Have you given any consideration to AI platforms like Grammarly, things like that? So I've had a question of whether or not we can utilize those services with our agency, but because we have confidential information right now, we're just like, well, we don't know enough about whether or not to do that. So if I am wanting to kind of make sure my grammar and things are appropriate, or help writing a speech or anything dealing with our cases, we're kind of shy about doing any of those platforms with the work that we do. Have you given any consideration to?
That's a fantastic question, and I actually have an answer. So, so when we go back to thinking about the terms that we talked about, one of the reasons we say, hey, I don't know about Grammarly is an open source AI tool. They have a closed source version, but what is available and free to use for the public is an open source. So especially if you're a state employee, you should not be using the free version of Grammarly. It does not protect our data. Our data becomes their data. So if you put it into the system or you're writing investigation memos and you're using Grammarly, you're not protecting the confidentiality of state data. However, STS, our IT department, they know that this is an incredibly powerful tool. I personally love Grammarly. I'm a big proponent for Grammarly. Grammarly, they have worked to secure a contract for closed source Grammarly where we can control our data and our data doesn't become public. So you can actually reach out to whoever is your IT person in your department would be the one to coordinate it. So go talk to them. But we now have licenses available. I think they're like $200 and something per user per year. So if you do a lot of writing, like investigation memos, I wouldn't say the lay user probably needs a subscription to Grammarly, but if you do a lot of writing, especially a lot of legal writing, Grammarly is a great tool and you can go and get a license for it now. Yeah, to use it securely. Great question. Thanks for asking what I know. All right. Thank you, everyone. Oh.
One last question.
I was writing down what she said. Yes, I had just as kind of, if you use like Grammarly to create a document or even an email, do you have a policy or an idea? Should you disclose that information? Like say, hey, I formatted this email using GPT, or is it just don't even worry about that? You know, what is your recommendation on that kind of stuff? The disclosure and transparency that I'm using it with my coworkers.
So this is Melissa's take on it, is that, I think it goes back to like, what's the intent? Like, what is the intent of whatever it is you're producing using AI? And if it is a decision-making tool, especially, like if we're talking about using AI in a, say, hiring practice, for example, we should be transparent about that. If it's making decisions for us or pulling data for us and analyzing it, we should be transparent. If you're using it to, what he called in the video, create or fight the blank slate problem, maybe not so much when you're just using it to help generate content that you're going through and you're vetting and you're verifying and you're just kind of helping it to get your outline going for you, for example, probably not so much. But if it is an impact on a person, absolutely. We should be transparent and disclose that we're using it. Okay. Thank you, everybody. If you love this topic, you're welcome to come talk to me during the break.
Thank you again, Melissa, for your presentation. Tons of information to take back to our organizations and agencies. At this time, we're going to take a break. We will, it says 10 minutes, but we're going to cut it a little short since that session ran over. So we will return in 8 minutes at 10:15, and we will hear from our next presenter, Deborah Wright. So we will begin again at 10:15, 8 minutes. Feel free to grab some snacks, use the restroom. And for folks online, if you have questions, please submit them to the presenter. I'll see y'all soon. All right. We'll be kicking off with our next presentation, so please grab your seat. To introduce our next speaker, I'd like to invite to the podium Will Wade, General Counsel of the Tennessee Human Rights Commission.
Thank you, Jacob. Good morning, everyone. It's good to see some familiar faces this morning. It's my privilege this morning to be introducing our next speaker. I first met Deborah about 15 years ago during our first year at NSL. So Deborah Wright is an employment attorney. She's a workplace investigator and an HR professional. Deborah's held key roles such as an HR attorney at Stansberry Weaver an external workplace investigator for prestigious institutions such as the Employment Practices Solutions Incorporated. From Deborah's early days in HR and employment law, she witnessed firsthand the significant impact that well-conducted investigations have on workplace culture and morale. Outside of work, Deborah is looking forward to the holiday season and will be preparing the gift of baked goods for friends and family. Please join me in giving a warm welcome for our next presenter, Deborah Wright.
How's everybody doing? Everybody good? Yeah. Not too early yet. Melissa got the early, sort of trying to get your day started. She got everybody going for me. Right, so welcome. Can everybody hear me okay? I tend to move, so this is going to be hard to keep me here. So, and this is a nice big group. Great to see you all today. So, as Will mentioned, I am a workplace investigator. I'm an employment law attorney, particularly work on the management side, most frequently at Stansberry Weaver. I'm their HR attorney, work with small business clients. But I have found in the last several years, I've gravitated more toward conducting investigations. I conduct several of them, and have recently begun working with Employment Practice Solutions, and they do investigations and as well as training, and they provide expert witnesses all across the nation. And so I have been doing some investigations for them as well. And conducting investigations can be fun, it can be scary, it can be overwhelming, it can be a lot of things. So what we're going to cover today, or what we will aim to cover, I probably have more slides than I'm going to be able to get to, but I'm going to try. But we're going to look at a scenario that will eventually lead to a complaint, and then we will review that complaint. We will map out the investigation and then help you understand and identify priorities. And then we'll create a witness list, determine who we are going to look at as far as witnesses, and then talk about and explore some strategies, including how to break down specific claims. Now, thank you all or most of you provided some answers. So I know there are a lot of people in my pre-seminar questions. A lot of you have conducted investigations. Some of you are just starting. Some of you looked like you had done several. So some of this might be review for many of you, but other than that, this will be brand new. And at the end, I really hope I can leave time for questions, but you also did send in some excellent questions. Thank you. And I will try to cover many of those as we go through. Whoops. Okay. I don't know what happened to that T. So the foundation of investigation, first of all, why? Why are we conducting an investigation? So we want to minimize our risks, of course. We want to make sure that the employees are being heard. We want to make sure we identify when there are issues. And we're going to try to minimize our legal risk, which we'll get into a little bit more. We're obviously going to adhere to state and federal laws to ensure that we are conducting those investigations that are required when these concerns and issues come up. We also want to let our employees know that we do have a commitment to them. We have an environment of respect, and so we hear you, and we're going to take it seriously. And most policies, most companies have handbooks that state, you need to let us know. You are obligated to let us know. There is a requirement for the employee to say when there has been a problem, because if we don't know as management, we cannot help. So we encourage that, and then non-retaliation policies fall back on that to help support it, which we'll get to as well. And we want to strengthen the integrity of the workplace. If our employees know that they can come to us when there is an issue, and we will take it seriously, then they're going to come to us when there is an issue. And that's what's very important, that they are letting us know, and that we are taking those seriously. And any handbooks that I review or write, I will do in their policies for harassment, discrimination, when we talk about coming forward, I will tell them, we will take it seriously. That is our requirement and promise to you. Now, when we talk specifically about some of those investigations, what we are doing is fact finding. And we're going to get into the nuances of fact finding because we talk about witness credibility in a little bit, and there were some questions about that. But as an investigator, what you're trying to do is find out what happened. Who knew what was said, where, what was written. And so we are fact finding. And sometimes it's a he said, she said, and those facts aren't obvious. But as we're going through the investigation, that's what we're doing. We're trying to find out as much information as possible. We are building morale. We're letting you know you're heard. We hear you. We have that duty under the law, minimizing our exposure, our legal exposure. I have been involved in investigations that have gone on to the THRC, that have gone on to the EEOC, or then have gone on and they filed a complaint in court. And a good investigation done prior to having to work through an agency complaint is going to help you as you work through that. You want to make sure that you have all of the information available. A bad investigation will handicap you. A bad investigation will hurt you. A non-investigation is even worse if you didn't even take it seriously. But agencies look favorably upon companies that did take it seriously and did an investigation, because then they can speak to what all we did. Here's what we did to understand the situation. Here's what we did to minimize. And then that we acted responsibly because it is our requirement. So what are some of the qualities of a good investigator? So we're going to get into the meat of the employer or the employee who now maybe it's HR. You could bring in an outside investigator. You might have a full-on investigation team. Many large companies have an employee relations group, and they do the investigations. So an investigator is neutral. And this is so hard sometimes when you're in a company, you are a coworker and you are investigating. And I am an outside investigator. And that is hard too sometimes, because I'll send out an email, try to set up a time to meet with somebody. They're like, who are you? I'm not talking to you. I don't know who you are. You're not even from my company. And so it's hard to begin when this outside random person wants to talk to you about this maybe incredibly sensitive topic. But then if you are on the inside, then it's, well, you work for my boss, who is my boss's boss. So how are you going to give me a fair shake? But you do present neutrally and let them know that I am here just to get the information. I'm here to ask the questions, to let your voice be heard. You're unbiased, and we all come in with our own life experiences. But you sort of, you pull a shade over those to say, tell me what you know. And you're asking those questions. It's a balancing act with the, being empathetic as well, because you want to have sympathy, you want to be empathetic, but, and we'll talk a little bit more about that later, it's not about, oh my gosh, that's awful, I can't believe that happened, because we are not siding with anyone, whether it's the complainant or the reporter or the subject or respondent. It's not about who was right or wrong at this time for the investigator. I am simply trying to get the information. And so we don't want to present that we are one side or the other, because then that person's not going to talk to us. That person won't want to hear what we have to say. So we have to be very professional in that respect too. The heart of your investigation is your witness. You've got your complainant, and we'll get to a scenario where we will see that. But we've got a complainant. You could have a reporter. So a complaint can come through someone who was not potentially harmed or injured. It can somebody who had seen something. And you have your witnesses, people who have observed or were a part of a conversation or a situation. And then, of course, you have the subject or the respondent. They're going to give you the information you need. They are most valuable. That's where you're going to get your gems. That's where you want to make sure that you're doing your test or your witness interviews well, and you're preparing for those, because they are going to provide the big picture for you to put it together. So Jacob, I think we're ready for our scenario.
Hey, you ready to check in? Yeah. Just waiting on my room to be ready.
Welcome. Checking in?
Yes.
And what's the last name?
Miller.
All right.
I like that blouse.
And that will be, is that one room or two?
I suppose two. There's nice glasses, Ash. They new? Wow. Your eyesight's worse than mine.
All right. If you two will sign right here. All right. There you go. Your rooms are just down the hall from each other, and they will be ready just after 4 p.m.
Perfect. You know, grab dinner around 7. We can talk about the meeting tomorrow. I can knock on your door.
Is Marcus joining us for dinner?
I think he's meeting with college friends. Just the two of us. All good?
Okay. Okay, so before we get into what happened there, the complaint. Now, I know many of you are probably thinking she probably filed a complaint, but it was not. I'll go ahead and read this morning. You received an email from Senior Manager Peter forwarding you the following message from Marcus. Frank Miller is creating a hostile work environment. I'm not comfortable sharing the details, but he was inappropriate toward Ashley at the recent work conference and generally favors the women on the team. I'm concerned that my opportunities for promotion will be limited so long as he is my manager. I would appreciate being considered for a transfer to a different manager. Now, can someone file a complaint or express concerns in a situation such as this where you see maybe this was inappropriate, but it wasn't maybe inappropriate toward me, and say, I feel that there is a problem with what I just saw? Of course, yes. And now Ashley might have her own concerns. Ashley might send a letter the next day, or there may be something that comes up in the interview with her. But Marcus has seen that there has been treatment toward some of his coworkers he is uncomfortable with, to the point where now he feels like it is causing him some potential discrimination, might even set up for a hostile work environment. Now, what you do as an investigator, you're not initially going to go in there and go, I think it's this, and I think it's this, and you're not going to identify, because you don't know all the information. They may not even use those magic words. And we don't want to immediately, and we'll talk about those claims later, but you don't want to immediately say, oh, reading this, oh my gosh, this is discrimination, this is. We're not going to identify, because we have to get the information first. We have to find out what happened. We didn't actually see this. As the investigator, we have to hear what happened. And their scenario may come across a little differently when that person explains it. But first, what we need to do is we're gonna do a roadmap for our investigation. What is our investigation going to look like? In many cases, some of my clients want me to draft an investigation plan, so they know what am I going to investigate, what questions am I going to ask, to whom am I going to ask them. That is very helpful so that you can see where we're going with the investigation, and identify all of those witnesses and a timeline, and then clarify any of the complainant's allegations. So you need to know, because oftentimes, especially if there's a hotline, if they had a hotline report, if they went to a manager, you might find that they reported it in multiple ways. So you want to get your hands on every location that they may have stated. And some places have more than one. Company that I did investigations for, they had an ethics point, and then they had another hotline that they could report to. So I had 2 or 3 come in. So you want to condense those and bring them all together. And then, of course, your scope, which we'll talk about scope when we're talking to Ashley. So should everybody who's a potential witness be interviewed? Well, probably not. Sometimes you're going to ask, well, most of the times you're going to ask each of those you're interviewing, who else do you think I should speak to? Who else might have information on this that would be helpful? I have had people give me 20 names. Oh, well, you need to speak with Bob, you need to speak with Janet, you need to speak with, not all these people are going to provide valuable information, but you want to know from that person who would be helpful. So you're not necessarily going to include everyone, but anybody who observed the situation, if it's behavior that came through written, so email, you want to, anybody who was a part of that email chain. But find out who, of course, you're going to look at, the complainant, the person who claims that there was an issue and that they have been harmed, and then the respondent or the subject, the person who engaged in the potential misconduct or improper behavior, and then those who have observable or known information that can help you craft a picture to understand exactly what happened. But you need to prioritize and then focus on those individuals. And there are a lot of times where somebody's name will come up that you did not initially think you should speak to. Just happened on a recent case that I was investigating. Not even on my radar until, so the person I was speaking to said, yes, and John was there too. And I said, oh, John was in the room with you when this happened? Yes, John was there. Oh, well, what is John's name? And then I thought, this is somebody I need to speak to because this goes to the heart of the matter. Before you prepare your interview, you need to make sure you're ready. You've got your questions, and you will veer from those questions. You will drill down, and you've probably all heard about sort of the funnel or tornado, where your big picture first, you're looking at, tell me about it. Tell me about your concerns. And it's very broad, very open. And then as they start talking, now you're going to narrow in. You're going to get more specific with the questions and as you go. And sometimes you may not know what that question is until they start talking. And they point something out that you weren't even aware that there was something that was going on. And then they bring it up and you go, oh yes, that's important. I need to come back to this. So you want to prepare, have your questions ready. And you're also going to have your intro and your script, but it is important to know who I'm going to speak to first. I personally always go to the complainant or the reporter. So if the reporter is not the complainant, I go to the reporter first, because there's a reason that person came that the complainant didn't. And so I will go to the reporter first, get as much information as I can from the reporter. Who else should I speak to? Then the complainant. And try to get as much information that I can from the complainant, go through the witnesses, and then subject or respondent last. Because I want to have all of the information I can available when I speak to the subject, so that I'm not going back several times to the subject to say, oh, well, then I spoke to this person and they brought this up. Because you only want to have to talk to the witnesses and interviewees one time. And if you have to go back, it's just uncomfortable. It's a difficult process. It's hard for them. And they don't want to be talking to you. They don't want to be involved in this. So if you can keep it to one, that's best. That's why I always like to do the respondent last, so that I can have all the information and that person can speak to whatever it is that's been alleged in that one sitting. And so your notifications, and this is especially important as an outside investigator, so that handoff is pretty clean. As an internal investigator in-house, you want to notify the individuals when there is an investigation taking place. Very quickly, it's going to go to the complainant. We received the information or your hotline complaint, and we want to let you know that we take it seriously and we are going to begin conducting an investigation. We would like for you to make yourself available to our investigator. Here is who our investigator is. That person will be contacting you to discuss this matter. And so you're going to notify that person. I do not send anything to the subject right away. And that's because it might be a week, it might be 2 weeks before I get to the subject, before I'm able to interview that person. And they're gonna be stressed out for those 2 weeks. And then they're gonna be talking to people. And then they're gonna try to find out what everybody knows, who they've been talked to, or who's talked to. So I try not to send notices. You don't send blank notices to everybody that here are all the people. It's one at a time. So then when I decide, when that person I've discussed with the complainant, I have a better idea to whom I should speak, then the next witness will get a notice, and then the next witness. In that notice, it is rather vague, because I also don't want to say, hey, Marcus said that you were a jerk, and I need to talk to you about that because he feels like that hurt him. Because now, without even talking to me, without having, you know, that banner of non-retaliation, confidentiality that I say at during those interviews, then all of a sudden Frank's out there trying to figure out what's going on. And there's that appearance of retaliation. Frank might just be talking about it. There may not be any retaliation, but there's that appearance. So one person at a time, you know, just there has been a complaint, a part of which you may be involved or have some more information about. We would love to speak with you to see what you know. Here's the time. Now, in some cases, we do also include a statement of confidentiality in that. That can be scary also to employees when they receive, especially witnesses, when they receive that, because they're very nervous when they get to the interview. And so even with the subject, I don't name, you know, so-and-so. Now I do have one client that does name that person, and that is part of their policy and they require it. But for the most part, we do not name the person. They will get to find out who in the interview, unless there's a situation. There are a few times when that name does not come up because there could be potential violent situations. But most of the time, they will get to find out in the interview with me, the subject, but not in that email. And unfortunately, that does set them and put them in a position where it can be difficult for them to speak on the matter, because they go, oh, I didn't know this was about John. Okay, hold on, let me get to my computer. And that's fine. I'll say, take your time, pull up whatever emails you can find. And if you can't get to them now, please send those to me. And then we set up a secure link in Dropbox or OneDrive where they can upload, and they're the only ones who can upload those documents and the only ones who can see those documents in that folder. And then, of course, me. So it's secure and it's safe, but they don't have that information sometimes. Or oh my gosh, this was a year ago. Gosh, that party, was that Christmas? No, that was Easter. So they can't prepare, and it would be great if they could, but we just don't want to have them going around asking questions and stewing about that and then pulling information up and then talking to people. So with the witness notifications, that's why we stage those out. And then we're going to be drafting those questions. Identify what we need to talk about, big picture. If it's about the party, if it's about the hotel, big picture, what happened before, after, and then of course, were there other times something like this happened? So you're going to ask those questions. Is there anything else that, you know, not related to that particular incident that might be relevant to hear? And then always do your who, what, when, where, how. And you're going to try to use open questions instead of, did this happen? I don't want to put words in your mouth. So even though the complainant already said that he made me feel uncomfortable, I'm not going to say, did he make you feel uncomfortable? How did he make you feel? I want in the interview your words. And so I'm not going to claim that. And I'm not going to identify or put language to it. I want you to. And so I'll keep asking those questions. And then always that, is there anything else that we have not discussed that you feel is relevant or important? Because I want them to be able to address. Now, I've had people go on and on about so many other things, and they'll talk about that don't have anything to do with that particular incident, but you know, they're having a tough time and they want to talk. Again, I'm very neutral, I'm very unbiased, I'm not judgmental, I listen. Okay, tell me about that. And it's not cold, it's just very matter of fact, because I'm finding the facts, I'm getting the information. And during those interviews, you go active listening. So asking questions, you want to know that you are there, you are listening, that they are being heard as you are taking notes. I take copious notes. Sometimes we record, it depends on the client. They get permission. The interviewee knows. The interviewee does not record, but then the interviewee gets a transcript of the recording or of the interview, and then they can sign off on that. Other clients, we do not record, and we don't have a recording, so I type, and then in some cases they will say, I will type it up and I'll send it to them, and then say, this is the my summary of what we discussed. Your open-ended questions, don't forget to do that as often as possible. There will be times you will bring it to a close because somebody, if they continue to talk, and you want to just get, so did he say that? You started to go down that path and you may want to bring it in. And do summarize periodically. So what I heard you say is, and so it's almost like you're the therapist but again, we're not giving advice. We're not healing, we are hearing. But we might say, okay, so the three of you were together in the room, and then when did John come in? And so you're reiterating what they said and then bringing in the next question. And you want to build that rapport because you want them to feel safe sharing. Now, because I am outside external counsel and investigator, they don't know me. And sometimes that's difficult. So I try to build rapport right away as we're talking. Now, again, I'm not there to be their best friend, their buddy, because I also don't want them to think, oh, the way she was reacting to me, she knows I'm right. She knows what I said was, he is going down. I don't want that either, because that may not be the case. It may not be substantiated. And it is not for me at that time to decide. So when we interview in this scenario, the complainant, remember that was Marcus. And you want to understand again what topics and then the specific questions. Write down the specific questions. You may not get to all of them. You may not need them. But in your mind, think through the interview. What am I going to start with? I would start with background information. And then when we get to the questions, what do I have to find out? What do I need to know with Marcus? What does inappropriate mean? Okay, so they're going to give you words that might mean something different to you. So he's been inappropriate. Well, what exactly was inappropriate? What did you see? We want to understand the behavior that went along with inappropriate. And he grabbed her glasses and made this comment. Well, what exactly did he say? And you'll write all of that down. And then also instances, because his complaint included that he felt like he was not going to have career opportunities. So we want to know, has that already happened? Have you already been looked over because he promoted someone else? Or is there something coming up? Or did somebody else, do you feel, was overlooked? And each one of those complaints, each one of the statements, we want to get an understanding of the facts behind it. So we're not going to let any blank statement go by until we know how is that going to happen, or when did that happen, or what did you see that goes along with inappropriate, or there is a misunderstanding. What was the misunderstanding? Dates are so important too. If we're talking about, for instance, the hotel situation, when was that? And then there was another opportunity that I was passed over. What was the date? When did that happen? So as I'm taking my notes and he's talking, if he didn't give me a date, then I type in the word date and highlight it very quickly. And if there are other questions that come up, he's talking and he said, oh, and then John entered the room, and this was not a piece of information that I had, then I'm going to write down John ? And highlight it, because he's still talking. So as I'm taking my notes, if something comes up, I don't want to interrupt him right now. But as soon as he's finished, I'm going to say, okay, Marcus, thank you. I want to go back for just a minute. You had mentioned that on October 2, John came into the room. Tell me a little bit about John. And what time was that? Was it earlier? Was it later in the conversation? Because timing matters. So we want to, as best as possible, to narrow down and understand those times, those dates, the specific behavior behind statements. What did you see? What happened? What was said? These are the facts that you are gathering as the investigator. not feelings. And it's okay that they felt hurt. And that is part of our investigation report. But why? What happened to make you feel hurt or upset or scared? And so all of that information we need to make sure that we're gathering, and those specifics. And then reassure, document, of course, at any time. Oh, well, could you send that email to me? If you do still have access to your email account, could you send me so that I can take a look at that? Or a policy. If they're talking about a leave policy, maybe that was inappropriate or misapplied, do you have a copy of that policy that I can take a look at? So we're going to document everything. We're going to look at all of the evidence. We're going to ask them, even if you don't think it's relevant, send it. And as you're going through your email, if you see something that you didn't think had anything to do with this, please send it to me. And as I look through them, if it isn't helpful, that's fine, but we have it. So please send all of the information. And they do. Most of the time, they'll send what they have. And then remember to discuss confidentiality. And I'll get to that in just a second. But the takeaways for your complainant specifically is you have to be very careful because they're in a little bit of a vulnerable situation and position. And while you are not their therapist, you're not their friend, you are fact-finding. You want to reassure them that you are neutral and that you are there to get information to make sure that whatever he or she felt or what happened, that we understand the facts around that. And that's why you're there. And I've always, of course, maintained professionalism. So then Ashley's a witness. We're going to do the same thing. We're going to prepare. We're going to ask about specific observations of treatment. Did she feel that there was any inappropriate behavior? And find out from her. Now, it doesn't mean it wasn't inappropriate, even if she says, no, it was fine. Okay? Because again, Frank, it made him uncomfortable. Or I'm sorry, Marcus, it made him uncomfortable. So she might say, he's just like that. He's a jerk. I don't care. It didn't bother me. And that's okay. She can say that. Now, if she said, oh my gosh, yes, that was just wrong. That was rude. When we get to the end of our interview with her, we might ask her, is there anything? We'll always ask, is there anything else? Or are there any concerns that you feel that you need to bring out at this time? Now, that's going to be a separate investigation. So we're not going to pull that. We would not pull that into this because there will be times when there might be additional allegations that come up in the course of an investigation that you bring into this one. We need to add this allegation. But this would be a separate, and this would be Ashley as the complainant. So we would put a pin in that and say, okay, thank you for bringing your concerns. Ashley, I will definitely follow up on that. And then we're going to open a new case, or we're going to let HRER know that a new case needs to be opened on that. And then know her perspective of the events and how she was impacted. And then ask, how does Frank engage with other employees? And ask about those situations where we've got her being able to observe, did she see the same thing Marcus saw? Okay, so now Marcus is saying it's not just Ashley, it's many women. Does she see the same thing? And then those other women, those might be names that we can bring up now and that we can start looking at and ask them. And then we might go into an interview where we're talking to other women, other men. It depends, those who may have been impacted by Frank, or if Marcus says, well, Josh was overlooked for a promotion for a female. We might want to speak with Josh. Again, we're going to find out the dates. We're going to be very neutral and what he has observed. And then Frank, of course, we want, again, starting out big. Let's talk about the situation at the hotel. Can you tell me about that? And what happened? What time did you get there? Who all was there? And no, when I interview witnesses, they don't know who else I've interviewed. And so they don't know, I already know who was there. And so they're telling me as though it's the first time I've heard. And that's, of course, your checks against other witnesses to see who was there and if the information corroborates one another's. And so, well, who all was there? What date was that again? Does everybody have the same date? And what time? And then who did you speak to first? So we're finding out that path and what happened to make sure that each person is hearing or telling me the way from their perspective. I'm not telling them. So I say, so I understand that you went to a hotel on October 2 and Marcus was already there and then Ashley came and tell me about that. Because I'm making his statement. I'm putting words in his mouth. I'm claiming it. It's not mine. And I'm there to find out the facts. So I want him to tell me. Now, what if he never says Marcus is there? What if he never mentions Marcus? Do I say, oh, you liar, Marcus was there? Of course I don't. That would not be the right approach. But are you sure nobody else was there at the scene? And if it's absolutely, definitely no, nobody was there. Even sitting in the chairs, there was nobody? No, nobody was there. Well, the hotel hostess was there. Oh, well, yes, of course, the hostess. And then did the hostess check anybody else in before that? Well, yeah, Marcus. Oh, so Marcus checked in before you? Yeah. So had he left? Well, no, Marcus was, oh yeah, he was in the chairs. So sometimes it can be intentional. Sometimes they're nervous, they don't know what to say, they forget about it. Now, I will, if they continue to say Marcus was not there, I might say, well, my understanding of this is that he was somewhere in the lobby. Is that correct? And if Frank still insists no, then no, it is. And that's what I'm writing down is he says no, Frank or Marcus was not there. So, but if I have that information, I want to get it from them because it could be that somebody else said Marcus wasn't there, Marcus wasn't there. Maybe Marcus heard about it from somebody else. So we do want to make sure that we're pushing and finding that information, but we're not putting words in their mouth. And then we're going to find another way around. We're going to ask other questions around it to see if we can get to the same thing. So again, we're going to be general. We want to let the subject know what the allegations are once we talk to them. And then an opportunity to tell us about that event, that situation, those emails, whatever it is. So they get the floor just like the complainant did. And you can ask, why do you believe, because most of the time you'll say, I don't know why she thought that was wrong. I don't know why she thought that was inappropriate. We can ask, well, why do you think someone might? Or do you believe there's somebody who might feel that this was inappropriate? Why might they think that? Also, your non-retaliation and confidentiality. So at the beginning of every interview, I have a script. And the first, I guess, half of my script, I say the exact same thing every time. And I want to make sure I say the exact same thing every time, other than their name, to that person. Because number one, then I can say, I know I said that because I always say it. That's the business practice rule. So I say it every time. I always start off with, hi, may I call you Melissa? Because they may not want me to say Melissa, they may want me to say Missy, they may want me to say Mrs. something else. So I always say, thank you so much for agreeing to meet with me today. May I call you Melissa? And that immediately starts building a rapport. And that's what we need to do, especially as outside investigators, because they don't know me. So may I call you Melissa? Oh yeah, that's fine. Yeah, you could totally call me Melissa. And they say, well, thank you so much for agreeing to meet with me today. This is what we call an investigative interview. It's an opportunity for you to tell me on the record everything that you know about a matter that we are looking at right now. Now, you know I am an attorney, but I am not engaged as an attorney in this matter. I don't represent you or any of the parties or the subject in this matter. I'm on a fact-finding mission. I just want to learn what happened from your perspective. Does that sound good to you? Oh, yeah, that's fine. Now, I do have a couple housekeeping items I want to cover first. Your company has a strong non-retaliation policy, and that means no one can retaliate against you for participating in this process or filing a complaint of your own. Of course, that goes without saying. We ask that you not retaliate against anyone with regard to this matter. But if you do feel like you're being retaliated against, please let me know so that I can escalate that to the proper person. And also, I am not a confidential resource. However, we do ask that you keep all the information that we provide, that you learn, as confidential and as private as possible. Because some of the things that you may learn if it's talked about, can be hurtful and harmful to other people. And we also want to protect from the potential of the appearance of retaliation if we are talking about it out there. And I will be taking copious notes, but I'm not recording. And we ask the interviewees not record. So I'd like to ask right now, are you recording this conversation? And if they say yes, I can't stop them from recording. But then I also always say, well, then for the record, can I please find out if anybody else is in the room with you for your recording? And I would like to make an announcement for your recording. And then I just state my name, that I am an attorney, but I am not representing anybody. Only one time did somebody say that she was recording, and she said, I'm sorry, I stopped it. And I said, okay, if you would like, I can send you a summary of my notes. She said, would you please? So I did. Now, I don't know, most of mine are Zoom. I don't know for sure if she stopped her recording on the other side of Zoom or not. But I do say that and let them know I'm not recording. If, for that one client, I will say, no, we do ask interviewees not to record, but I am recording, which they have to say in Zoom, yes, they have to accept, so they already know. And then I'll say, in a moment, I will begin our recording. And at that time, I will ask this information on the record. And after we finish, I will get you a transcript. So I say that at the beginning of every one of my interviews, no matter who I'm interviewing. And it sets a tone. It helps them get a little more relaxed. It helps them see, I really am a professional just trying to get information. And then I always get background. The next thing is always background for every person. I already know. I've been sent all of their information, usually by the company. I know their job. I know who their manager is. I have that information, but I ask it anyway. And this is where I start working, understanding credibility. And so I'll say, so I'd love to get some background information from you first that will help me with this investigation. Could you please tell me about your position and title? And then that's what they'll, oh yeah, well, I'm the maintenance manager, and some people will go on and on and on. And then we try to wrap it up. But then how many years have you worked there? Who are your direct reports if you have direct reports? Who is your manager? And ask them questions about that. How many people are in your department? And I'm sort of getting a baseline now, their behavior as they're talking. And what's their normal? What's their level as they're engaging in conversation? And then I'll say, oh, thank you for that. That was very helpful. Now, as you know, when I sent the email, I was very vague and I did not provide a lot of information. And they usually go, yeah, right, you didn't. And there's a reason, and that's so that we can protect the integrity of the process. The reason I asked to speak with you today is because, and then I will say, there's been an allegation that you treat women differently, or if it's one of the witnesses, there's been an allegation that women are treated preferentially and that they might receive more benefits over some other employees. Can you tell me a little bit about what you know about your manager, Frank, or about your coworker, Frank, and how he works with other women? And we start very broad, and then we drill down and get into that. So that's how I start, and that's my script. And then under that, I've got all my questions I hope to get to. It always changes, and then I just start typing as they start talking. And I've got all that information as they're going, and I'm typing, and then I look and I'll say, okay, give me just a minute, and I look to see if there are any other questions that we haven't covered. Most of the time, as they're talking, they are going to answer many of the questions I have written down. And so I just delete those because I had already gotten those questions answered, and I don't need to get them again. But all of them, sort of the interview strategies, which we already talked about that, your intro script, and your disclaimers. And then as we get through, I'll always check on time, because sometimes they've got some place to be and another Zoom call, but we want to be mindful of their time. And if you can wrap it up. But if you have to come back for a second interview, I've had to do that. It's a little different, because then when they come back, they've looked stuff up and they are a little more well prepared in that situation. So I'm not getting it fresh and raw, but if we have to, we will. And then, of course, always at the end, then I've got my block at the end that's always the same. Is there anything that we have not talked about today or addressed that you feel is important to discuss on this matter? And most of the time they'll go, no, it's just that. And then they go into more information, which is fine because sometimes new information comes out there. And then I will go back to if I have any sections highlighted that I did not get information. I also, if they say, oh yeah, it was an email, I will highlight the word email and then I'll go back and I'll say, well, just as a reminder, you did say that you would send me a copy of that policy and an email. There were, I guess, several emails around the check-in procedures that you wanted to send me. Oh yeah, I'll get this to you. And then I'll tell her, I will send you a link. And once you get that link, you can upload those and then I can review those documents. So always let the person tell their story. Remember, it's not my story. I'm not saying based on what other people told me. Every person has their own individual perspective. And so I am not going, to insert my perspective onto them. Even though I have already interviewed 5 people and I have a pretty good idea what happened, it is still not mine to tell. Every person gets to tell their own perspective, whether it's the complainant or the subject. They get to tell me. And so their story, always use your open-ended. If there's somebody who does start to go on and talk and you are now the wheels have come off and they've gone on and on, then you can say, oh, okay, thank you for sharing that. I'd like to get back to, if you need to circle back to something that they didn't quite answer. And then start broad and then ask those questions if necessary. So did you get back to her? Did you tell her what when she asked? So there are times when you will need to have those leading questions when somebody has not specifically answered, and you can say, yeah, you want to get a yes or no from them. And periodically summarize and review. You don't want to say whether or not that a policy has been violated. So as you're interviewing, even if somebody says that it was a dress code violation and she's always in dress code violation, I'm not going to then in the next interview say, well, I understand she violated the dress code. I don't know that. That was somebody else's statement. I'm not going to, well, that sounds like a policy violation. I'm not there to inject my thoughts and my opinion on what has or has not happened at that time. And then for situations specifically with the subject, when it can be tumultuous, we can have potential violence, we don't always state the name of the person yet that filed the complaint. In most cases, we will say that, well, Marcus believes that or alleged that, and then explain that. Act shocked or surprised, and then he took her glasses off. We're not going to go, what? He did what? Oh, that's rude. So we're not reacting. It's just listening. And you might hear some shocking things. I have heard some shocking things, right? And you go, but you have to, you got to practice poker face because you don't want that person going, see, I knew it. I was right. And you might very well be, but again, I'm not going to respond. So even though this was said, which I even had one person say, and I told her because she's a woman, she doesn't need to be in that job. And so I said, okay, and then what happened after you told her that? So it's a very matter of fact. Was that appropriate? Should he have said that? No, but that's not my role. So after he said that, I said, okay, so what did you say next? And then what was her response? And we're just asking those questions. And then, of course, no indication about what other interviewees are saying, because sometimes gossip happens and the word does get out and they find out that an investigation is taking place. So we're not going to say necessarily, well, Bob said, but it is my understanding that if you have to try to get information, but it's not Bob said when you're talking to them. Okay, so this question actually came up a couple of times, assessing credibility. How do you assess credibility? And then well, should you assess credibility? If we're fact finding, why are we assessing credibility? Well, the question or the answer is because you need to know when to drill down. You need to know when somebody, as they're answering questions, if you feel like something is not right, I'm going to ask follow-up questions. And I have a lot of follow-up questions that I prepare in case somebody is, they're sort of being evasive. Now, here are all the things. So I did my background. I have had people where when they start talking, because I had a situation where 2 individuals were, I believe, talked in to supporting a complainant's statement. They were not there, they were not involved, but then they claimed they were. And one, every time I asked him about this individual and when they were behaving, I got this. He started doing his hair and looked away from me almost every single time. And then another one, not too long ago, when I asked, well, then did you go into payroll? Were you in payroll when he asked you to make those changes? She would hold her breath. Never did that before, but she would, before she answered, almost like she was trying to keep something in. And so you just see these baseline changes. And so I knew, okay, we gotta talk a little bit more about payroll, but I'm gonna come back. Or I might say, well, tell me about the process with payroll. Oh, well, and then they get a little more comfortable and then they start explaining payroll and what they do. So if somebody enters the room when you're working on payroll, what happens? Oh, well, I close it down immediately. Every time? Yes, every time. So there hasn't been any time where you've left payroll open. Well, and there she started doing it again. And so we moved on. And then later I came back and asked again. I said, so now when you're working on payroll and then someone else who she mentioned had come in and Nancy came in, what did you do? Well, with payroll open, we started looking at. And so now we're talking about payroll being open and Nancy's in the room. And I said, okay, so payroll was open when Nancy was in the room. And then she realized right then, oh, yes, payroll is open sometimes when other people are in the room. And so then I said, okay, so I'd like to go back to then the other situation. So while I am not deciding whether you're right or wrong, I am trying to understand when you're talking to me, am I getting the truth? Am I getting everything? Is this credible information? Because then that goes to the credibility of the evidence. And so with my baseline from getting their background information, I'm watching and seeing this behavior. And so I can. And so they get that breath in where they're not speaking, or they start touching their hair, or they look down. Now, that doesn't mean they're lying. Don't hear that if they do something that's different, that means 100% they're lying. It may not be. Sometimes it's a number of changes. Sometimes there might be something they're just omitting that they're not telling me. Other times they're just nervous. And that's why we go back. But that's why credibility, trying to assess and understand what this person is saying is so important, because it helps you know as an investigator, do I need to come back to this? Do I need to find a different way around it? And I had one time in an interview, when I was asking her about the situation at hand, she was very short. 2, 3 words. That's about all she said. Now, that was not her baseline. Her baseline was she's very talkative. And so I could tell, okay, there's more here. And I need to get into that. But it was, no, this didn't happen. No, I was the one who decided what she'd get on her performance review. That was my call. And she was very firm on that. And then as we started, I said, okay, something is not quite right with that, but I'm going to go on. Again, I highlighted it. And I said, okay, so with the performance review, can you tell me, is there a review that goes on after that? Oh yeah, there's a review. It goes to this person and that. And then I was asking, tell me about the review process then. What happens next? And when do you get your review? And it was sort of sideline. That didn't matter as much. But then as she was talking, she said, well, then my manager who told me what I need to put on her review, said. And so there she was telling me she did not do the performance review. It was her manager who said that this is what it needed to be. And again, this is not about gotcha. I'm not trying to get anybody. It's, okay, that's a good piece of information. So then I followed up. I said, okay, so when your manager said you need to put this on her performance review, what did you do? Was that something online you had to go in and adjust? Yes, I went in and I changed it, and it was, needs improvement and whatnot. Okay, and so did you feel she needed improvement? No, I didn't, and I hated to give her that. So that's why credibility is important, not to get them, not because I'm judging, but it's important because you might need to know, I got to follow up on this. There's more to what they're saying that they're not telling me. There's something off baseline that needs to happen. So this came up several times, and I wanted to try to make sure I got to that. And am I on time? Okay. So when we talk about claims, again, this is what we talked about earlier. We're not naming it. They might say, that was discrimination, that was retaliation, this is a hostile work environment. But remember, we want behavior. We want to know what happened. What did you see? How did you behave? So which action? And these are some of the statements that you can look to. What was the action? What that your manager did? What reason did he give you for this employment action? Why? So we're asking those questions about behavior, about what was behind it. What did you see? What did you hear? As opposed to just giving it a name. And then for hostile work environment, what is it your manager is doing that makes you say that? Okay, because we want to get down to the facts. We want to get down to the behaviors. We want to know what they're doing, why they're doing it. And so that we can say whether this claim was supported. It was supported because these are the actions that took place that were inappropriate, or this was misconduct. Or it is not supported because there is no evidence that any behavior took place to support those actions. Sexist, racist. What are the behaviors? Again, have they made those comments based on sex or race? Okay, somebody can behave in such a way because they're behaving that way because you're a woman does not necessarily mean it's sexist. It could mean they're just a jerk. And I've had plenty of those investigations where it ended up being a jerk boss. Maybe it wasn't discrimination or sexism, but he was a jerk boss. And so we want to find out exactly what happened and to know what's behind those words. So as you are wrapping up your investigation, make sure you get all the documentation. Review the documentation as it comes in. And that way, again, remember you're talking to your subject last. And so you should have reviewed anything anybody had sent you prior to so that you can have everything available. So when you're talking to the subject, you are ready for that person to be able to address everything and you're not having to come back to them. So you're reviewing the evidence, everything that comes in, performance reviews, policies, videos, emails, privately, securely, and you're making notes. You've got your case notes and you've got all of this documented. You've identified whatever document it is and then the relevance to it. And then who sent it to you, of course, where all of that comes from. And then your notes, if you need to send a summary of your notes to the interviewee, for them, you can do that. And then if you are giving an oral debrief, of course, then you would take that information, prep your debrief, and so that you can go in and let HR or legal know exactly what what the process was. They probably already had your investigative plan, so they will have seen. And then after your debrief, then you're going to provide your report. Some of my clients don't want reports. Most of them do, and so I draft an investigation report. But some of them don't. And your report's going to have all of the information, everything you did, to whom you spoke, the allegations, the policies implicated, law implicated if relevant, and summaries of what they said, as well as then you can. Some will ask for a determination. Some do not. They just want you to say what happened, or the facts as you found them, and that's it. Some of my clients specifically want a determination. Was this substantiated? Was it supported? On the claims. Some are partially, and they're usually multiple. Some are partially substantiated, some are fully, some are not. And then fewer, but some still then want recommendations. Additional training, suspension, etc. Most of them, they take it in-house and they make that decision. And as far as follow-up, be based on your organization, on exactly how you do it, but you do want to close it out. You do want the complainant to know, we did complete the investigation, and here's what we found, as well as the subject. We don't always notify the witnesses. That's up to your organization, but we definitely don't want people out there who've been interviewed to wonder, has anything happened? And if any of my, anybody I've interviewed wants to know a status, I will let them know just where it is in the process, because they're anxious, but I don't let them know any information. But I'll say, it's in the, I've finished my interviews, it's in final review in-house, and so hopefully something will be coming to you soon. That's usually where I leave it. But I want them to feel free to reach out to me, because it's understand that this is a difficult process for everyone, not just the complainant and the subject, even the witnesses, because they don't want to say something bad about somebody. They don't want to feel like there's going to be retaliation. Everybody gets anxious and nervous. And that's why you're building that rapport. You're making sure that they feel comfortable speaking to you and that you are going to keep that information quiet. So this is our summary. And then these were some of the questions that you had. I think are we on time? Do you want me to okay, we get a few more minutes. So some of the questions you all said, and how many staff members at minimum should be involved in the interview? So I do mine alone. And I've had a couple cases where I've worked together with somebody else. It's intimidating, y'all. It is intimidating. If you are sitting there and you are a witness or you are a subject and you got two people staring you down, that's tough. So it's rare situations that we will include two people. And sometimes I will tell you, there are investigators out there. I work with many investigators, especially with EPS. They prefer it because they've got a note taker. They've got a second set of ears, and that's wonderful because then they've got that backup because they're not recording. But it is hard when you are the person on the other side. It's hard to build a rapport with somebody when you've got two people, especially two in-house individuals. These are your coworkers. And now two of them are staring you down, asking you questions, and potentially making you feel uncomfortable, or I've done something wrong, or I'm going to say something wrong. And then if it's two outside counsel, then it's, oh my gosh, I've got two attorneys staring at me. Am I going to jail? What happened? So I always do it alone. I take really good notes and then I summarize those. We talked about the best practices, tips for encouraging employees to participate. So if someone said that they've had situations with no call, no show, I've had those as well. It can be in your handbook that, as far as investigations, that you are obligated to participate. Now, if somebody simply does not want to, and they are absolutely not going to talk to you, they don't have to talk to you. I usually I will do several follow-up emails, and I will ask in that email, may I just call you off the record just very quickly to find out maybe if there's a reason why you don't want to speak with me, and it not as an interview. And usually they will, and they're scared because they feel like something's going to happen to them. And in that conversation, then I'll say, look, this is not on the record. I'm not going to put this in the investigation, but can you help me understand why you don't want to speak with me? I'd love to hear your perspective on this. I think it is so important for you to have a voice in this matter, because I feel like you have relevant information that could be shared to help the parties resolve this. And that usually helps. And they'll say, well, it's because, and then I can help assuage those concerns, and then maybe say, I would love to do this on the record. Can we schedule time for tomorrow? And you can tell me just what you told me just this last 5 minutes. And they will. If it's the complainant, we still will continue with an investigation because the complaint was made. We need to look into it. We just won't have the complainant's perspective. Other than if they filed the complaint, but then they said they wanted to withdraw it, we still look into it. And then if it's the subject, I let the subject know a determination will be made even without your perspective, and we would hate for you not to be a part of this process. We would hate for you not to have a voice in the determination of this matter. And so that usually gets them involved with that no call. In investigations, how do you, if you disagree. So another reason why maybe we don't have two people now. If you have a second person, they also will, many times they will ask a question that maybe I don't think of, which is usually helpful and wonderful. But if they do have a problem or we disagree, I'll say, that's a fantastic point. You make an excellent point on that. We're going to couch that, pin that for right now, and we're going to move on. If it's after the interview, for instance, and we're talking, that's okay. That goes in the report, because we will state specifically that this is, investigator 1 saw this, believes, and based on the facts and evidence, this is the outcome. Investigator 2, we're going to present that, and that's what it'll be up to the powers that be. And I'm getting waved off. My time is up. I'm sorry I didn't get to more questions. Oh, yeah. Okay, so legal team is not always involved, but many times they are. If the legal team is involved, then our investigations become private and confidential and privileged. Okay, so you need to know when it becomes privileged, when legal is involved. Just because I'm an attorney does not make it privileged, and that's what I tell them that. If the situation, if it's an infraction of policy, almost never legal is involved. If we're getting into potential violation of employment laws, then they usually will get involved on the end of it, especially if the determination is substantiated, that the claim. And so then they will be brought in and they will be debriefed. But most of the companies that I work with, legal does not start out involved. It's usually ER or HR that starts those, but there is a process where they will look at what the claim is, and that it might immediately go to legal because of the confidential privilege piece. And so then they're told during the investigation that it is a privileged matter, that legal is involved in that. Good, yeah. Oh, yeah, I guess if anybody has another question. Yes.
Bringing them up. So we're opening up to questions now. So for folks online, if you have a question, please submit it to the panel chat and we will read them out. And for folks in person, if you could raise your hand and we'll bring a mic to you. Thank you.
How do you feel about putting in an investigator's observations or assessments of body language or a party's demeanor in an investigation report?
I think that's an excellent point and an excellent idea. Yeah. Especially if it's pretty obvious. Now, because you're not making assessments or evaluating their credibility or their truthfulness, you may be just stating, and I had a situation like that where this person really changed their demeanor when those questions were asked. So yes, you can put in there as you're explaining, doing your summary of that interview, for instance, in your report, that witness shifted in his seat 3 or 4 times, stopped making eye contact, or even turned away from the camera. Interviewee turned camera off. Sometimes, it happened once, somebody turned their camera off because they were angry. So you can put that in there. That is very helpful information for the people who then might need to make a determination or disciplinary action if that's what they find out it comes to, because they might have to go back and assess credibility. Thank you. Anybody else? Any online? Nope. All right. I guess that's a wrap. Okay. Thank you.
Thank you so much, Deborah, for your presentation and sharing your insights with everyone. So real quick, before we break for lunch, one thing that we did want to do in the morning that we didn't have time for, so I'm going to leave this up on the screen for folks online as you step out for a break and join back, or folks in person. We do have a Menti poll that we wanted to get folks to see how they're feeling. So although it is past the morning time, I will leave this on the screen just to get a temperature check on how you're feeling today. So if you go to menti.com or you scan the QR code with your phone, you could put in this code right here, 1678776, and we'll throw that in the chat for online attendees. And we're asking folks to give an emoji response. So typically we do word clouds with word responses, but we want to get an emoji temperature check on how are you feeling right now. 2 sessions in, got our keynote and the rest of the day to go. How are you feeling? We'll revisit this at the end of the day. Feel free to submit it on your own time. I see some good responses, especially as we're getting for lunch. A little icy. And for folks online, please also submit it. Again, menti.com. The code is 1678776. Seth, how's it looking out there? Good. All right, folks. So we're going to break. We'll return at 12 p.m. for folks online. Please submit the Menti and then come back at 12 p.m. What we'll do is you can head out this door, and then the food will be set up buffet style. You can grab your food, come back, get yourself collected, and we'll have lunch during the keynote, which will commence at 12. So if you have any questions, feel free to come on up, and we'll see you all at 12 p.m. Thank you. Hello to all the virtual folks joining us online. I did want to share the results of our Menti. So if you can see, kind of a wide range of feelings. A lot of folks are feeling very excited, very informed. A few folks are freezing because it is a bit chilly inside and outside today. So we did turn down the AC a little bit. So hopefully folks are feeling better and the food will warm you up some. But we'll check back in later this afternoon towards the end of the event to get another temperature check. And hopefully folks are feeling just as good now as they are later. All right. So next up, we're going to be having our keynote join us for our keynote speech. And to introduce Mr. Colclough, we have the EEOC Memphis District Director, Downer Franklin Thomas. Everybody, please give a warm welcome to Ms. Franklin Thomas.
Well, good afternoon. And I'm telling you, this lunch is smelling good. And I took a small bite and it's feeling good. And we're getting ready to hear an exceptional speaker. I have the honor this afternoon of introducing our keynote speaker, Thomas Colclough. Tom, as we call him at EEOC, is the director of the Office of Field Programs. The Office of Field Programs is comprised of 53 field offices across the country. We're about 1,500 employees strong. In his role as director of the Office of Field Programs, he is a principal advisor to the Office of the Chair and to the Chair with reference to our administrative operations, which includes hearings, investigations, mediations, outreach. And then he oversees and ensures operational baselines are being implemented in our 53 field offices across the country. He is a graduate of the U.S. Army's Command and General Staff College in the Office of Personnel Management's Federal Executive Institute. He also received his undergraduate degree from St. Augustine's University in Business Administration and a master's degree from the University of North Carolina at Greensboro. When he retired from the North Carolina National Guard, he had the rank of Lieutenant Colonel. In September of 2021, our chair, Charlotte Burrows, appointed Mr. Colclough as a commissioner to the U.S. Commission on Social Status of Black Men and Boys. His work with this commission includes producing reports to address the conditions affecting Black men and boys and providing guidance for Congress on strategies to reduce the racial disparities in education, criminal justice, health, and employment. And I have had the distinct honor of working very closely with Tom over the last 3 years. And what I can say to you, he is a person that walks the walk. He cares about the staff at EEOC, and he cares about the public we serve. Please join me and welcoming our keynote speaker, Thomas Colclough.
All right. Good afternoon. Oh no, she told you I used to be in the Army. You know how we're always loud in the Army. So good afternoon. I know this is tough because everybody is eating lunch and it is dangerous to be between people and food. So I'm going to try to do my very best. So they always tell me that when you do a presentation, you should start out with a joke. So I decided, let me see if I can come up with two. They're short jokes. Dallas Cowboys 2024. Or Mike Tyson versus Paul. Okay. So I guess Dallas Cowboys won, finally, right? Finally. Okay. Well, first of all, I'd ask you to join me in giving the organizers of this event a round of applause. I think they did a phenomenal job. Next, Ms. Thomas and Ms. Wright. Hard acts to follow. That's just not right. That is just not right. Okay. But they did a wonderful job. So I'm going to try to, because I'm a walker just like Ms. Wright said she was. And so we're going to talk a little bit about what's going on with the commission from 2024 and beyond. Okay. Now, what we have at EEOC is we have a strategic enforcement plan. And I was very privileged, and Delmer, she did me a favor, Ms. Franklin Thomas, she put me on that program, and I wound up being the co-chair of drafting the strategic enforcement plan. I enjoyed it. I learned a lot about what we do, why we do it, and I think it is very meaningful. Why do you have a strategic enforcement plan? It's a roadmap. So one of the first things we did with that group is we felt like we got a group of really good subject matter experts from within the commission. And we decided, hey, this is a baseline of things that we wanted to expand our strategic enforcement plan to look at. Okay. The next thing that we did was we held listening sessions with the public to get their insight, because just because it was what we thought was the right thing, we needed to hear from the public. And that was a good thing. Next, we set up an email box so that we could also hear from other people who may not have been inside the listening sessions. As a result, we came up with some really good things. Now, let's talk about strategic approach. Well, as I stated, when I was in the Army many years ago, any military folk in here? We used to always have those battle books, right? And we used to always have a briefing at the beginning of the year. That's kind of what our strategic enforcement plan is about. It is to set us on a path that says that we're going to have a focus to decide what are we going to do. Why do we have to do that? Because as great as we are at EEOC, we know we can't do it all. I do want to just step back a little bit, though, and as we talk about the strategic approach. I applaud all of you also for being in the room today and doing what you do, because in the work that we do, it's not easy. I heard that the commission had their 60th anniversary this year, and EEOC is getting ready we're going to do ours next year. And the reason why I think it's important to say is, why do we do what we do? And I think it's something we have to ask ourselves every day. And I want to tell you why I do what I do. I remember Ms. Franklin Thomas saying this morning that, it's about jobs and it's about housing and all of those things. It is. I'm a product of the Civil Rights Act of 1964 as amended. Okay. And I remember way back when, that's when I had more pepper than I do salt. Okay. I was a young guy, and I remember I was working in a tobacco field. I don't know if any of you know much about that. And so in that tobacco field, my brother and I was working with these other guys, and we decided, let's stage a coup. We're tired. Let's go home. And we tell the guys, when we get to the end of this road, guess what we're going to do? We've been here for like 10 hours. It's time to go home. We've done too much. And one of the guys said to us, him and his brother, his name was Larry, and his brother Jerry. It's the things you remember. He said, we can't do that. Why not? If we do that, we will be put out of our house today. That's us, our mom, and the rest of the family. It helped me to understand, and I tried to remember that you ever heard of this document called the Declaration of Independence? It talks about three things in there. What are they? Life, liberty, and the pursuit of happiness. And do you know how we typically get those big three in America? It's called a job, right? Do, re, mi. No job, no life, no liberty, no pursuit of happiness. That's why it's really important that we understand what we do and why we do it. So again, let's all give ourselves a round of applause because that's what we're doing on a daily. Come on, I know you're eating, but we can do that. Now, the other thing is an integrated approach. EEOC, it is a big machine. It is. In that integrated approach, what we have to do is get everybody on the same sheet of music. That's why a strategic enforcement plan. But it goes with collaboration, coordination, and consistency. It's not just EEOC, it's also our federal partners, the Department of Justice, the Department of Labor, community groups, because we do outreach, plaintiff bar, and the defense bar. It's all of us working together to try to do what? That big mission of EEOC. Stop, remedy, and prevent unlawful employment discrimination, right? It's taking us all to do it. Now, the other thing is the accountability piece of EEOC. Because again, we have a responsibility to what? If we say that we're going to do it, to deliver it based on the resources that we have available. That's really important because we have a responsibility to the public that we serve to walk the walk and talk the talk. And we try to do that as best we can with the resources that we have. Now, here's one of the focuses, eliminating barriers in recruitment and hiring. Here's something interesting. I sit on a board at North Carolina State University for the College of Management. And believe it or not, a lot of the organizations that have headquarters in North Carolina, SAS, Red Hat, their HR directors or their human capital VPs, they sit on that board. It's about 33 of us. And what do we do on the board? We try to come up with what we think students should be learning as far as what's going on in the world today from an employment standpoint. I get to sit on there to say, yeah, but you got to make sure you're teaching them about employment discrimination. That's what I keep echoing, make sure we're doing that. And so one day we were talking about AI in recruitment and hiring. And there was one gentleman there, he'd written a couple of books about AI. And he convinced all of those people to say, take a look at your policies and see what the bad is sometimes in AI. One of the snapshots that he gave was, he said, they did I guess, kind of like a little test in one of the classes in which they took one pool of students to use AI in order to determine if they could get hired at a particular employer, and another group of students who didn't use AI at all. After about 3 months, the students who were using AI, guess what they were able to do at every employer they went to? They aced the interviews through socialization and learning and using that AI tool. Guess what the bad part was for the students who didn't have the AI? None of them got an offer. The danger with that is we all agreed during that meeting was, guess what that can lead to? If you don't have access to the tool, and typically guess who does not have access to the tool? You've got those vulnerable workers, they're going to get left out of the employment game. So a lot of those organizations decided that they would get rid of some of their AI tools. The other thing, let's talk about restrictive application processes or exclusionary job ads. Here's something that happened, and I don't know if Jason remembers it. We had someone that visited the office one day, and they indicated that they were discriminated against because of their age. The employer had posted a job ad looking for a technician to work, let's say at company ABC, but it was posted in 2 languages. It was posted in English and it was posted in Mandarin. In English, if you remember, right? In English, it was a very standard ad. Anybody could apply. But in Mandarin, it stated no one over the age of 40, their application would be accepted. We were just fortunate that we had an employee on staff that spoke Mandarin. Otherwise, we would have missed it. Those are things that we have to look for. All right. Let's also talk about protecting vulnerable workers in the underserved communities. I was talking to a good friend of mine on Monday about this, and I was telling him, his name is Edmund Sims. I don't know if you all ever heard of Edmund Sims. And I was telling Edmund, I says, you know, one of the things I really enjoy on the weekends is just driving through the countryside. And he said, why, man? What's going on? I said, well, guess what we do when we drive through the countryside? We get to see the real America. We get to see people. And as you're driving through the countryside, I want you to think about it now. And you start driving, you see those houses, and they're big and they're nice. Guess what you also know that might be happening in that household? It might be big and nice, right? The do-re-mi. But then you drive by another house, and guess what? It may be dilapidated. There's a car that's on blocks. Do you ever think about what's happening in that house? That might be someone that's part of the vulnerable population. It's all of those things you think about as you ride through and just ride through neighborhoods. What's happening? Where do they work? And are they getting those opportunities to do other things? Let's also talk about older workers. Let's see if we can give you a shock this afternoon. Remember I told you nowadays I got more salt than pepper? She laughed. Take a guess. How many people do you think turn age 65 every day in the U.S.? Take a guess. We'll just use 2024. Take a guess. Any guess? Per day. I'll give it to you all. 11,200 people every day turn age 65. That equals out to about 4.1 million people for this year. Do you know what a lot of people that turn age 65 do not do right now? They don't retire. So now you have that group that's in the workforce, and then you multiply that by every year. So by 2030, I think my notes say, that's going to be 20% of the population at work. What do you think occurs when you have an aging population in the workforce and we start talking about this thing called AI? Something else happens? Now, if my mom and dad were still alive, guess what? They'd be blown away with, the smartphone. I was watching a movie the other night, and this lady said, I must have a bad phone because my phone is not smart. She said, I got a dumb phone. She didn't have all those bells and whistles on the phone. But what you get is you also get harassment, correct? When people think folk move too slow. That will happen as our workforce ages and people don't retire. Anybody not believe me on that? Thank you, sir. I appreciate that. No, it's going to happen. And so we've got to be cognizant to look at that, because that is going to be a vulnerable population. Now, another thing is looking at those emerging and developing issues. Well, June 27th of 2023, EEOC began enforcing the Pregnant Workers Fairness Act. That is an accommodation statute. One of the things that employers have to know is that if you engage in the interactive process and you come up with a reasonable accommodation, guess what you can't do? You can't play the okie doke that we agreed on it in the room back here, but now we're going to change it. That's a violation of the statute. Just also know that things are always emerging. I always love to ask this question when we're doing presentations. Who in here loves the ADA? We're all the experts in the ADA. Notice how the hands got smaller. And the reason for it is the ADA is a very tough statute. One of the things I always recommend folk to do is think about the process. Someone tells you that, hey, I need an accommodation. Are they entitled to an accommodation? What is the process? What is the interactive process? And once you come to the decision that maybe you can grant the accommodation, it's okay to communicate with each other, right? To communicate, to see, hey, am I doing the right thing? Because a lot of times, guess what happens? We can do the wrong thing. I'm going to tell you a funny story with accommodation. You're going to like this one, ma'am, okay? So anyway, I visit this one particular employer, and the individual says, hey, you know, I have a bad back, and my doctor has asked me to make sure that I elevate my feet on a daily basis, you know, while I'm at the workplace. And she said, and that no good employer of mine will not give me an accommodation. So I arrive at the facility, and I says, well, you know, you work here, ma'am? You still work? Yeah, I still work here. Let me go introduce you to that no good employer I'm talking about. So we walk up, and she said, now here's my daddy. True story. Here's my dad. He will not accommodate. And I says, what is the problem, sir? Your daughter's stating she needs an accommodation to lift her foot up. And he says, yeah, and I don't have a problem with that, but she wants a $2,300 ottoman to do it. And I says, well, let's talk about it and let's see what we can figure out. Do you agree that she has a disability? Yeah, she has a disability. She's had this bad back for years. I said, well, do you have a shipping and receiving department? Yeah, we do. So we walk to it, and I says, well, how about this? Take this right here and this box, and let's take it to her office. And I said, okay, ma'am, put your feet on it. And she said, what do you mean? I said, put your foot, elevate it. Does it work? Well, yeah, it works right now. And I says, well, guess what? That might be the accommodation. When that box wears out, give her another box. And you know what that's all called, right? Thinking outside the box. But it was a true story, believe it or not. It's a true story. Now, this is another thing that we looked at in our strategic priorities. Now, equal pay. Does equal pay disparities exist in the U.S.? I agree. But did you know about 1% of all the charges filed with the EEOC are based on equal pay? Find that odd and strange? Not really. We all work, right? And I bet we've all worked at those employers that say, if you talk about your pay, you see that little second bullet called secrecy policy? You talk about your pay, you're out of here. Do we believe that still exists in America today? Yeah. And any idea what the unemployment rate is today? 4.1%. That's right. And that was as of yesterday, right? 4.1%. Yeah. But with that 4.1%, it seems like a small number. I think it's what, about 7 million people, right? All right. And it seems like a small number unless you're one of those 7 million people. And if you're one of those 7 million people, that has an impact on how much you're going to discuss your pay and other issues, right? But somehow, you know, EEOC looked at it as a priority because we have to somehow get those folk out of the shadows if there is a pay disparity so that we can assist them, okay? It's about trying to do what's right. Now, preserving access to the legal system. As you see, we've got 4 boxes here and, you know, unlawful mandatory arbitration provisions. Well, let's say that someone has been subjected to sexual harassment or sexual assault. Do you think they really want to go to mandatory arbitration? That might be a concern. Also, record-keeping violations. Record-keeping violation could be, you know, I'll give an example of a few things that I have seen in my lifetime. The employer throws the applications away. Or prohibited medical inquiries are asked on the application. Or failing to submit an EEO1 report if required to do so. We used to have this little thing called you know, that posting of a notice. Anybody ever heard of that? What you should know? Any idea what the cost of not posting that notice is in the Code of Federal Regulations? Anyone want to take a guess? It's about $647. $647. Now, guess what is a really easy thing for all employers to always do? Just post it. Or you can call EEOC, or you can go to a website and you can print it off. I remember seeing an employer once that was sitting in a meeting that said, hey, I've got 100 stores and I don't have that poster at any of my stores. 647 times 100. because that's the way the CFR has it written. But that's an easy way not to do that, right? It's the easy way. The other thing is retaliation. Those things that may lead to a chilling effect. Those things that dissuade someone from participating in the EEO process. Guess what we should always want? We should always want someone to participate. And I know that when people make complaints against a particular employer about A, B, C, or whatever, race, color, sex, etc., it's hard. But guess what I like to look at it as? And I'm gonna look over at Ms. Brown because she's one of our outreach and education coordinators. They will always tell you that when someone is making a complaint and they're being willing to tell you what the issue is, look at it as a gift. I know it may not seem like a gift, but what if that is just a small tip of the iceberg of what's going on? Because as managers and supervisors, guess what we can't do? We can't see everything that's going on. So if that employee is brave enough to bring it to us, we should at least be willing to listen, right? Everybody with me? Okay. All right. This is another issue, preventing and remedying systemic harassment. But I know harassment does not occur anymore, right? Somebody said yes. Okay. You are correct. Believe it or not, about 1/3 of the allegations of employment discrimination that are filed with the EEOC yearly are based on harassment. One of the things we have to ask ourselves, and I know we ask ourselves at EEOC, but we also have to ask ourselves as employers, is what we are doing, why is it not working? Right? And we need to think of what can we do to lower that from 1/3. Good snapshot, we receive about 80,000 charges a year. You divide that by 3. Don't beat me up today, Philip, okay? I'm going to say it's about 30,000. Is that about right? We'll say 30,000, probably about 26, something like that. That's a lot of folk that are being subjected to harassment. Those are the folks that made their way to our doors. Just to give you an idea, we receive about 230,000 inquiries per year. Okay, and sometimes, those folks decide they don't want to file the charge. Okay, another situation, misgendering. I remember a situation in which transgender employees working for this one large employer, and I remember her telling us that, hey, every day at work, my managers and supervisors are harassing me, misgendering me. We found out that to be true, and it was an easy way we found out it was true. She had the recordings. It was not necessarily a good situation when the employer showed up and were like, let us hit the play button for you. This is what's going on. We need to fix this. The good news is they did fix it. And I think with some training, some guidance, haven't heard from that employer again doing those kind of things. The other thing I think that is important, and we're going to talk about this just a little bit more, and that is social media. All right, let's find out. Who got Facebook? Who got Instagram? Okay, all the grams. Okay. TikToks? Snapchat? Any more of those out there? Social media sites? Oh, there are tons, right? The thing is that making sure that people exercise that thing called keyboard discipline, right? Because guess what's really easy? To go on those sites and start making comments and trolling coworkers and doing all kinds of things, right? And we're going to talk about a case kind of like that a little bit. Again, just some things that the EEOC has done over the last year. In April of 2024, because we started enforcing the PWFA June 27th of last year, but we got our regulations, we got those issued this year. As I told you, make sure that as an employee, if you agree in the interactive process to an accommodation, let's don't do the okey doke and try to change it later, right? The other thing is high-tech, low inclusion. As we talk about all of those social media sites, you know they're all high-tech, right? You know they pay a whole lot of money to build those sites, right? As I was leaving the hotel this morning, I was waiting on the lift. There was a lady standing there. What do you do? Oh, I'm from St. Louis. I'm just here to, today to, to help my company. I only travel here every once in a while. Well, what do you do? I work in high tech. Do you know who doesn't get to work in high tech? Do you know who's been primarily excluded from high tech? Any idea? People of color. Okay. They're excluded. So we've got to find ways to figure out what's going on there. Because are there people of color that are taking classes in colleges and universities to work in those industries? Yeah. And that goes back to the first thing that I put up there. Barriers in recruitment and hiring. We've got to find out what's going on to make sure that those opportunities are opened up. Okay. Now let's talk about some fun stuff, okay? I also promised Jacob that I was going to get us back one time. Now this first case here, EEOC versus Charter Communication, and it was something that was, I guess, the Seventh Circuit did a review on. Now, this was one of those cases that was personal to me, because watch this right here. See, I can take my glasses off now. I can really see everybody in here. This case was filed, Mr. Kimmons, his name was James Kimmons, and he filed a complaint with EEOC in which he alleged that he was denied a reasonable accommodation. Now, Mr. Kimmons, in 2016, he was diagnosed with the early stages of cataracts. Anybody in the club? No, don't tell me. Okay, I was in the club, okay? I was in the club a couple years ago, I think, Deborah, right? I was in the club. And so my optometrist said, hey, dude, guess what? You can go in for surgery. They'll take care of that. They'll give you a couple of lenses in your eyes. You don't even have to use these if you don't want to. Just wear them when you feel like it. So now I just wear them because hey, I got more salt than pepper. They help out. But anyway, here was the thing. With the onset of cataracts, what it affects you on is when you're driving at night and the folk got those lights on, it blurs you a little bit. So all of a sudden, what do? Mr. Kimmons did what I did. I'll just come in early to work, okay, and leave early so I can avoid driving at night. So what Mr. Kimmons asked the employer, Charter Communication, hey, can you please change my schedule so I don't, so I can leave early so I don't have to be caught up in traffic? And they agreed to do it for 30 days. Here's a hard question. Did he have a disability at that time? Uh-oh, I heard it. It depends. You're right, it depends. Because guess what the courts concluded at that time? Hey, we'll just say, for sake of argument, we're not going to question whether or not he has a disability or not. Because the ADA says look at it broadly. The thing that I think in this particular case that is important for employers is after the first 30 days, Charter Communication said, no, we're not granting another accommodation for another 30 days for you to, switch your schedule. Guess what the Seventh Circuit came back and said? Yeah, you may have to. And they looked at, hey, whether a modification of a schedule or transportation for someone, was it an accommodation? Okay. We don't know what would have happened with Mr. Kimmons because guess what he decided? He left the job for whatever reason. But I think that's important for employers when you start thinking about scheduling. And please know that under the ADA, schedule modifications is an accommodation. But I think that's a very important case to look at. Now, you remember I told you we were going to talk about that social media stuff? This is what case number 2. I'm going to try this, okay? Okinawaski versus Merrick B. Garland. And that was done in the Ninth Circuit. So we'll say her. Okay, that way I don't have to mispronounce her name. We'll say that She was working for the Department of Prison, the Bureau of Prisons, as in the psychiatric department. So she would meet with the various inmates and talk to them about situations. Well, there was this one lieutenant that was also worked at the Bureau of Prisons, and he did not like some of the things that she was saying. So he decided to get on the gram and started making comments about her. And the comments were derogatory. Then they turned to, when he didn't mention her by name, but then they became sexual. And then it started being memes, or I guess the little cartoons or whatever, about sexual assault, even up to the point of the little memes about rape. And I know what you're saying. Well, hey, he was at home doing this, right? What's the big deal for the Bureau of Prisons? Would you believe about 150 of the employees from that site were actually following him on the gram? To include HR and the assistant warden and the employees who actually investigated the EEO complaints. And so when she complained, guess what they were all saying to her? It's a joke. It's just harmless fun. And the first argument that they put forth was, well, wait a minute, we can't be liable because he's using Instagram and he's at home doing this. What are your thoughts about that?
The next section.
It's very interesting. You know how it turned out, right? It's very interesting. Because in the situation here, what turned out was, and again, I hear what you're saying. Can I just say one other thing?
Take it away.
Okay. For me, as I was reading this, I was like, this could be an NLRB issue because you've got so many of the employees here that are online and they're talking about employment related stuff, right? They're going down a slippery slope. And of course, all of the leadership, most of the leadership from this one site, they're all engaging because they weren't just on the site, they were making comments. Okay, they were making comments. They finally had someone to investigate and they came out with a report and said, yeah, just harassed. They even told, we'll call him Joe Knucklehead, Lieutenant Knucklehead, shut down your site. And did he do it? Not right away, he didn't do it. There was one issue I did have with one of Miss Okinawaski that I did have one issue with her. You may agree or disagree with me. Here was the one issue I had. He blocked her from the site so that she could not visit the site. And she created a new profile to go to the site. Here's the issue though, is that the employer was aware of what was going on. Did the employer take immediate and appropriate action? I'd say no. Did they finally take some action? Yeah. But this lady left her job. And I think probably when, you start with let's say the bad mouthing, but then you escalate all the way up to rape comments, I can kind of see why you would leave your job. You could get kind of frightened about that. But that is something that I think is interesting for all employers to ask themselves. Do you think this lieutenant was only using the gram at home? How easy is it to get onto the gram? You got it as an app, right? Right? As a matter of fact, on. Do I think the lieutenant was doing it at work? Absolutely. Because in their research, they were able to go back and look and see when he was on the gram, and he was doing it at work. So if he was doing it at work, was that creating a hostile work environment? I'd say so. Some problems. So why do I even mention this? And thank you, sir, for bringing this one up in your presentation. I think it's worthy for employers to say one thing. Make sure you look at your email and your keyboard discipline things, and also let people know if you're at work, guess what you really should be doing? And stay off the gram. Right? All right. Here's some initiatives that we've got going on. We've talked about AI and artificial intelligence. And again, how we use those technologies. I think it's important. And as our speaker said this morning, we're already using AI. AI has been around for a long time, but you have to make sure that you're using it appropriately. So think about how your organization uses AI to make sure it comports to the employment laws that we enforce. The hiring initiative. I think this is a good initiative between EEOC and DOL because it's talking about how do we ensure that people in vulnerable populations, how can they find good jobs? Now, anybody who finds a job, yeah, I say it's a good job. But every job can't support you. Let's be honest. And it kind of goes with the high-tech jobs. If there are opportunities for us to be able to recruit and hire folk into those good jobs, we should try to find ways to do that. We also have a REACH initiative that is being conducted by Commissioner Colclough. She joined us last year. And with the REACH initiative, what she's doing is she's going around the country and she's talking to vulnerable populations to find out, hey, what's going on in your life? What can we do? How do we help folk to get ahead? Because I think that's important. Now, the other thing that I wanted to talk to you about is something that we launched December of 2023. And that was our a portal that we call eFile for attorneys. And what that allows licensed attorneys to do is that if your client has already signed a charge, you can upload that charge into our eFile portal. Comes to EEOC, you get immediate notification that a charge of discrimination has been filed. Or you can draft a charge for your client to sign, upload it into our portal. We get it to your client, they sign it, and it's a lot quicker process. We kind of like the eFile for attorneys portal, and I would dare say that about 2/3 of the attorney drafted charges that we received in 2024 actually came through that portal. So we think that that is a good process. Next thing I'd like to say, though, is this right here. I'd like to give you an opportunity to ask me any questions. Nothing about the Cowboys, though. Let's see, how'd that do? All right, Jacob, I got you back on time, just about right.
Yeah, we're good on time.
All right.
Let me just. So if you have any questions, please submit. And for the folks online, submit it to the panelists in the chat, and we'll have some time to pick the mind of Mr. Colclough. So, any questions, thoughts, concerns for Mr. Colclough, our keynote?
All right. Come on, Eduardo, man.
All right, yeah. I had another question for you, but the biggest thing, just hearing everything you're saying, and this might be a hard question, but do you have any resources for being able to engage with anybody as they're overcoming objections to the practices you're coming up with to encourage diversity in the workplace? Because I've grown up in Middle Tennessee my whole life, and there's a lot of pushback culturally to those kind of initiatives. It's really easy to be like, you're wrong, I'm right, push you away. I feel it's better to engage people and try to educate them. How do you plan to overcome those things?
I think and this is just me talking, okay? I think we overcome those things based on what you said. I think one of the things that I don't believe in, going toe-to-toe with someone about the difference of opinion doesn't work. Because at the end of the day, guess what we're really trying to do? Change hearts and minds to show everyone that, hey, we are stronger together. Because at the end of the day, I believe, and this is my belief, guess why most people go into business? They go into business to earn a profit, and provide for their families. Why do most people go to work? Earn money and to provide for their families. So guess where we start from at the beginning? We all have the same objective. and getting people to understand, hey, don't look at me based on my race, color, sex, religion, or et cetera. Look at how I can help you meet your objective and you can help me meet mine, right? And again, that goes with changing the hearts and minds of people. And I'm happy to say at EEOC, I think we have. And I mentioned that over at the Nashville office yesterday. Guess what we have done since I've been at EEOC? We get to look into the faces of the people that we've helped and the people that, you know, that obtained remedy from EEOC, okay? And to me, the remedy is not necessarily if you got $1 million settlement. Sometimes it's about the education. You know, I'll give you a snapshot of someone that I worked with years ago. Person came to EEOC, stated they were being discriminated against because of their national origin. We investigated. We didn't find a violation. However, we worked with the individual, educated the individual. She went to law school. She reached back out and said, hey, thanks to you and what your organization did, it helped me to decide what I wanted to do with my life. She's now the managing partner for K&L Gates in Seattle, and she still keeps in touch with us. That's how we help to change the hearts and minds of people. Okay.
Any other questions for Mr. Colclough? Anything online?
I get to escape then, right?
Closing words, anything?
Yes. Thank you again so very much. Please listen to Fred, because you're going to get some good information regarding that case as he discusses it. So thank you very much. And you all, please have a wonderful remainder of your conference.
Okay. So to kick off our afternoon session, we're going to be joined by a very special friend of the commission and our former keynote speaker, Fred Bissinger. Fred Bissinger is a partner with the Nashville office of FordHarrsion. His practice focuses on coaching, counseling, and advising clients on difficult employee issues, especially those involving complicated disability issues, including mental health and addiction, as well as behavioral issues, terminations, and job elimination scenarios. Whether you are representing an employee or an employer, Fred believes that this work can create a positive impact on people and their workplace. Outside of work, Fred is looking forward to the upcoming Thanksgiving holiday and his annual Thanksgiving turkey trot and post-trot breakfast. Please give a warm welcome to Fred Bissinger as he will present on navigating politics and harassment in the workplace in 2024.
All right, is that working? You hear me over there okay? All right, I have this like beautiful PowerPoint that I'm not going to use. And the reason I'm not going to use it is because what it constitutes is essentially a high-level data dump on the harassment guidance, sort of like the infrastructure of what the guidance is. You can read it on your own. That's why I provided it. But I'm here to talk to you today because I hate PowerPoints. Like they're useful in some limited capacity. But on this topic, I'm just going to talk to you, okay? Now, I've been doing this work for 32 years. And when I first started in '93, I was active duty military. And I joined and started working right at the time that the tailhook scandal happened. Does anybody here remember tailhook? Only a couple people. Who was our president then? Huh? Who was the president? Huh? Bill Clinton. Now, Bill Clinton and harassment may not be synonymous, but there's a certain overlay there that I want you to understand in terms of irony, right? If you understand the concept of irony, because as part of this whole tailhook fiasco, in addition to representing a combat decorated fighter pilot who happened to attend a party in Las Vegas, we were also tasked with training at the base I was at all of the Navy and Marine Corps personnel on harassment. So if you think about that, my boss, Bill Clinton, ordered me to train a bunch of sailors and Marines on sexual harassment. Does that sound ironic to anybody in the room? I have a serious point about that, though, I want to make. I'm aware of one and only one solution to dealing with harassment in the workplace. Does anyone here want to take a guess as to what that one and only solution that I've learned after 32 years might be? Where are my friends and who are in the military? Mark, what do you think it was? What do you think it might be? No. Strategic, more strategic. What do you think? Yeah. I can't hear you. Yeah. You got somebody else. Give me a hand here. Somebody. Nobody? What's that? Listen. How about leadership? Do you think if you have a boss who tells you, if you do X, Y, or Z, I will fire you so fast your head will spin, and you actually see your boss do that, do you think you might listen and follow that example? So if you had a boss who says, hey, these are the rules of the road and how we deal with one another. If you can't live up to those expectations, you can't work for me. Do you think that that might actually work? Because to the point, I've heard a couple people say, don't do it or try and change people. Do any of you here think that when you hire people that you're going to change who they are through your onboarding, coaching, counseling, training processes? That's like saying to somebody, yeah, when I marry you, I'm going to make you different. Like, good luck. I'll see you in divorce court in 6 months. Like, it's not going to work. Are you kidding me? So the deal is this. People are crazy. And some people can't contain their crazy when they're in the workplace. So if you want to be successful, and I'm talking to the people in the audience who manage and lead people, whether you're in the state or whether you're in private employment setting. We know some people can't behave themselves. They just can't do it. No matter how smart, how educated, like doctors, lawyers, all these high people with all this education, they're as bad, if not worse than anybody else, because they always think they're smarter than everybody else. And then, of course, they put it in a text message or a social media posting. It's like, yeah, you're an idiot, because this never goes away and I'm going to use it against you. Like, really? But that's the world we live in. So this is the one and only solution that I have come up with. And I've seen a couple of clients really execute on this. And it starts with anyone who is in a leadership capacity, but especially at the executive level. The people at the executive level, starting with the CEO or whatever the equivalent is in the state entity, whether it's a commissioner or whoever, has to take a stand and say, I'm planting my flag on behavior. We have non-negotiable requirements, whatever they may be. For me, when I train managers on this topic, I try to make it simple, because you need to talk to people in simple terms that they're going to understand, regardless of their level of sophistication or not. Like, for example, you need to behave in a respectful manner or you can't work here. Very simple. You need to be a good teammate, because if you can't be a good teammate, you can't work here. Now, before I joined FordHarrsion last year, I worked at a smaller firm, and I was an owner, and I managed an office for 20 years. I managed people for my 5 years on active duty. I have a lot of experience managing people, right? I'm not saying I'm the best manager, but I've learned a lot along the way. And I can tell you that employees who've worked for me, one thing they know, like, I am crystal clear. My New Jersey mouth does not skip steps or go through filters. Like, there's none of this like circuitous logic. It's like, this is what I need you to do. If you do X, Y is the consequence, for better or for worse. And when I have fired people who could not get along with their teammates, it's like, dude, I told you when I interviewed you, I told you when I onboarded you, I told you when I was ramping you up. If you could not get along with the people that work here, you cannot work for me, right? Regardless of what that means, you can't work here. And if you don't have leadership, starting at the upper levels, that sets those expectations and plants a flag in the ground and says, this is our left guardrail, this is our right guardrail. You stay in between left and right when it comes to behavior. You get outside of left or right and you're getting tuned up like ASAP, so fast your head is going to spin. That's the only way, after 32 years of doing this work, that I have found that employers, they're not going to prevent it. But here's how bad behavior in an employment setting like that unfolds. Someone acts like a jerk, whether it's an employee, whether it's a client, whether it's a vendor, doesn't matter. The employee or employees who are the recipients or who observe that behavior, they know that sticking their head in the ground, you know the ostrich syndrome, you stick your head in the ground and hope for things to get better after a little while? Like, does that work when people behave badly? Or does that just facilitate and encourage more bad behavior? Right? They know two things. One, that they are expected to engage, whether that means they engage directly, whether they report it to somebody with more stripes on their sleeves to deal with it. They know they are expected to engage. The other thing they know is if they do not engage, that they will be held accountable for not engaging, regardless of the fact they had nothing to do with the bad behavior. What does that do? What do you think that does in terms of creating a workplace culture where people not only believe that the senior people have leadership credibility, do you think that over time that they don't take ownership and pride in that type of workplace where they know they have a direct input on what that culture is, or more importantly, what that culture is not? Anybody? Bueller? Bueller? Somebody? Okay, you guys are asleep. I got it. The only thing that you can do that will be 100% foolproof is to set the right example, but that example has to start with you. If you are in a management level role, you cannot be do as I say, not as I do. You have to set that example. You have to hold yourself accountable. You have to hold other people accountable. And that means you're going to have to fire people. And you may have to fire people at a very senior level who are very talented at what they do. But imagine, can you imagine, like, if you've ever worked in a law firm, there might be like highly talented lawyers who are prima donnas and total toxic cancers? Yeah, right? It kind of goes with the territory. Doctors, same thing, like unbelievable, the egos. It's like you can't get enough oxygen in the room. Sometimes you're going to have to fire people and make an example out of them to let them know that you're serious. Because if you're not willing to fire someone, like you're willing to fire a $20 an hour employee, but you're not willing to fire the $2 million employee, right? What kind of example is that? What does it say? It says we have different expectations for different people. What is that the per se definition of? Similarly situated people held to different standards.
Yes.
Discrimination, right? I mean, come on, that's shooting fish in a barrel. But if you want to be successful on this topic, that to me is the solution. Conceptually, it's very easy. Carrying it out can be a little more difficult because you have to figure out, how do I set expectations with people, right? What is it that I need to do to accurately and effectively set communications, right? Do you think if you go into a room with a bunch of rank and file employees, whether they're white collar or blue collar, and you start reading a harassment policy that talks about severe and pervasive and blah, 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 you think that anybody is going to understand or listen to anything you have to say? No. It's like in one ear, out the other. You have to explain to people on a very basic level what you want them to do, and you have to show them what that means, and especially when it comes to employee conflict. We always have conflict of some variety in the workplace, regardless of what you do, okay? And you have to explain to people that conflict is part of life. But when you are at work, that conflict, if you are strategic and you're thinking about how do I make myself better, how do I make my business better, right? I need to use that conflict or that negative situation to make a positive out of a negative every single time. If you go into a termination setting, for example, if you have the authority to fire people and you go into a termination meeting and all you can think about is I need to get this guy out the door, and you're not thinking about what the second, third, and fourth order repercussions to your leadership credibility are going to be when you fire that person, you're going to miss the entire strategic opportunity that that termination brings to you. What do I mean by that? Let me explain. Has anybody here ever worked with somebody who just didn't understand how to behave properly? What happens if that person is allowed to stay and continue to be a jerk, regardless of the fact that the boss has talked to him 18 times? What do you think? What do you think? Does that create a workplace culture where you can recruit and retain talent? No, people are running for the hills like, this place sucks. I'm out of here, right? I want nothing to do with this. So you need to be thinking to yourself, okay, yeah, this is a valuable team member. He has a lot of skills, but you know what? If I keep him, I'm losing 4 other employees who have valuable skills too. So I need to go about this in a fair manner so this person gets their procedural due process before I fire him. But then when I fire him, right, do you think you just fire this person and act like, yeah, nothing happened? Everybody knows he's gone. The employees now, former employees now on social media whining and moaning about why he got fired and telling some ridiculous tale about how he was treated unfairly. Do you think that you might want to then, if you're being strategic, think about how am I going to now talk to my team about how serious I am about behavioral expectations and the consequences for acting like a jerk? Anybody? What do you think? Still stunned silence. Jacob, where's that coffee, man? All right, I had a couple, let me give you some high level thoughts, and our last speaker did a nice job of setting some things up that I want to run through. The EEOC did their study on harassment, was it like 2016 to 2018, and you published your findings 2019, is that about right? Something like that, ballpark, right? And my interpretation of the EEOC's findings was that after 50 years of measuring and analyzing harassment in the workplace, we've made 0 improvement whatsoever. Is that a reasonable interpretation? Because the statistics in terms of the number of charges filed per year and the nature of the behavior involved in those charges in this day and age is essentially no different than it was 50 years ago. Because we know that 75–80% of all charges are number 1, sex, and number 2, race. It's not like there's some big secret here, right? A lot of this fancy footwork on in this guidance about all these other topics, I read it, and I'm like, yeah, that's interesting. But for regular people who are trying to run a business or manage people, if you focus on sex and race, everything else is going to fall in line. Because you've already set the example. I planted my flag in the ground on how we treat people in a respectful, civil manner. We've learned that if we can't agree, we can disagree without being disagreeable, and that we have to be teammates at the end of the day and get the job done. And if we don't get the job done, everybody's going to suffer for not getting the job done one way or the other. So this issue about where we are as a society, right? And by the way, do you think that when it comes to the issue of harassment, do you think that harassment might be more problematic now with cell phones and social media than it was in 2000 when we didn't have these cancers, right? Because now social media is literally an opportunity for employees to harass one another 24/7. It never stops, right? We didn't have that before, right? So from a historical perspective, we know that based on the EEOC studies, we've had 50 years of time and money put into this topic, and we've made no substantive improvement, statistically speaking. If that's the case, right, then what I gave you as a proposed solution, because I've seen it work both on active duty and in some private employment spaces where people are very serious about it, that's what works. But we know that if we think that we put out a nice policy and we do some fancy training and we get everybody to sign off on the policy that our job is done, like, forget it. We have no chance. You're going to have to be thinking strategically, day by day, what am I doing today that is going to further my leadership credibility so that people understand what the behavioral expectations in this workplace are? And if you don't go at it with that aggressive an approach, you have no chance of being successful. But the flip side is that when you get positive momentum, when you get rank and file employees who will come to you and say, hey, boss, I want you to know, this guy over here, like, he's good at his job, but he's antagonizing everybody, talking about, let's say, something, you know, that people don't get riled up about, like politics, okay? Oh, yeah, we had an election recently that I may have forgotten about it already, right? What is that employee who complained? What is that employee giving you as a boss? What do you think he's giving you? He's telling you that there's a problem. Go ahead, give her the microphone. He's telling you there's a problem. I voluntold you for this. What do you think he's giving you? He put a big steaming pile of a problem on your plate. What's he giving you?
He's giving you an opportunity.
An opportunity to succeed, right? You're really busy. You work 60-hour weeks as it is. You're frazzled because times are tough, and you don't have time for this. That's what 95% of people who get that steaming problem on their plate, like, yeah, I don't have time for it, which in the harassment setting, right, we know when you look at any of the case for the lawyers in the crowd, you've read these cases, there's 18 times that the companies put on notice and they do nothing or do something wholly insufficient because they're too busy. But they're not thinking strategically, because if they were thinking strategically, they'd be like, yeah, this stinks. I'm not happy about it, but now I know I have an opportunity to drive this issue to a positive resolution and let these people know, my good employees and the small percentage of the jokers, who I am, what I stand for, and when I fire one of these clowns, everybody's going to know that's who we are. We don't play that game. And then when you recruit, right, your employees, your rank and file employees, do you think when they know that you have a backbone and you'll deal with the problem, especially behavioral problems, which are so toxic in our society today, do you think that your rank and file employees are going to help you recruit talent? Do you think they're not going to be out there telling their buddies, hey, man, you need to come to work here. This place is legit. That dude or that boss, she doesn't mess around, man. This guy was a clown. She fired him so fast his head spun. And ever since he's been gone, man, this is a great place to work, right? But the most common scenario we get is complaint, ignore it, complaint, ignore it, and then it just blows up. So from a historical perspective, we know that this issue is not going away. It's not really going to change other than it's become more complicated. Social media has made it far more complicated, legally speaking, and because it's become a 24/7 blood sport. So it is even more important that we are super focused on what we are trying to accomplish. Let me talk about this for a second. I want you to think about what is it ultimately that you want to accomplish when navigating this issue? Jacob, where are you? Did he disappear? He disappeared. All right. I'm going to ask you, since you're in the front row, we'll share the mic. You just put something, she just put food in her mouth. All right. Tell me, you're managing a group of 10. You have one person who's a jackass and doesn't get it. You have to manage that person because they behave badly. What is it strategically you want to accomplish?
Strategically, I'd like them to stop being an ass. Strategically, I'd like them to stop being an ass. Stop the behavior. Set a precedent for the rest of us, set the tone. Let it be a teaching moment.
So she said she wants them to stop being an ass. Okay, fair enough. Is that a sufficiently strategic answer? Who says that's a sufficiently strategic answer? I can tell some of the ladies over here, you two, you like frickin' frack over here. Hey, Jacob, frickin' frack here. We need a mic.
Bear with me.
Green or yellow, doesn't matter. They both look like they can more than handle themselves.
Okay.
So it's not just I want him to stop being an ass. What do you want to do? What are you trying to accomplish? Tell us.
Yeah.
You got 20 employees. You got one guy. He's just creating hate and discontent. You can't meet your production quotas. You got people who want to leave. You're not recruiting as well. Your profitability is down. What do you want to accomplish? Tell us.
Yeah, well, his behavior needs to be corrected, needs to have actionable steps, so that when we do fire him, it is plausible legally. And then
Go ahead and take the mic, Miss Green. Come on, you don't be weak-kneed. You can do it.
Well, first I want to know why he's doing this behavior. I'm gonna talk.
Oh, hold on, time out. She gets a prize right there. She's thinking strategically. Why is he behaving that way? Does anyone here think that matters? Hell yes, it matters. Let's think that one through for a little bit. Is it that this person is 22 and it's their first real job and nobody in their life has ever explained to them that coming to work on time, doing your job the way you're supposed to do it all the time and behaving like an adult and not a teenager is a path forward to professional success? right? Do you think that educating this person on that might be of benefit?
Access to the team because they don't know anybody or haven't been held accountable for their behavior. So when you let them know, hey, why are you doing this? Okay, in the work environment, you can't do certain things. So when you set them, you tell them exactly what it is you're expecting of them, and then you tell them what's going to be held if they do not, do what you ask them to do. But again, you're trying to make an effective team, and that person could be a good asset once they've been educated on appropriate behavior in work.
So you're asking him, why do you think, I'm going to put words in your mouth. You asked the employee, and let me just digress for 1 second, come back to Ms. Green here, and then maybe Ms. Gold gets picked on again. Anybody here familiar with the concept of agency? In other words, you want employees to have a say and to own their own destiny. So instead of you saying to this employee, you act like a jerk, I'm not putting up with it. If you keep it up, I'm firing you. Yes, that's the latter part. That's like 3 steps down the road. The first step is what you correctly identified, strategically thinking. Why are you behaving like this? Do you think there might be a better way when you have conflict of some variety with an employee, with a client, with a vendor, to engage in problem solving that is positive and professional instead of making you and us look like third-grade idiots, right? And then we get into the second part where moving forward, what's the go-forward action plan as well as the consequences? Because let me tell you something. If you think that you're going to fire somebody in today's world, even if you've given them a PIP or a final warning, and Patrick, at the end of the PIP or final warning, what does it always say when the HR people get done with it? Failure to meet our expectations moving forward will lead to further discipline up to and including termination. But when you fire that employee, if you haven't told that employee ahead of time that you're going to fire them because they don't behave properly, guess what they're going to say when they sue you for discrimination or retaliation? I didn't know I was going to get fired. And you're like, a deposition. Didn't you read the last sentence? I did, but the HR police wrote that. My boss, who I've worked with, never told me that I was not meeting behavioral expectations, and if I continued to fail to meet behavioral expectations, I would be fired. You have to tell people what you need from them on this topic, right? You cannot mince words. You have to speak directly. Now, I'm not suggesting that you should be as direct as I am, because every person is different, and how you talk to them needs to be in a manner where they're going to understand it and accept it and not feel like you're beating them down. But I also go back to your strategic analysis. We want to give people agency on their behavior. Do you understand that there are negative consequences in terms of your relationship with everybody else you work with when you behave like this? Do you understand that you're disrupting our business? Now tell me, next time this happens, how might you do it better? And let them give you the solution, and then you hold them accountable to the solution that they proposed, assuming it meets your expectations, right? So really well done, you two. Are we picking on more people here? All right, got it. So let me, a couple things. You guys know this time of year, a lot of packages get delivered. You know, the brown buses, UPS. Anybody familiar with UPS? Maybe? Right. They had a jury trial on a single, I want you to listen to facts very carefully, single plaintiff race case in Washington State in September. Here are the facts. A black driver, and at UPS, right, they're generally, they're organized by the Teamsters, who are a rough bunch. So it's an interesting world with a company like that. But black driver transfers from Seattle to Yakima. I don't know anything about the geography of Seattle, but with a name like Yakima, it's got to be in the middle of nowhere. So the guy comes from Seattle and he goes to the middle of nowhere. And they always have managers that do ride-alongs, right? To make sure, because UPS manages everything. They have all the metrics and electronics. It's like Big Brother 1984. They measure everything. And then they're successful, right? So whatever. So this white manager is referring to this black driver who's new from Seattle in Yakima and calling him boy. And he does it not only to the driver, but to the driver in front of customers. And the driver says, will you please stop? And what does the manager do? Does he stop? Of course not. He doesn't stop. What is his answer to when he is asked to stop? What do you think he might say? Anybody want to hazard a guess? Oh, hang on. Where's green and gold? You guys are on a hot streak. What do you think? What do you think this manager might say in response to when he's asked not to call the black driver boy? Are you guys from the South? Okay. His response was, "I'm from the South. That's how I talk." Is that an excuse? Now, let's extrapolate facts for a second. Does that give license to a female to talk derogatively towards another female because they're female? Does it give a black employee the right to talk negatively and derogatory towards another black employee because they're both black? You do all the permutations, right? It doesn't matter, okay? This employee then goes to the warehouse manager who supervises the offending manager and says, "Hey, this is what he did. I asked him to stop, and this is what he said." What do you think the distribution center manager said? Huh? He's from the South. That's how he talks. What do you think the jury said? How much do you think they got whacked? Green and gold. Come on. How much did he get whacked? How much did UPS get whacked? What do you think? Come on, take a guess. $1 million? Come on, be specific. Okay, how about 238 million? 199 in punitives. What are punitive damages? Punitive damages are when a jury says, "We hate you, you suck, you're awful, and we want to make sure you never behave like this again." Right? That's what they say. Now, today's Thursday. I think Tuesday, that judgment was reduced to 40 million, okay? Because the court said there was no justification for punitive damages of that amount. Now, a couple of things I want to mention about that case that are fascinating to me. First of all, it was a single plaintiff case. That kind of number, you normally see a class action, right? You also, or you see something like there's real physical violence associated with it, or sexual violence, or like you don't see just using words like that. Here's what word did I not use in reciting that story to you that you would expect to hear in that type of case? The N-word. And the article did not reference the N-word being used at all. Like, how remarkable is it that the use of the word boy could result in a $238 million verdict? What does that tell you about the temperature gauge of our society, especially people who are on a jury, majority of whom will be non-management people, to companies letting employees be treated badly? They're not having it, right? So this whole concept of leading by example, setting expectations, and firing people sooner rather than later who don't get it, there's a real, put aside what that does, the negative to running your business if you don't do it, look at the financial consequences that could flow from that, okay? Now, here's another one this one I just saw this morning. And for my friends at the EEOC, they're going to be puffing their chests out. Let's not let their heads get too big. This is November 20th. This is a Texas jury. A Texas jury found in favor of the EEOC on Wednesday in a suit that saw SkyWest Airlines accused of sitting idle while an employee experienced persistent sexual harassment, awarding over $2 million in punitive damages for the workplace misconduct. Now, it doesn't have a lot of facts, but it does say that the company knew about the harassment or should have known. And it says the juror stopped short of saying SkyWest retaliated, but they put her on an indefinite leave. So the jury didn't find retaliation, which is interesting. They did find that SkyWest failed to act in the face of unrelenting sexual assault jokes that drove the employee to consider suicide. Well, let me ask you guys, and I was talking with my friends from the EEOC. Those of you who were here last year, remember, I spoke about mental health, addiction, and suicide last year, right? You remember I talked about how prevalent it is in our society. The statistics are horrific on all those topics. And so, right, if you know that people are being adversely affected by this type of behavior and you do nothing, right, you can expect to get whacked really bad in front of a jury in this day and age. Like, people are not having it. And post-COVID, people are way more sensitive. You guys might have figured that out, right? If you manage people, you know post-COVID, the world is crazy. We're still crazy. And we haven't totally figured it out. But these cases, right, these are not, like this factual setting is way worse to me than the UPS case. Now, obviously, I wasn't there for either one, so I can't say that, but just reading it, this factual pattern that you're making jokes and pushing someone on we're going to sexually assault you to the point where they're considering suicide, like that seems a whole lot more serious to me than the calling somebody boy. What do I know? But look at the disparity in the jury verdicts, right? I guarantee you in the UPS case, 100%, a whole string of white and black employees walked in, raised their right hands and said, yep, that manager's a racist. He was laughing and bragging about, giving this guy a hard time, calling him boy in front of customers, et cetera. I guarantee you that the workforce, the Teamsters came together and threw the company under the bus, appropriately so, for that bad behavior. Because there's no way you get a $238 million verdict with like nobody corroborating that type of behavior, right? So this is the real deal in terms of when things go south, if you allow this type of behavior, it can go really south. Let me just stop. Anybody got any thoughts, comments, questions at this point? Because I'm going to pivot here and go down to a different road.
And for folks online, if you have questions, please submit them in the chat. Remember to select presenter or host, and they'll be able to reach you. Oh, sorry, panelist or host in the chat. So if you have questions, submit it to the panelist or host.
If we just interrupt me if we have anybody online who wants to ask any questions. I've read this guidance, and there are a couple of things that, and people who are from the EEOC, put your fingers in your ears for a minute, or forget what I say. This is an interesting guidance, okay? It's the first guidance that's come out in like 24, 25 years, so it's been a long time. A lot of it is focused on topics that have arisen in the last 4 years, DEI-related type topics. Again, whether you find that to be persuasive and a relevant part of your job duties as a manager, I leave up to you. But I am telling you, as sure as I'm standing here, when sex and race are 75, 80% of all harassment complaints, you know what the primary objects of opportunity are for you. You know where people are most likely to have flashpoints, and you know where you have to manage them out of the workplace, right? So you want to think very carefully about how you navigate those two issues in specific. And it's very interesting because one of the things that I've encountered in the last 10 years, right? In the last 10 years, I have dealt with more, statistically speaking, more females who are senior managers and executives than certainly in my first 20 years of practice. And guess what? Do you think that females who are senior managers and executives are above being dragging ladies and acting as bad as any guy? Absolutely not. Like some of the most appalling behavior I have seen is from women. And you know what it is? It tells me this is not many times about the underlying issue. It is about an abuse of power. It's about people whose egos are out of check and they do not belong in the positions they're in because they cannot manage their egos. So when you are thinking about who am I going to put in a lead position, who am I going to put in a supervisory position, who am I going to put in a managerial position, you need to think very carefully. The fact that they're the best, let's just say, hypothetically, you're looking for someone to supervise or manage some sort of mechanical department. This guy is our best mechanical engineer. Is being a good mechanical engineer or a great mechanical engineer a job qualification for managing a department of mechanical engineers? Maybe, maybe not. I have to tell you, their ability to speak to people, to set expectations, to manage people, and most importantly, beyond all, is to lead people. That's a totally different skill set that may have nothing to do with their underlying technical skills. So you want to be very, very thoughtful about how you are analyzing who you put in these positions. And then when you put them in these positions of authority, because they bind the company to liability, as you all know, right, we need to be very carefully monitoring them and not just taking what they tell us at face value. Because if we're just taking what they tell us at face value, we're setting ourselves and them up for failure. So going back to the guidance, one of the things I found interesting, there are a couple of points for those of you who manage people that I want you to take away from this. I think that the most important points of the guidance to me, if you manage people, are the discussion about what should be in a policy, how you train, how you investigate, and how you discipline, right? Because that, to me, is practical application that you need to understand. Look, it's not binding, legally binding guidance, and there will be some challenges to this guidance for certain on some topics. But as a general proposition, this guidance gives you some very good pathways on how to structurally set yourself up for success, okay? But none of it will be successful if you don't have the leadership piece established. That's just simply not negotiable. Now let's talk about policies. How many of you here manage people? Okay, where's Jacob? Where's that microphone? Put your hands up again if you manage people. Hit this lady up over here in the white shirt, since she's right by you. All right. You've been voluntold. How many people do you manage?
3.
3. Okay. Do you think if I were to walk into your workplace and you told the people, hey, this is Fred, he's some clown from New Jersey who we retained to help us identify potential issues in our workplace, do you think that they would tell me the truth, or would they just like make stuff up to make you look good?
Say that again?
Would they tell me the truth about the workplace culture, or would they just make stuff up to make you look good?
Would they tell me?
Tell me.
Oh, I think they would.
They would.
No.
Okay. Would they tell me that when I asked them, does the company have a harassment policy? Do you think, what would their answer be?
Yes.
And then I say, have you read that harassment policy? What would they say?
Hope so.
What's that?
They better have.
Yes. Hope is not a strategy.
Yes.
If I ask them, what can you tell me the policy says, what answer would I get? What answer would I get? Do you know? All right. Somebody else take the mic. I've overwhelmed her. What's the play? Who manages other managers?
Right here.
All right. We have the same barber. That's why he got into it. So you manage other managers?
Yes.
Okay. And you can use this, because I call this mental jujitsu, but it's super effective. If you were to ask one of your managers, hey man, just check in. Do we have a harassment policy? What would your team say?
Yes.
Is that definitive? Yes?
Absolutely.
Absolutely. If you ask the next question, what does the policy say? What do you anticipate they would tell you?
Exactly what's in it.
Really?
Yes.
How many pages is your harassment policy?
It's in depth.
It's in depth. And they would be able to quote you chapter and verse?
They would most likely be able to guide you through top to bottom, maybe not word for word. I'm over employee performance and culture and employee relations as Deputy Assistant Commissioner. So
give us a high level. What would their answer consist of? I want to hear this, because I got to tell you, I've never had anyone tell me that if they put their team on the spot that they could tell us what the policy really said, other than don't use the N word and keep your hands to yourself. So being a little facetious, not much. Go ahead. What?
My division does the training,
right,
with Department of Corrections, so all the prisons and HR staff. So they train on the policy. They've attended DOHRs, mandatory, annual. They're facilitators, so they've been trained on the policy. So they would be able to tell you exactly Title VI, all the protected classes, all of it.
What would they tell me about the procedure when somebody has a complaint about harassment?
We train on the procedure for filing a complaint. The complaints come to my office, well, my staff's office, and then we provide the guidance on how that investigation is done. My director actually assigns it to my staff to investigate it. So essentially we train HR managers all across the state on what that policy is as far as being able to file the complaint. We reference it and they send it to us, plus provide them the guidance on what not to do when somebody gives you a complaint. So
what is it that you tell them not to do?
don't start investigating it for yourself. Don't get into the questions of what they're claiming to you. Make sure that you forward that immediately to our office because time is of the essence around.
Right. All right. So here's what, for those of you who manage people, I want you, when you go back to work, to play this little game for me. I want you to pick out a manager and ask this manager, hey, brother, I'm just checking in. How's everything going? Yeah, good, glad. Looks like your performance is going pretty good. I just want to check in, though. Do we have a harassment policy? I want you to ask, that's question number one. Do we have a harassment policy? Number two, if yes, have you read it? If yes, when was the last time you read it? That's going to be a big indicator, right? Can you tell me what the policy says? And see what degree of specificity, you talked high level, fair enough. But I want to know, what are they going to tell me? What does the policy say you're not supposed to do? Like, flesh it out for me. Don't just tell me, oh yeah, you can't behave bad. That's not an answer, right? What is the reporting? Does it address a reporting mechanism? And if so, what is the reporting mechanism? Because guess what? Guess where most of these matters get choked off at the front end, where we end up having big liability. People either don't know how to utilize the reporting procedure, the reporting procedure recipients don't know that they're recipients, or they don't take that obligation seriously, so the complaint never gets sent to the right level to be investigated. The policy says that we will investigate the matter. The policy says after we investigate the matter, we'll fix it, right? Remedial action. I'm going to come back to remedial action. And then it says what not to do. No retaliation, right? Because the number one problem with harassment complaints is not harassment, it's the retaliation every single time. Play that game with your management team and see if they can answer those questions in a coherent manner. My guess is they won't. They'll give you some very thin answers, right, that tell you we have work to do. Your managers need to know the basics of the policy. And the most important point to me that you need to make to your management teams on this topic, or even, this also applies to ADA analysis. They identify there's an issue. Like, that's job number one. So that means they have to pay attention to their employees, pay attention to their workplaces, and when they observe that something is wrong, they have to engage sooner rather than later. Identify an issue is number one. What do you think number two is? Come on, you're the big shot. I'm putting you on the spot. They identified the issue. Next.
Report?
Yes. You have to report it to the right people so that the right people can do what they need to do. And you can tell your managers, if you do those two things, we win and you win, right? But we know like 90% of the time, they either are not paying attention, or in the case of the distribution center manager in the UPS case, he was so stupid that he thought that it was okay to say, well, he's from the South, that's how he talks. Like, he just totally blew it off, right? Which is even more callous disregard of the policy and the expectations. So play that game with your managers. Ask them to answer those questions for you. If they can't answer those questions, then you need to get into the weeds and train them, right? So let me go back to the EEOC guidance. It talks about the policy and what you should consider having in the policy. Take a look, that's good stuff. Then it talks about training. And I want to talk about training for a second, because there's a lot of different ways to train people. And at the state, I'm assuming you guys use like virtual learning tools because they're time effective, cost effective, and they can actually be fairly helpful, right? But on a topic like this, especially for your management team, do you think that that's an effective way to communicate what you need to people on an issue that's so problematic as harassment? No. You have got to get in front of your people in person and talk to them face to face and let them know what the deal is. And here's the thing, right? It is, to me, and the guidance talks about kind of how to do this, but I have to tell you, I'm a firm believer that military principle KISS, keep it simple and stupid, right? Here's the thought. Maybe go on the EEOC's website, hit the newsroom drop down, pull a few of the recent harassment cases where they've gotten either a big verdict or a big settlement, generally 7 figures, and use that as a training platform. Ask people to read the case. It'll take them 3 minutes because it's no more than 2 pages in big font. Ask them, what went wrong here? Why did it go wrong? How would you deal with this situation differently? Make it a real world event, not just what is the definition of hostile work environment? What is severe and pervasive? Blah, 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 right? It gives me a headache just thinking about it, right? When I get in front of management teams, I pull these cases out. Like, I love it. It's for free. The EEOC does my job for me, right? But here's the reaction I get. I swear to God, here is the reaction I get to these cases, especially ones with really egregious fact patterns. I can't believe people still act like that. I'm like, what planet are you on? Like, I want to say, are you alive and with it? Like, do you know there's a thing called social media that has made us like hate one another? Like, are you kidding me? Make it real. And that way you can roll that into a discussion about, hey, you see how this case unfolded? You see these mistakes people made? Well, let's talk about a scenario in our workplace, a recent scenario in our workplace where maybe we could have handled it better. And you don't have to make it specific. You can make it generic. And then you kick it back and forth about how is it that we didn't timely identify? How is it that we didn't timely investigate? How is it that we didn't make an informed decision? How is it that we didn't engage in appropriate remedial action? How is it that we didn't, insist and ensure that there was no retaliation? Right? These things you can train on them in a practical application manner in very short order. Now, it also talks about, I mentioned policy, training, reporting procedure, but then the investigation. There's really good information on investigations. And I realize that most of you are here from the state and there's a defined process, okay? You need to follow the process to the T. But if you're in the private sector and you don't have those resources immediately available to you, you need to think it through. A couple of things. Am I going to investigate in-house or am I going to outsource it to an HR professional or a lawyer who's a third party? The more serious the case, the more likely you outsource it, right? Because you want to be able to put that person on a witness stand and have them testify that they did a professional investigation. So when you're in front of that jury in Yakima, they're not whacking you for $238 million, right? So you want to think through this issue of how we investigate. A couple of things I'll just mention to you. I know you had a session on investigations this morning, but a couple points I want to make. One of the first considerations is, am I conducting this investigation into a harassment under attorney-client privilege or not? You need to make that decision at the outset. And the general dividing line is, if the employee who's making the allegation or filed the charge or filed the lawsuit, if they are a former employee, right, you're starting that investigation out under attorney-client privilege because it's in anticipation and defense of litigation, right? Whether it's a charge or litigation, same thing. If they are still an employee, you guys heard of Farragher defense, right? We want to use that defense. We want to use the investigation as part of our defense. So we're going to be segregating which portion of it is privileged and which portion of it is not privileged. Okay, because we want to be able to throw out a bunch of information and witness summaries to a jury and say, look, we got the complaint. We jumped right on it. We investigated it right away. Here's all the paper we put together, right? Show good faith that you were jumping on it with 2 feet immediately. By the way, let me just skip to one topic here that's relevant, but what do you think is a good strategy if you have somebody who is accused of being a bad actor in terms of his or her behavior? What do you think might be a good strategy to mitigate retaliation? Green and gold. Come on, you guys, help me out here. We got a bad actor, got a complaint about a bad actor. What are we going to do to ensure that the bad actor doesn't retaliate once he knows or she knows that an investigation's underway? Say that for the crowd, please. You're hitting it out of the park again.
We put them on administrative.
Yeah, we're getting that person out of the workplace so that they don't have an opportunity or as easy an opportunity to retaliate. Okay, so they're out of the workplace, then we go through our investigation. What's another thing? I was joking with my friends here before about people in these scenarios. They think that, they're smarter than everybody else, so their bad behavior is put on social media, put on their work email, put in text messages, right? The litigation hold obligation starts immediately. Even if there's no formal threat, you need to anticipate that you are headed to litigation and you need to grab all of the electronic information you can sooner rather than later so that it doesn't disappear. because that electronic information is going to, one, tell you whether or not there's smoke, whether it's just smoke or whether there's real fire here. And if you don't grab it, you'll be accused of deep sixing it when you get in litigation, and then the judge jumps on you with 2 feet and you're in a really bad place. So you need to be thoughtful and strategic on how you investigate, then making determinations about whether or not people have engaged in behavior that really constitutes harassment, right? I will tell you that the vast majority of harassment investigations that I do, whether as part of litigation preparation or as a third party, the behavior is not harassment in the legal sense of the word. It may be bad behavior. It may be somebody being a jerk. It may be somebody being a bully, but it is not illegal behavior. Does that, let me vote, the fact that it does not, the behavior we investigate and the behavior does not constitute illegal harassment, does that mean that the offending employee is off the hook? Who was talking down here? Green. Hey, Jet, you need to stay down here because these Frick and Frack are all over it here. They're killing it. She's batting like 750. She's like an MLB All-Star.
I'm just saying it's probably could be a policy violation.
What would be a policy violation? Be specific.
The behavior might not be legally illegal, but it could be a violation of our policy.
What if it's not a violation of the policy, technically speaking, but it's still, the person's being a jerk?
You still need to address it.
Yeah, that's right. One of the downfalls I see in these scenarios is that employers have noticed that someone doesn't behave properly, but they're like, well, that's just who he is. And he's not saying anything that is per se in violation of our policy. But you guys ever hear the concept death by 1,000 slices? If someone is a jerk over and over and over again, right, whether or not that behavior technically violates our policy, are you going to tolerate it? And if you allow it to continue, do you think that at some point that behavior, it's like you have a teenager and you tell them to be home at 10 and they roll in at 11, there are no consequences. Next time they don't come home. It's like there are no rules, right? Because there are no consequences. So you're going to have to be very, very specific, right, about what it is that you expect in that type of scenario. So it may be that somebody is not technically violating the policy, but that's why I go back to plain talk. Your behavior is disrespectful. Your behavior is undermining our ability to function as a team. I don't care about a harassment policy. I don't care about a bullying policy. I'm telling you, as sure as I'm standing here, if you can't be respectful, if you can't be a good teammate, you're gone, right? That's the analysis you have to apply. Because I'm telling you, you look at these cases, it's the same thing. Bad behavior not addressed becomes worse, not addressed, and then the people who complain all get retaliated against every single time. So on the determination piece, think strategically. And here's the thing. So let's roll this into remedial action. Okay, where's the microphone? Let me have this because I got to keep frickin' Frack on the roll here. Hey, Frick, Frack's been killing it. It's your turn. Here, will you hand this back? Thank you. All right, you ready?
Yes.
Okay. We have Bob, and Bob insists on just saying things that are antagonizing. There's nothing in it that is overtly racial, sexual, whatever. He's just being a jerk. And he knows he's being a jerk, but he always stays just a little bit under the radar screen, one step on the right side of the law, and you've identified it, and you're going to call him out on it. But what I want to know is, what is your strategic plan of action to address this scenario? Walk me through what you're going to do and who you're going to do it with. That was a multi-choice question.
Well, I'm going to do it with Bob.
Is Bob your primary audience? Think carefully. Trick question.
Well, I have to set an example so that everybody can see.
You're on the right track there. Keep going.
Like she said earlier, we have to identify the why. And you said strategically, what would I do?
So the point is here, Bob is a secondary audience. Bob may or may not succeed because he doesn't seem to want to behave properly.
Okay.
I am leveraging Bob to let everybody else know what my behavioral expectations are and what the consequences are going to be if they don't play nice.
Okay.
Right? So again, strategically, my audience is the team that reports to me as opposed to Bob. Bob is a secondary concern.
Okay.
Right? So let's just roll into remedial action. Let's just say in this scenario, Bob's 22. He's never had a real job before, like where he actually had to be an adult. And so we're going to give him a coaching opportunity because he legitimately doesn't know any better and he's not done anything so egregious we have to formally discipline or fire him for. So we're coaching him up. He's getting another training on the policy. He's signing off on a counseling memorandum that tells him, this is the expectation on behavior. This is where you screwed up. This is in the future. These are the 2 or 3 things you're going to do differently so that you don't behave like that again. Here's the time frame in which I expect you to get on step with my expectations. And oh, by the way, if you don't get on step, here are the consequences that are going to flow from that, right? Okay, what are we going to do with the rest of the team? What? Give me a suggestion. How am I going to deal with the rest of the team? After I tune up Bob, what am I going to do?
Revisit the policy with everybody or the action plan if that behavior, if somebody else.
All right, so this is a good, she's focusing on 2 things, specific and general. The specific as to Bob is going to be private to Bob. The general as to the policy and even hypotheticals that might somewhat mirror the scenario with Bob, right? We're going to use that as a coaching opportunity for everybody.
Yeah.
But first of all, going back to Green's point earlier, we want to kind of understand when we're talking to people, hey, what's your temperature gauge on this workplace? Do you feel like you're respected when you work here? Do you feel like this is a good place to work? If there are problems, what are those problems? Like, what can we do better? What can you do as an employee? What can you do better to make us collectively better, right? And have sort of that strategic 365 discussion about how we can all do better to work in a place that we all want to work in, right? Again, Bob's secondary, right? But in most of these scenarios where I see companies struggle, they get it right with Bob because that's easy. It's what's right in front of their face. But they're not thinking about 2nd, 3rd, and 4th order consequences. Go ahead, Patrick.
The other thing I want to know is this Bob or is this more than Bob? Because if this is a recurring pattern that Bob's just one more story, that's on us. If Bob's a one-off, that's more on him. But we got to be looking at what are even our select. You talk about promoting somebody up into it in the engineering. It's a different skill set to be managing. And if we're not looking at what do we base our selection of them on in the first place, just being an engineer is not the same thing as these kinds of behaviors that make you a good manager. What kind of feedback or performance assessment are we giving them along the way? What kind of developmental coaching are we giving them along the way? What's the accountability on the back end of that? That we own, but too many organizations, it's all about put them there, it's on them, it's the blame game, and it's not solving it.
Well, if you look at, I won't even get into it, but there are plenty of examples in our society. And by the way, you guys know who Patrick is? Patrick is he runs the MTSU Industrial and Organizational Psychology Master's Program, which is like the #1 ranked program in the country. Like, he's a rock star. And anyway, just so you know who he is, he teaches some of the brightest students I've ever met in my life. Every time I'm with his students, I'm like, God, I am by far the dumbest person in this room. But they actually listen to me. I'm like, I walk out of there, I'm like, oh my God, I fooled them again. They didn't, if they started scratching beneath the surface, I'd be in trouble. Yeah, no, but your point is very well taken. But that goes to talking about, explain to me, what's your temperature gauge on our workplace? What are we doing right? What are we not doing right? Employees will tell you if they believe that you will lead by example and actually take what they have to say seriously and do something about it. The worst thing you can do is, hey, Mr. Employee, tell me what we can do better, and then do nothing about it, right? Because even if they give you a solution that makes no sense on how you can improve behavior, you can at least go back to them and say, hey, we analyzed this, and this really doesn't work for X, Y, or Z reasons, but we appreciate you giving that input, and we're going to do something different to make it better, and this is what we're going to try, right? But most times what I see is in one ear, it's lip service, okay? So remedial action, very important, thinking about strategically who you're trying to address here. I mentioned litigation hold, also documentation. Do you appropriately document your interview summaries? Do you have some sort of a findings document, right, that tells us were the allegations corroborated, not corroborated, or inconclusive? And then what is specifically stating what the remedial action is going to be? And then clearly no retaliation. Now, I did want to make, in a couple minutes I have left, by the way, for those of you who submitted questions in advance, I told Jacob, I have never had such thoughtful questions submitted. It was like crazy. I was sitting there having my coffee this morning, like 7 o'clock. I'm like reading this stuff. I'm like, oh man, they're loaded for bear. I better be ready today. They're all over this. So I want to talk about the politics because you guys, a bunch of you asked about politics. Now, you guys know the election's over, right? So we don't have to worry about politics in the workplace, right? Right. This is we're living in times of insanity. And so I'm bifurcating my answer. For those of you who work for the state, employees have a First Amendment, they have First Amendment rights that apply. And so you're going to have to navigate this carefully. And I know that there are attorneys at the state who deal with these issues. So I'm going to defer to them to a certain extent. But the analysis is the higher you are on the food chain, the more limitations apply to your First Amendment political speech, right? And when people get really angry about this and they're like, hey man, this isn't communist China. I get to talk about whatever the hell I want to talk about. And the answer is, well, maybe or maybe not, right? If you are in the private sector, the answer that I tell my clients to give is, hey, I appreciate the fact that you feel very strongly about political issues. Good for you for voting. Good for you for being engaged in our society. But guess what? We're not the government. This is a private for-profit employment setting, and the First Amendment has no application. So if you're on social media, venting your spleen in a manner that violates our harassment policy, our discrimination policy, our anti-bullying policy, right, talking about our last speaker, he was saying, well, there are a bunch of people who are employees who are following that person on the gram. They're also talking about it, the same thing at work. It's not like they turn it off. That outside work behavior is absolutely a workplace-related disciplinary or termination event if they are going to continue to behave in a manner that is unacceptable under your policies. Most people in the private sector really chafe at that and they don't get it. And I'm like, well, too bad. I'm sorry you don't get it. But you have no constitutional protections here. You have no right to this job. You're an employee at will. If you can't live and behave in a manner that aligns with who we are, adios muchacha, vaya con Dios, you're out of here, right? And some people don't like it. It's fine. Free country, man. Go find a job elsewhere. And literally, I tell my clients, when an employee is having that conversation with you, you tell them, okay? Yes, you have a First Amendment right to your protection of your free speech. That First Amendment right doesn't apply here. You can vent your spleen any way you want. I'm not telling you what to say or not say. I'm just telling you, you can't behave here like that and work here. The two are mutually exclusive. You choose. Remember that concept of agency? You choose, brother. It's your decision. You want to rant and rave about politics and insult everybody who you work with? Have at it. But you ain't working here. And then you need to stand firm and fire that person. Now, on the government side, right, as I said, it's a sliding scale. The higher you are in the food chain, the more limitations you have, the lesser your First Amendment protections are. And again, I'm going to defer to the state lawyers on that. But it is one of these things that I think from a strategic perspective, if you are managing other employees, even if you're managing managers, you need to focus them on the issue of culture. What is our culture? What do we want it to be? How are we going to recruit and retain employees? Are we going to be successful in recruiting and retaining employees and having them be productive when we allow employees to rant and rave on social media and insult everybody they work with? No, you're not, right? And it's simply not okay. And that, by the way, that behavior that we talked about with frick and frack, it's barely, maybe it violates our behavioral policies. It's certainly being a jerk. Maybe it violates our behavioral policies. If we let it go on for 6 months, it's inevitably going to rise to the level where it violates the behavioral policies and subsequently it violates Title VII. And here's another thing. Our prior speaker mentioned the National Labor Relations Board in Section 7, right? Protected concerted activity. Employees have a right to engage in protected concerted activity on issues of dealing with wages, hours, and working conditions, right? So in other words, employees, at least under this current administration, they can get away with a lot about saying really nasty things about their supervisors and managers if they're saying it on behalf of themselves and others. So they touch on wages or something like that, and then they're, you know, my boss is an MFer and all this other stuff, the NLRB is going to say that's okay. And I say to employer, Patrick heard me say this yesterday, you have a scale. Your scale is on the one hand, what is my risk profile with this employee who's a problem? The scale on the other hand is my workplace culture and the viability of us as a group to be effective and productive. Which one do you think is more important in the grand scheme of things? Frick and frack, come on, this is easy. Individual, group. Group. Sometimes you need to fire people. Sometimes you need to get in a lawsuit and defend it if you're in the right. But you're going to have, the EEOC people here are going to tell me, Fred, I'm going to talk for them. I don't really care that the NLRB says they have a right to do it. That behavior violates Title VII, and therefore we're going to hold you accountable. So in other words, you're in a catch-22 with Uncle Sam. If the EEOC is not going to step on you, the NLRB is. I'm picking my fight with the NLRB every day. I'm not picking my fight with the EEOC. Somebody asked me why. Why, right? Because I value my culture and my employees more than I'm worried about a fight with the NLRB. The Title VII requirements go to the heart of who we are as employers. Providing a workplace where people are given an opportunity to succeed. Equal employment opportunity, right? That to me that's my own personal opinion. So when it comes to these behavioral issues, sometimes there is no right or wrong. There is no definitive black and white. So you need to think about the scale. Which is more important? The group, our culture, us as a team, or this one person? Right? And you're going to have to do that your own analysis on that. I'm just telling you, 95% of the time, I'm going with my group analysis because I value the work and the effort it took to create a positive team. And I'm not going to let someone who engages in bad behavior take us down. It's just not okay. And you may have some limitations on that on the government side. But again, I suggest you don't walk away from that issue. How much time do I got? Am I 5 minutes? All right, I'll wrap up here. Our prior speaker, he talked about, in a different context, about this issue of generational issues, right? On the AI side, for example, in the tech sector, a lot of the tech companies get hit for age discrimination because they have an assumption, either intentional or unintentional, that's baked into the software that does their interviewing, that it definitely favors people who are younger and therefore excludes people who are older who might be qualified, right? That's a real thing. I know from an age discrimination perspective, in age cases, I don't see very many of them. They're not that prevalent, honestly. But I know for a fact, being old, that once you hit 55, if you're in a senior level position and you lose your job, you ain't getting another job at that level. That's a fact of life. It's just a fact. Some things are facts of life, whether you like them or not. Okay? So when we are talking about the issue of the generational divide, I want you to think about, if you have people who are 22 to 65, how many generations is that? Like ballpark 4, something like that? Do those 4 generations have any concept of how to talk to people who are of a different generational stripe? Put aside sex and race, because I have to tell you, to me, and you can disagree with me on this. This is my own personal opinion. If I put at a table, white male, white female, black male, black female, they're all 65. I put at another table, white male, white female, black male, black female, they're all 25. They're different on race and sex. But the differences between the 25-year-olds as a group and the 65-year-olds as a group, to me, are going to be far more pronounced than it will be between white male, black female, white female. The generational divide is because we have cultural expectations of what is and is not okay. And I'll give you a perfect example. My now 28-year-old daughter, when she was like 20 years old, I showed her what I consider to be the finest TV ever made. Archie Bunker and George Jefferson. I swear to God, if you watch those shows and you think about the messages they're getting, I'm like, this was brilliant, beyond belief. She said to me, that's the most racist, ridiculous nonsense. I can't believe you watched that. And I'm like, oh my God, you're totally missing the point. And then I thought about it. I'm like, well, maybe I'm missing the point. Maybe I don't understand her as a 20-year-old. So when you're thinking about how do we navigate behavior in the workplace, this generational divide, as the last speaker was talking about, the statistics of older people working, we need to focus on how we talk to one another. That's a lost art because, especially with younger people, it's all texting, tweeting, and social media, and put them together. They're like, I don't even know how to do this. Like they text across the table because they can't. We have to manage that. The last thing I want to talk about is language matters. Some words and some phrases are totally unacceptable no matter what. And I want to give you two specific examples. I have seen more scenarios in 32 years of doing this where there are allegations of use of the N-word. I am telling you, as sure as I'm standing here, if you allow anyone, white, black, pink, polka dotted, green, purple, to use that language, regardless of how they are saying they are interpreting it, you are setting yourself up for catastrophic failure. Why? Because the language that is okay among black people today, when one of those black people gets fired, they're going to say, I was offended, but I didn't say anything about it because I wanted to fit in with my black coworkers or something along those lines. And you, Mr. Manager, you knew about it and you let it go. It doesn't matter. You cannot allow people to use that type of language under any circumstance. And that means if they're on social media doing it, you have to police it, and you're not going to be George Orwell, 1984, following them and micromanaging their social media efforts. But when it is brought to your attention, which it will be, you have to do something about it. The other thing is derogatory language about women. And I don't care, again, whether it comes from a female saying it to a male, it doesn't matter, right? Because once that person gets fired, they will inevitably say, I had to talk like that. I had to swear like a sailor because I was one of the only females here, and the only way I'd fit in with the guys was to act like that. And then you're still going to lose, right? And then talk about also the underlying, if you allow it, what is our culture? What does it say about us as leaders? It says that we don't have a backbone and we're not doing the right thing. And having a backbone and doing the right thing is conceptually easy. Application sometimes can be hard. But the point is, if you do the right thing and people know you're going to do the right thing, your rank and file team will do the right thing for you because, as I said at the outset, they know if they don't follow through and execute on your expectations that you're going to hold them accountable for knowing about a problem and ignoring it or not doing something about it. All right, last question, then I'm out of time. All right.
So if language matters, then why do you keep calling these employees over here frickin' frack?
Do you want me to call them green and gold?
No.
I'm calling them frickin' frack because they're over there whispering in each other's ear like they're lifelong buddies. And they're, by the way, they're hitting like 900.
Sir.
Hey, frickin' frack, are you offended? I apologize. Is that acceptable? You guys rock. All right, thank you, everybody.
So we are about to hit the break. I will ask if there are any other questions online, if you can please submit them, and then we'll share it with Fred afterwards for a response. All right, so we'll be back at 2:30. So if you guys will have about a 10-minute break, 9 minutes, and then we will continue. Okay, everyone on the virtual live stream, if you guys can sign back on now, we're about to begin with our final session of the 2024 Employment Law Seminar. Again, if you have any questions or comments for the online webinar stream, please submit them to the chat to either the panelist or host, and they will be able to read them off for the presenters. So to kick off our next session, I'd like to introduce one of our planning committee members, Melanie Kohler, Deputy General Counsel of the Tennessee Department of Human Resources. She will present our speakers for our final session of the day.
Good afternoon, everybody. Welcome to the season finale of the Employment Law Seminar. We're excited for those of you who hung on with us to the end, and we have two very exciting speakers for you for this last session of the day. I'm so thrilled to introduce two members of my team, Jourdan Tonti and Elizabeth Hufham, who goes by Libby. Jourdan serves as Associate Counsel within DOHR's Office of General Counsel, specifically within the EEO division. In her role, she oversees the biannual reporting process for all executive branch agencies, handles workplace investigations, facilitates workshops and trainings to state employees at all levels, and offers guidance to state agencies on employment law matters. Jourdan believes that by working to improve work environments and keep employees safe, we indirectly make the world a better place. Fun fact about Jourdan is she recently attended Taylor Swift's Eras Tour concert. She was in the 12th row. So if those of y'all fought the Ticketmaster war and lost like I did, we're very jealous of Jourdan and her luck. Libby Hufham serves as our Assistant Counsel in the Office of General Counsel, EEO Division as well. In her role, she conducts workplace investigations involving various policies within the state, including workplace bullying, workplace discrimination, and violence in the workplace, as well as involving providing guidance on those policies, FMLA, ADA, and similar employment law matters. Libby enjoys public policy. She was inspired to work in a legal sector job that is policy-driven. She believes her work plays a small hand in creating a more inclusive and diverse society. And Libby's fun fact is that for the holiday season, she is looking forward to eating cinnamon sugar toast, which sounds delicious, homemade hot chocolate, not from the box, and other delicious family treats. So please welcome Jourdan and Libby as they present on Your Employee is Expecting What Now?
Good afternoon. All right, Mr. Colclough said every presentation should begin with a joke, so here goes. What do a pregnancy and a joke have in common? A good delivery. All right, well, we've heard some great information today from other presenters, and we're happy to be closing it out with expecting employees. Before we jump in, a few housekeeping things. You all receive sheets in your handouts for CLE credit. I'm sure the instructions are on there, but fill them in and turn them in if you want credit for these courses. Confidentiality, we may go through some scenarios today. None of them are real names or anything that can identify anyone. And if you end up talking about anything, we encourage you to protect confidentiality as well and don't share names or any identifying information. Also, Libby and I may be lawyers, but we give the disclaimer that nothing we're about to say should be taken as your own legal advice. Every situation is different and depends so much on details. So it would have been impossible to make this a one-size-fits-all presentation. So always seek your own legal counsel if you have an issue. We're happy to try to connect you with someone if you do need help. And also thank you to those of you who sent in questions ahead of time. There were a lot, also very thoughtful questions. We made sure to incorporate them into the answers into today's presentation as best we could. But for time purposes, we do ask that any further questions wait until after the presentation. We do believe we might take right up until the end. So we ask that you save those for email and then you send us after, and we'll be able to think of thoughtful responses for you. Our contact information will be on the last slide. Last note, we apologize ahead of time. You will not see much of our eyes because this information is very dense. We're presenting on, and it's going to require some reading. All right, let's begin. So over the last many years, there have been laws, regulations, guidance relating to expecting employees, whether through pregnancy, adoption, or fostering. Some of those, like the Pump Act and the Pregnant Workers Fairness Act, have come out recently. Others have existed for many years. But with so many different aspects and things to consider, we thought it might be a good time to kind of just get all on the same page, touch on each of these, remind you of what you should be thinking about if you do have an expecting employee. And so I'm not going to go through all these, but this is what we're going to cover today. First up, we're going to talk about the Pregnancy Discrimination Act of 1978. The EEOC, as we've heard multiple times today, is responsible for enforcing federal laws that make it illegal to discriminate against a job applicant or employee because of race, color, religion, national origin, age, disability, genetic information, and sex. The EEO enforces 3 federal laws that protect job applicants and employees who are pregnant. That's Title VII of the Civil Rights Act of 1964, which was amended by the Pregnancy Discrimination Act. The ADA, as amended by the ADA Act of 2008. For the rest of this, I'll say ADA, but I'm talking about the 2008 inclusion. And then the newer Pregnant Workers Fairness Act, which we'll refer to as PWFA. These EEOC laws apply to all types of work situations: hiring, firing, promotions, harassment training, wages, and benefits. Let's briefly cover Title VII and the ADA before taking a closer look at the Pregnant Workers Fairness Act. So Title VII, primary federal law that prohibits employment discrimination based on race, religion, national origin, color, and sex. Congress enacted the PDA in 1978, which amended Title VII to make it clear that discrimination based on pregnancy, childbirth, or related medical conditions is a form of sex discrimination that's prohibited by Title VII. Under Title VII in the PDA, pregnancy discrimination can be based on a current pregnancy. This is refusing to hire an employee just because she's pregnant. A past pregnancy, this can be something like firing an employee while they're on maternity leave for no justifiable reason. A potential pregnancy, like not promoting a female employee because she voiced her intentions to create a family. And this also includes contraception, firing an employee for taking birth control, and then also a medical condition related to pregnancy or childbirth. Demoting an employee because of her breastfeeding schedule is an example of that. And then abortion also falls into this. So pressuring an employee to have an abortion if she wants to stay on path for advancement is an example of that. Moving into the ADA, this protects individuals from employment discrimination on the basis of disability, limits when and how an employer may make medical inquiries or require medical examinations of employees and applicants, and requires that an employer provide reasonable accommodations for an employee or applicant with a disability. It's designed to eliminate discrimination on the basis of disability by essentially equaling out the playing field with employees who do not have a disability. While pregnancy itself is not considered a disability under the ADA, pregnant workers and job applicants are not excluded from the protections of the ADA. Changes to the definition of the term disability resulting from the Amendment Act of 2008 made it much easier for pregnant workers with pregnancy-related impairments to demonstrate that they had disabilities for which they may be entitled to a reasonable accommodation. Now, despite that 2008 amendment, it was still a bit difficult for pregnant workers to qualify for an ADA accommodation because typically when you're thinking about a disability, you're thinking long-term. This is something that this person's going to have for a while. And it was still a little bit difficult to qualify. And so with that, the PWFA was born, pun intended. It became effective on June 27, 2023. It requires most private and public employers with 15 or more employees to provide reasonable accommodations or workplace modifications to qualified employees with known limitations related to pregnancy, childbirth, or related medical conditions, unless the accommodation will cause the employer an undue hardship. The PWFA essentially closes the gap between the PDA and the ADA. The PWFA does not preempt more protective federal, state, or local laws. To the extent any of those laws overlap or provide more employees' rights, the employer must follow the applicable laws that are most favorable to the employee. The EEOC released the text of the final rule and interpretive guidance implementing the PWFA on April 15th of this year. And after receiving more than 100,000 public comments, the final rule was published and it became effective June 18th of this year. Now, there are a lot of overlapping and matching terms within ADA and PWFA, but there are some key differences, so we are going to go through those. First up, defining a known limitation. So this is the first key difference. Under the PWFA, the known limitation required for an accommodation under the PWFA can be significantly lower under that than the ADA. Under the final rule, a limitation under the PWFA is any physical or mental condition related to, affected by, or arising out of pregnancy, childbirth, or related medical conditions that has been communicated to an employer. The condition can be modest, minor, or episodic, and it does not need to meet the definition of disability under the ADA. The limitations can occur before, during, or post-pregnancy, and the final rule essentially makes clear that the limitation does not need to be a disability that substantially limits a major life activity. Some examples of limitations under the PWFA can be morning sickness, inability to breathe in chemicals, being unable to lift a certain amount of pounds, postpartum depression, lactation, notably under the EEOC's final regulations, infertility, menstruation, endometriosis, fertility treatment, miscarriages, and abortion all fall within the scope of the PWFA protections as well. Shortly after, this is just a note, shortly after the EEOC published the final rule on PWFA, a group of 17 states, led by Tennessee, filed a lawsuit in the Eastern District of Arkansas seeking to halt enforcement of the rule, specifically the part that requires employers to accommodate pregnant workers who want or need an abortion. That court ruled on June 14th of this year that the plaintiff states lacked standing, meaning the required level of injury to proceed with the lawsuit, and dismissed that case without prejudice. The court explained that even if they were to consider the merits of the case, the plaintiff states were not entitled to an order enjoining the final rule because they had not shown a likelihood of irreparable harm. Other similar lawsuits have been filed across the country, and given the landscape regarding that issue, we may see more guidance to come out in the future. Back to no limitations, the condition becomes known to the employer when the employee or employee's representative has communicated the limitation to the employer. That representative can be a family member, a friend, a doctor, a union rep, or other similar representative. That limitation can be communicated to a supervisor, a manager, someone who has supervisory over that employee, or who regularly directs the employee's tasks. You can go to HR or another appropriate official, or the employer may have a specific reporting or request policy. There are no magic words to request an accommodation under the PWFA, but here are just a few examples. I'm having trouble getting to work on time because of morning sickness. I need an hour off once a week to see the chiropractor for my back problem that started during my pregnancy. I'm worried that if I keep continuing to lift heavy boxes, it'll harm my pregnancy. Or could you please put my wife on light duty because her doctor has restricted her from lifting? Note that the limitation may be a need or a problem related to maintaining the worker's health or the health of the pregnancy. It doesn't need to be caused solely, originally, or substantially from the pregnancy or the childbirth. So it could have been an existing condition that was exacerbated by the pregnancy. Back pain is a common one. So it has to relate in some way. If an employee who gave birth 2 weeks ago is vomiting from food poisoning, probably not going to be a known limitation under the PWFA. They may try though. All right. The next key difference, the ADA does not require an employer to provide a reasonable accommodation that would eliminate or modify an essential job function for any period of time. In other words, qualified employees under the ADA must be able to complete all essential job functions with or without an accommodation. However, the PWFA rule indicates that employees who are unable to perform one or more essential functions of their job can still be qualified as long as the inability is temporary, the employee can perform the essential functions in the near future, and the inability to perform the essential functions can be reasonably accommodated. In other words, the PWFA allows for temporary suspension of one or more essential job functions. The final rule defines temporary as lasting for a limited time and may extend beyond the near future. It also states that for a current pregnancy in the near future generally means 40 weeks from the start of the temporary suspension of the essential job function. The EEOC indicates that this marker of 40 weeks doesn't mean that pregnant employees are automatically afforded 40 weeks. That's kind of just the guidance they considered as qualified. Essential job functions can also be temporarily suspended for conditions occurring after pregnancy, like postpartum depression or lactation. For these conditions, near future isn't defined as any particular length of time, but the guidance did make clear that an employee who needs indefinite leave cannot perform essential functions in the near future. Next, let's talk about some of the reasonable accommodations under the PWFA. All right, so this is a non-exhaustive list of examples that would address known limitations related to pregnancy, childbirth, or related medical conditions. Frequent breaks. This is additional, longer, more flexible breaks to drink water, eat, rest, use the restroom. Sitting or standing. Sitting. Schedule changes, part-time work, and paid or unpaid leave. Telework or remote work. Just a note on allowing employees to work from home, because we did receive quite a few questions about certain considerations for remote workers. If COVID taught us anything, it's that there is a way to work from home in many jobs. As an employer, if you had employees successfully working remote, especially the pregnant employee who's now requesting to temporarily work remote, it's going to be a little bit difficult to prove that it would be an undue hardship. So keep that in mind. And as far as any special considerations for accommodating an employee who's currently remote, you might have to accommodate less, because I think working from home does, eliminate a lot of issues to begin with. But some options are still, that employee still may need a delayed start for morning sickness, or, more frequent breaks or time off for appointments, just to give a few examples. There are also many other possible reasonable accommodations. And also a point, a worker may need different accommodations throughout their pregnancy. Things change. I've heard morning sickness doesn't last the whole time. I don't know. So, you can change the accommodations throughout the worker's pregnancy as well. In another departure from the ADA accommodation standard requiring interactive process and assessment, the PWFA rule identifies predictable assessments. These are situations that it's pretty much automatically required for pregnant employees upon their request. There are four on the screen. These are simple modifications that will essentially in all cases be found to be reasonable accommodations that will not impose an undue hardship when requested by a qualified employee. And so these are carrying or keeping water near and drinking it as needed, taking additional restroom breaks as needed, sitting or standing as needed, and taking breaks to eat and drink as needed. EEOC observed that employers should be able to provide these, and in fact, many accommodations under the PWFA with little difficulty. Again, reasonable accommodations can be given to employees postpartum as well, so long as the limitation stemmed in some way from the pregnancy. Accommodation examples in those cases may be allowing the employee time to go to doctor's appointments, allowing them to work remote for a period of time while they recover from a pregnancy-related condition, allowing them to work from home while they're treated for postpartum depression. Those are a few examples given. All right, let's talk about the undue hardship. When an employee can perform all of the essential job functions, undue hardship has the same meaning under the ADA and generally means significant difficulty or expenses for the employer's operation. However, if the employee cannot perform all essential job functions and the accommodation is a temporary suspension of an essential job function, the employer needs to consider the ADA definition of undue hardship as well as the following factors: the length of time the employer applicant will be unable to perform the essential functions, whether there's other work the employee can be doing, such as transferring the employee to a different position, the nature of essential function, including its frequency. Is this something that truly cannot be not done? Whether the employer has temporarily suspended the performance of essential job duties for other employees in a similar position, whether there are other employees, temporary employees, or third parties who can perform or be temporarily hired to perform the essential functions, and whether the essential functions can be postponed or remain unperformed for any length of time and for how long. In another departure from the ADA, the PWFA rule limits when and what type of documentation is required. Specifically, the rule states that employers may seek supporting documentation only when it is reasonable under the circumstances for the covered entity to determine whether the employee has a physical or mental condition related to, affected by, or arising out of pregnancy, childbirth, or a related medical condition, and needs an adjustment or change at work due to the limitation. So, what does this mean? EEOC indicates that what will be considered reasonable for the employer to request minimum that's sufficient to describe or confirm the physical or mental condition, that the physical or mental conditions related to, affected by, or arising out of pregnancy, childbirth, related medical condition, and the change or adjustment at work needed due to the limitation. So, did I lose the page? I dropped my slides before I came up here. I'm missing a page. As far as what's not reasonable, the limitation, these are the situations where it would not be reasonable to ask an employee for additional documentation for their limitation. The limitation and adjustment or change needed is obvious, and the employee provides self-confirmation. This is like asking for a bigger uniform. That's obvious. You shouldn't ask the employee to give you documentation to prove their stomach is growing. The employer has sufficient information to determine whether the employee has a qualifying limitation and needs an adjustment or change due to the limitation. Morning sickness, I think, would be a good example of this. You really can't prove you have morning sickness beyond asking the employee to send you a video of them vomiting, and that's not encouraged at all. So that's an example of that. When the employee is pregnant, one of those 4 predictable assessments, break, sitting, standing, carrying water nearby. The reasonable accommodation relates to a time and or place to pump and or to nurse during work hours, and the employee provides self-confirmation. Or the requested accommodations available to employees without known limitations under the PWFA pursuant to one of the employer's practice. So if you don't require any of your employees to provide a doctor's note unless they're out for 3 days, say, you should not request your employee to give you a doctor's note for having to miss a day being sick. All right. So wrapping up, here are the prohibited practices and key takeaways for the PWFA. An employer must not fail to make reasonable accommodation for a qualified employee's known limitations related to, affected by, or arising out of pregnancy, childbirth, or related medical conditions, unless it causes undue hardship. Remember that under the ADA, a qualified employee with respect to an individual with a disability means that individual can perform all of their essential job functions with or without an accommodation. Under the PWFA, not only are those individuals qualified, but also individuals who are temporarily unable to perform one or more of those essential job functions will be able to perform in the near future, and it can still be reasonably accommodated. An employer must not require a qualified employee to accept an accommodation that wasn't agreed upon through the interactive process, or deny employment opportunities to a qualified employee because it has or will have to provide a reasonable accommodation. These are still consistent with ADA. Or require a qualified employee to take paid or unpaid leave if another reasonable accommodation can be provided absent undue hardship. And then lastly, punish or retaliate against an employee or applicant for requesting or using a reasonable accommodation for a known limitation under the PWFA, reporting or opposing unlawful discrimination under the PWFA, or participating in an investigation surrounding the PWFA. And also note that the PWFA protects employees and applicants from coercion, harassment, intimidation, threats, or interference in exercising their rights or helping others exercise their rights. Nope, didn't mean to do that. As far as best practices go, given the temporary nature of pregnancy-related conditions, the EEOC encourages employers to respond quickly to employee requests for accommodations under the PWFA. With this, their best practice listed was granting the accommodation on an interim basis if the employer requires additional information, reviewing and updating workplace policies and accommodation procedures to align with the new guidelines as needed, providing training for HR personnel and management so they really understand all of these changes and can enforce them. Establish processes to monitor ongoing adherence to PWFA requirements and address any compliance issues promptly. This is still a newer law, and we will continue to learn as the EEOC lawsuits for PWFA violations are decided, so keep an eye out on those. The most important takeaway from the creation of this law, I think, is to remember that its purpose is to make it easier for employees to receive accommodations for conditions and limitations that regularly and commonly occur during and after pregnancy. While it may make things difficult for a period of time for the employer or the employee's coworkers, employers need to remember that it is temporary. The standard is lower than ADA and takes a less strict approach with documentation because it is a temporary situation. We received a question that referred to a pregnant employee's request to work from home due to morning sickness as extreme, but is it? If you woke up every morning throwing up for 2 hours, would you want to go into work? Employees are more productive when they are comfortable and feel supported. That's a fact. So keep in mind during the interactive process, when you want to laugh at some of these requests, ask yourself, is saying no to this temporary situation worth ruining this employee's morale or potentially losing that employee? All right, let's test your knowledge. If you would like to participate, please scan the QR code or go to mentimeter.com and enter the code to join. You can just hold your phone up to the screen and your camera, it should have a little thing you can click on. It should take you to the link. And even after we're done with this, you can keep the link on your phone because we'll be using it again a couple other times today. Oh, has everyone got it? Okay. All right, first scenario. Betty experienced a stillbirth 5 months into her pregnancy. Betty's job involves going into a chaotic office every day and mainly conducting phone calls with customers, which she feels would be overwhelming. As a result, she sent her employer a doctor's note stating she could not return to work for approximately 6 weeks to recuperate and grieve. The next day, Betty was terminated without engaging in the interactive process because the employer didn't want to deal with that mess. Does the PWFA, that's the first question, does the PWFA account for stillbirths? What? Okay. Are they? Can you tell if they're all on? Yeah. I mean, they're still going, but okay. It looks like mostly all of you got it right. Yes, the PWFA includes stillbirth as a pregnancy-related medical condition. Question 2, how did the employer violate the PWFA? A, failing to engage in the interactive process. B, failing to provide an accommodation. C, terminating Betty for requesting an accommodation. Or D, all of the above. Good job. Y'all are confident about it. Yes, 100%. D, all of the above. The employer made no effort to go through the interactive process with Betty. They failed to provide what, obviously we only have minimal facts, but what seemed to be a reasonable accommodation just because they didn't feel like dealing with it. And the employer retaliated against Betty for terminating her for requesting an accommodation. Last question for this one. What if the employer had engaged in the interactive process and was able to prove that 6 weeks of leave from work would be an undue hardship? What are some other accommodations the employee could consider? Go ahead and submit some ideas. Let's see what you come up with. A lot of working from home, remote work, limited hours, coming in late, leaving early, moving to another job, less chaotic. Yeah, so a lot of similar responses. Some ideas thought of allowing Betty to work remote if she's okay talking to customers, but just doesn't want to be in an office around people right now. Reassigning Betty's job duties to less social tasks where she doesn't have to talk to people all day. So great responses, thank you. All right, let's do one more. All right, Veronica is facing challenges in her first trimester with nausea and vomiting, which make commuting difficult. To address this, she makes a verbal request to work from home for 2 months. Veronica previously worked remote during the COVID pandemic and maintained her work performance. Is there a known limitation? Yes or no? All right, 70% say yes. Yes, this would be Veronica's nausea is a pregnancy-related condition requiring a change at work, and she voiced her request to the employer. What if Veronica's husband had contacted the employer on her behalf with the request? Would it still be a known limitation? Yes or no? Yes. So remember, the employee's representative can make the limitation known to the employer as well. Is this a situation where the employer could, or should I say should, request documentation? Yes, an overwhelming no. This is one of those situations where it's really hard to prove that the employee actually has morning sickness. It's like we get sometimes, I saw one that sticks with me, where the employer asks the employee to get a doctor's note for a headache, which I feel like is hard, yeah. But this is the type of self-confirming condition you kind of just have to accept. Last question. Knowing Veronica previously worked remote with no issues and has the means to do so now, would the employer be able to prove there was an undue hardship? Oh. Right, not likely. Because the employer previously allowed Veronica to work remote and she maintained good performance and still has the means to work from home now, it's employers most likely unable here to prove that it would be an undue hardship. Now, we got a lot of questions. So say you do have a pregnant employee who has attendance issues in the past or hasn't performed particularly well. Consider some of your options there. Allowing the employee to modify their schedule to begin the workday an hour or so late if you truly don't think this employee is going to succeed working from home. Try a trial period. Say, we'll revisit this in a couple of weeks and see how it's going. We're willing to try this, but these are what we need you to do. Set some limitations there or requirements. Just do your best to work with the employee is our bottom line, is try your best. All right. And remember, it's temporary situations. Okay. The last thing I'm going to cover before turning it over to Libby, the EEOC harassment guidance that was released this year. This is the first time it was updated in quite a while. In explaining how to evaluate whether harassment violates federal EEO laws, it touched on a few areas, touched in relation to pregnancy and childbirth, so we're just going to summarize those up. The guidance clarified that sex-based harassment under Title VII includes harassment based on pregnancy, childbirth-related medical conditions. This can include issues such as lactation, using or not using contraception, or deciding to have or not to have an abortion. Harassment based on these issues generally would be covered if it's linked to a targeted individual's sex, again, including pregnancy, childbirth, or a related medical condition. Harassment based on, there were also some cross-basis issues, what they call them. Harassment based on the perception that an individual has a protected characteristic, for example, believing that someone's pregnant, can be harassment even if the perception is incorrect. Harassment that's based on the complainant's protected characteristic is covered even if the harasser is a member of the same protected class. This was covered earlier. Intra-class harassment is what that's referred to. So a pregnant person can harass a pregnant person. Harassment based on protected characteristics includes harassment based on social or cultural stereotypes as well, regarding how persons of a particular class act, such as persons of a particular sex. This includes harassment based on sex-based stereotypes about family responsibilities. Who's heard of pregnancy brain? Who's heard that term? Yeah, don't tell a pregnant employee that they have that, but that's an example. On that same note, employers need to avoid making decisions for employees based on the stereotypes or assumptions or opinions on what a mother or father should be doing. Assuming a pregnant worker can't complete certain tasks or won't be able to focus on a big project is discriminatory. We received a question about how to get supervisors to not make decisions for expecting mothers. Our best advice is to train and train and train your supervisors. If they understand that doing those types of things could be considered discrimination and could open them up to discipline or being the cause of a lawsuit, they'd probably pay more mind to avoid that type of conduct. A lot of it, from what we see, is I didn't know that or I didn't see that. So just making those things clear to your employees is key. We also received a question about how to prevent women from being passed over for promotions while on parental leave and what policies can be put in place to avoid gender being a competitive advantage for career advancement. So if we're talking about protected leave, that could be retaliation. For FMLA, at least, someone can't be passed over for a promotion solely due to them having to take FMLA leave. So keep that in mind. And then kind of overarching, as an employer, your employees shouldn't feel like they have to sacrifice their legal rights or their benefits to bond with their child or take care of their health in order to advance their career. So try to keep that in mind as well. Also, employers are responsible for preventing workplace harassment. Employers are responsible for quickly ending harassment if they do become aware of it. And when do they become aware of it? Somebody complains, doesn't have to be the victim. Owner, manager, supervisor witnesses the conduct, or the harassing conduct so open and obvious that the owner, manager, they should reasonably have known what was happening. There is no one-size-fits-all approach to responding to a harassment complaint. An employer should conduct a prompt, impartial, and thorough investigation to determine whether harassing conduct occurred, and then take appropriate action to address it. What steps to take, what evidence to gather, who to interview will, again, depend on the particular facts and circumstances of the allegations. Luckily, you all learned earlier how to conduct an investigation from Ms. Wright, so you all know how to do that now. Best practices for this harassment guidance: employers are strongly encouraged to have a clear, easy to understand anti-harassment policy, plain English. I know for the state, we have a respectful workplace training for all new employees, which goes in depth through our EEO policies. Have a safe and effective procedure that employees can use to report harassment, including more than one option for reporting. We have many in the state. You can talk to your supervisor, you can file a complaint with your agency, you can talk to your agency's HR, you can come straight to us at DOHR. There's an online form, many options. Provide recurring training to all employees, including supervisors and managers, about the company's anti-harassment policy and complaint process. At the state, we have the annual Respectful Workplace Refresher Training, so state employees keep up to date on any changes we have and are kind of reminded about the things they should not be doing. And lastly, take steps to make sure that anti-harassment policy is being followed and the complaint process is working. And with that, I'm going to turn it over to Libby.
Can everybody hear me?
Yes. You want to move the chair over?
No, I'm okay. I got the cool Britney Spears mic today, so. Okay. First, I want to start by saying, did you guys know that around 70% of pregnant women experience shortness of breath during pregnancy? I'm one of them. So if I'm huffing into the mic today, please just ignore me. I'm really sorry about it. I'm sure the 3 rolls at lunch didn't help either. You're right, it was 5, but I didn't lie. So as Jourdan noted, this information is dense, detail-oriented, and ever-evolving. So this is the last time you'll see my eyeballs, probably. They're brown, if you care. I'm going to be reading from my notes, so I make sure I give you all the correct information throughout the rest of our presentation. And again, if you have any questions, we ask that you reserve them for after the presentation so we can give well thought out responses. Like we said, this is very dense information. We don't want to mislead you. On that note, let's start with newer legislation passed in December 2022. You're gonna hand me the mic or that thing. Under the FLSA, nursing mothers are entitled to reasonable break time and a private space to pump at work for up to 1 year after their child's birth. The Pump Act was passed by Congress in December 2022 and amended the FLSA to expand these rights to more nursing employees. Its passage marked the first time the federal law entitled workers to break time and space for pumping. The Pump Act expanded breastfeeding protections to nearly 9 million additional women. While expansion of these protections is a positive one, there are still a number of exceptions under law which will leave many employees unprotected, such as women in many transportation industries, including members of train crews, airline crew members, rail carrier employees, and motor coach employees. Some will not receive protections of this law until December 2025, and some employees will not be employers, excuse me. If I get those mixed up today, I will try to correct myself, but there's a lot of E words in here. Employers will not be required to make accommodations if they require a significant expense. Generally, the FLSA covers most private and public employment. Employers are required to provide a reasonable amount of break time and a space to express milk as frequently as the mother needs. Employers with fewer than 50 employees are not subject to the FLSA break time and space requirement if compliance would impose an undue hardship based on the specific circumstances. For instance, in transportation industries, it's literally written into law that if it requires the moving of seats, they do not have to provide that accommodation. Undue hardship means an employer must demonstrate significant difficulty or expense of compliance in light of the size, financial resources, nature, and structure of the employer's business. The WHD will consider an employer's alleged undue hardship on a case-by-case basis, but many argue that this still presents a real possibility that smaller employers will be able to deny these protections to their nursing employees. There are no required words or forms necessary for an employee to get time and a place to pump at work. The employee should let the employer know that they are pumping at work and need breaks and a place to pump. How do I change it? There you go. As noted, in accordance with the Pump Act, nursing employees are entitled to reasonable break time for pumping needs. Rather than take a one-size-fits-all approach, this brief amendment requires employers to provide eligible employees with a reasonable break time to express breast milk for up to a year after the child's birth. The Department of Labor considers the frequency, timing, and duration of the pump breaks as a function of the needs of the nursing employee and their child, without regard to the employer's preference. Accordingly, the employer cannot dictate a schedule to which the employee must adhere, and if the two agree on a schedule, the employee may adjust it as their breastfeeding needs change. The Act does not require employees to be paid during pump breaks, quote, unless otherwise required by federal or state law or municipal ordinance. Additionally, if the employee is not completely relieved from their work duties, the time must be considered hours worked. Furthermore, if the employee is normally granted paid breaks at work, these breaks can be used for pumping. Employees who telework are also eligible to take pump breaks on the same basis as if they were working on site. And importantly, an employer may not require an employee to provide doctor's notes in order to take pump breaks. So next, the private space. In accordance with the Pump Act, the space for expressing milk provided to mothers must be shielded from view, free from intrusion from coworkers and the public, not a bathroom, and functional as a space for expressing breast milk. To ensure privacy, the employer may post a notice when the space is in use or provide a lock on the door to prevent others from entering. The Department of Labor's website provides flyers and doorknob hangers to post outside of pumping spaces to aid in denoting the space as such. While the space must be functional for pumping, according to the Department of Labor requires 1, a place for the pumping employee to sit that is not on the floor, and 2, a place to store breast milk. Further functionality is not required by the Pump Act. Some argue that this is an oversight. that may result in employees being required to pump in a location that lacks the outlets necessary for many traditional electrical pumps or without sinks for the employee to wash pump equipment afterwards. And legal recourse. Unlike prior protections, the Pump Act has more areas for legal recourse when an employee's rights are violated. Employees may either file a complaint with the Wage and Hour Division of the Department of Labor about any violation of the law or bring a private suit to enforce the reasonable break time mandate of the law. If the employee wishes to file a private suit over the lack of space to pump, they must first provide the employer with at least 10 days to become compliant after the initial request for space. There is generally a 2-year time limit for FLSA claims. However, per their guidance, the Wage and Hour Division recommends reporting potential violations of the reasonable break time and space requirement as soon as possible to allow the agency to address instances of non-compliance as soon as possible. Employees are protected from retaliation if they ask for a time and place to pump at work or if they are pumping at work. An employer cannot retaliate against an employee for exercising their rights under law, filing a complaint, or participating or cooperating with an investigation. All right, so we're going to do another test your knowledge. If you want to participate, same link, same code. We're going to go on to the first one. Hold on. Y'all got it? Anybody needs them? Okay. All righty. Irina, a shift manager at a restaurant, takes 4 25-minute pump breaks each day when she first returns to work after the birth of her child. Irina's need to pump changes as her baby grows, and when the baby is 6 months old, she reduces her pump breaks to 25 minutes twice a day. What is this an example of under the Pump Act? I don't know if it's, hold on. And if anybody wants to speak, I don't know if this is giving us problems or not. Is it allowing responses? No? Okay, that's what I thought.
Well, I have a mic here if anybody.
Yeah, if anybody
wants
wants
speak.
to. Okay, reasonable break time, that is good. So this is an example of reasonable break time under the Pump Act. Moreover, an employee may change their pump breaks as necessary as their pumping needs change. Yeah. Did my phone. Oh, there we go. Okay, now it's taking stuff. All right, so next one. Haley has recently given birth and has asked her employer for a place to pump. Nancy, her manager, tells her that there are ample bathrooms available for her to pump in. They're single stall, have locks on the door, and include a bench to sit on. Is this a permissible location for a pump break? Right. So under the FLSA, a bathroom is not permissible. It's not a permissible location for pump breaks. So using a bathroom to pump breast milk raises health and safety concerns, which may include the risk of contracting bacteria in breast milk or breast pump equipment. Now say Haley's employer provides a permissible pumping space in accordance with the Pump Act. Haley also asks her employer to install a sink in the space so she can wash her breast pump equipment appropriately. Is the employer required to provide Haley's request a sink under the FLSA? Right. So while the space must be functional for pumping, which according to the Department of Labor requires 1, a place for the pumping employee to sit, not on the floor, and a place to store breast milk, further functionality is not required. Again, some argue that this is an oversight for nursing employees. Okay, last one. Julia is on a pump break when she receives a call on her work cell phone from a coworker who provides her with instructions regarding a work project. After she finishes the work call, Julia completes her pump break. Is Julia entitled to compensation for this time? Yes. Because Julia was not relieved from duty, the time she spent on the call must be counted as hours worked. As with other breaks under the FLSA, a nursing employee must be completely relieved from duty, or the time spent pumping must be counted as hours worked. So next we're going to look at FMLA. FMLA is extremely dense. So like I said, you won't see my eyes, and if you have any questions, please reserve it for the end. Email us, we'll be happy to answer, but we will need time. So the Family and Medical Leave Act allows eligible employees of a covered employer to take job-protected unpaid leave or to substitute appropriate paid leave if the employee has earned or accrued it for a total of 12 work weeks in any 12 months. Covered employees include this list up here. So this is private sector employees with 50 or more employers, with 50 or more employees, all public agencies, federal, state, and local government, and local education agencies like public and private elementary and secondary schools, regardless of the number of employees at each location. So FMLA eligibility. To be eligible for FMLA benefits, an employee must have worked a total of 12 months and have worked for at least 1,250 hours, and that's actual hours worked, over the previous 12 months, and work at a location where there is at least 50 employees employed by the employer within 75 miles. All public agencies are covered by the FMLA regardless of the number of employees. So next we'll look at qualifying conditions. The list on the screen is not comprehensive, but it covers qualifying conditions under the FMLA related to pregnancy and adoption. Parents may use FMLA leave when their child is born and to bond with their child during the 12-month period beginning on the date of birth. Both mothers and fathers have the same right to take FMLA leave for the birth of a child and bonding. Parents may also take FMLA leave for the care of a newborn child who has a serious health condition or for a serious health condition related to the pregnancy or birth. Under the FMLA, a child is defined broadly and includes a biological child, an adopted child, a foster child, a stepchild, a legal ward, or a child of a person who is standing in loco parentis to the child. A parent is defined as a biological, adoptive, step, or foster parent, or someone who stood in loco parentis, but does not include parents-in-law. So under the FMLA, placement of a child with the employee for adoption or foster care and to care for the newly placed child within 1 year placement is defined as a qualifying condition. Additionally, if an employee is needed to care for a family member, spouse, child, or parent with a serious health condition, this is also defined as a qualifying condition. So the FMLA allows eligible employees to take job-protected leave for pregnancy-related reasons, including prenatal care, incapacity, which is the inability to work due to pregnancy, childbirth, or related medical conditions, recovery from childbirth, including a stillbirth, caring for a spouse who is incapacitated due to pregnancy or childbirth, adoption or foster care required, which is examples of required counseling, court appointments, and related travel prior to adoption or foster care placement, and or bonding with a newly adopted or placed foster child within the first year. An employee must provide at least 30 days advance notice prior to the date the leave is to begin. If the notice is not possible, it must be given as soon as practicable. We received the question, what exactly qualifies as a simple statement in regards to documenting FMLA related to parental leave for bonding with a baby? In the vast majority of cases, it would still need to be some sort of official documentation, like a note on the HCP's office letterhead stating the anticipated due date, patient name, and signature of the HCP. So just as simple as doctor's note could suffice. And a few more notes here. The FMLA does not require notice in advance of future leave, but employees are protected from an interference prior to the occurrence of a triggering event, such as the birth of a child. FMLA leave can be taken intermittently. However, employees who take intermittent leave for planned medical treatment have an obligation to make a reasonable effort to schedule the treatment so as to not disrupt unduly the employer's operations. And when an employee takes FMLA leave on an intermittent or reduced leave schedule basis, an employer may not require an employee to take more leave than is necessary to address the circumstances that precipitated the need for the leave. Employers must track FMLA leave using the smallest increment of time used for other forms of leave, subject to a 1 hour maximum. The employer may only deduct the amount of intermittent leave the employee actually took. And we'll look at some FMLA best practices. What is our end time? 12 minutes, okay. So first, prepare adequately before an employee is expected to go on leave to avoid having to contact them. An employer may require an employee to periodically report on his or her status and intent to turn to work. The best practice when an employee is on FMLA leave is to limit contact as much as possible, only reaching out when absolutely necessary for critical updates or administrative purposes to avoid any perception of interference with their protective leave. Essentially, try not to speak to them unless there's a compelling reason to do so. And if you do communicate with an employee on FMLA leave, clearly document the date, time, and content of the conversation and ensure correct record keeping. Be prepared to offer the employee an accommodation under PWFA or ADA. Check in on the employee as they're transitioning back into the work routine. And on return from FMLA leave, whether after a block of leave or an instance of intermittent leave, the FMLA requires that the employer return the employee to the same job or one that is nearly identical or equivalent. Ensuring supervisors are thoroughly trained on FMLA is crucial. Make sure they know not to inadvertently interfere with or retaliate against an employee exercising FMLA rights. And finally, stay updated on the law. Like we said, it's ever evolving, so don't be complacent and catch yourself following outdated practices. Okay.
We're gonna try to breeze through these state law just so we can get to our fun questions. Yeah. So this is Tennessee, the state of Tennessee's law on parental leave. Employees who have been with the same employer for at least 12 consecutive months as full-time employees can get up to 4 months of leave for adoption, pregnancy, childbirth, nursing an infant. This applies to employers who have at least 100 full-time employees on a permanent basis at their worksite. This also applies to fathers, so fathers also get 4 months of protected paternity leave. It could be with or without pay at the discretion of the employer, requires 3 months advance notice except in the cases of emergency, and employees must be reinstated at the end of their leave unless they use that time to look for another job, whether somehow working for another employer or their position so unique that the employer cannot, after reasonable efforts, fill the position temporarily. Under this law, you can choose to begin your leave before your child's birth, but for adoption, your 4-month period begins when you receive custody of the child. The Tennessee state government's paid parental leave also went into effect last year. This allows for up to 6 weeks of paid leave for the birth of a child or the adoption of a child. It's available for employees who have been employed with the state for at least 12 consecutive months and are in a full-time pay status. Ask for 30 days notice, but things happen, babies come early, so if that's the case and it's less than 30 days, just giving notice as soon as reasonably possible is the standard. Employees may be asked to submit documentation confirming date of birth. All of that 6 weeks has to be used within a 12-month period, but it does not have to all be taken at the same time. And if you happen to have spouses in it, they both each get 6 weeks. All right. I think we can go to
the tester.
Yeah.
Should probably get our last two.
You're FMLA.
Yeah.
Okay, we're gonna do, like, back out. A couple more test your knowledges.
We're doing a rapid fire.
I think we may have to skip the rapid fire unless you want to do it. Okay, so has everybody got it? There's our QR code. So Ash has worked for her organization for 12 months, but because she was initially hired on a part-time basis, she has only worked 1,100 hours. Ash and her spouse have recently decided to adopt a child. Ash is requesting 4 weeks of leave now to travel to a foreign country and fill out the required paperwork. She has also requested another 12 weeks and approximately 2 months to pick up and care for the baby. Can Ash take FMLA leave? No, Ash has not worked the required hours for FMLA leave. So, knowing this, should you tell Ash not to apply because they will not be eligible anyway? Ash should be informed of the FMLA law and the rights and responsibilities. However, Ash may be eligible for parental leave under state law. And note that if Ash had the required hours, she would only be eligible to take FMLA leave after the child has been placed with her. There is the triggering event. So the next one is while on FMLA leave, after the birth of her child, Kate's supervisor, John, began calling her at 10 a.m. each day to provide daily updates on his team, their ongoing projects, and how overwhelmed the team is due to her absence. Kate told John that she preferred not to be contacted anymore while on FMLA leave. However, John called her the next day and told Kate that she would not be able to handle her, quote, old position because she, quote, won't understand anything based on changes that have occurred while she has been on FMLA leave. Are John's actions considered FMLA interference? Yes. Like we said, it's best practice to limit communication with employees on FMLA leave to only what is necessary, such as requesting critical information or documents. So training supervisors on this is really important. They may think something is crucial for the employee to know, but 10 out of 10 times it's generally not, unless it's just something that they have to handle. What do you want to do from here?
We're going to go through a few more questions, but y'all can just shout them out. You don't have to use that. All right. An obviously pregnant employee seeks a bigger uniform because of her pregnancy and is asked by her employer to provide additional documentation. Is the employer's request acceptable? No. Obvious limitation. Under the PWFA, a pregnant employee requesting additional bathroom breaks is per se reasonable and not an undue hardship. True or false? True. Good job. An qualified employee under the PWFA can be someone who cannot perform an essential job function for a temporary period. True or false? True. Well done. Okay, Claudia becomes aware of her employer's, it should say employee. Claudia becomes aware of her employee's pregnancy and begins insisting that the employee sit constantly, do only simple tasks, and avoid any tough mental work because of pregnancy brain. Could Claudia's conduct be considered as sex discrimination or harassment? Yes. Is it possible for an employee in Tennessee to be eligible for FMLA, parental leave, and paid parental leave, assuming their employer has paid parental leave at the same time? Yes. Bobby wants to use 2 weeks of FMLA leave when his child is born, and for the next 20 work weeks, he wants to use FMLA leave half-time and work half-time. Is Bobby's employer allowed to decline the intermittent leave request for bonding? So in this case, no serious health condition. Where's my answer sheet? Yes, employees may only use intermittent FMLA for the birth or placement if the employer agrees to it. Now, consider instead that Bobby wants to use FMLA leave for 3 hours a day for 2 weeks while his newborn baby is in the NICU. Does Bobby need his employer's permission to work intermittently in that situation? No, not a requirement. We're going to skip through those. All right, so some wrap-up points. Best practices. Set practices to ensure continued compliance. maintain adequate record keeping, post any required signs that you need to, assign someone to keep up with EEOC, Department of Labor, and other laws or guidance that may be released regarding pregnancy or parenting laws and regulations, train employees on respectful workplace etiquette and discriminatory practices, document everything. I'm not giving you a list because you all know what you need to document, but document everything. Train your supervisors. Supervisors are your front line. They're most likely to become the first to be aware of something. So if they don't know how to handle that notice properly, it can land employers in trouble. If they're punishing an employee for taking leave, it can land employers in trouble. Good supervisors who are well trained on their roles for anything involving PWFA, ADA, FMLA, harassment laws, that's crucial to avoid liability for employers. Also, they set the tone for the rest of the office. If they're positive about an employee becoming a parent and not complaining about the extra workload or the inconveniences, it helps the rest of the office maintain that good positive morale. And then be consistent. What you do for one employee, be prepared to do for another employee. A lot of the times when employers are treating people differently, can trigger that you're looking like you're treating people differently or retaliating. And so the more consistent you are, the better you're able to justify decisions. It leads into the next point. Be able to justify all of your decisions, especially the ones that are going to negatively impact one of your employees. And then lastly, have grace and keep the big picture in mind. Like I said before, happy employees are productive employees, and providing employees with support and resources allows them to be healthy while they're growing their families, which was, most likely the goal in mind when these laws were being passed and created. Yes, it may be a temporary inconvenience when an employee is on leave. I know teams of 2 to 3 feel that when an employee is out, but again, keep the big picture in mind. Be nice. Remember, it's temporary. It's easy to be cynical and assume the worst in people's minds today. You might wonder if your employee really is getting sick at home or if they'd rather just be working at home. But, these things are known as common limitations, common conditions for a reason. And the vast majority of employees who are applying for these accommodations really do truly need them. So just try to keep that in mind. And with that, we thank you for coming and turn it back over to Jacob.
Thank you, Libby and Jourdan. Do we have any final questions for Libby and Jourdan?
We do
Either
have
online?
one online.
Okay.
So if an employee is attending a work-related meeting, but not in the employee's normal workplace, is there an expectation that the employee should be provided a place to pump? And is there a specific place in the Pump Act that covers this? And then the last part was, does it matter if the meeting was organized by the employer or not?
Would you mind emailing us that question and we will get back to them,
Yes,
please?
ma'am.
Thank you.
So we will respond to that question. So save it in the chat. We will follow up with the presenters and get back to you soon.
There you go.
You can find their contacts on the screen right now. So please take a screenshot or snap a quick photo. I will also be following up with the email tomorrow with a number of documents for both in-person and digital attendees, including PDFs of the slides, which you have received most already, but also digital forms, submission forms for evaluations and whatnot. And then we will follow up next week with any potential responses. So as I mentioned earlier, when we were breaking for lunch, I do like to take temperature checks to see where folks are at. And kind of give some moments for reflection and debrief. Now, I know this is a large group of people we have, over 100 in person, 100 online. So although I'd love to have discussions, get us connecting with some partners and doing reflection, we are short on time. So we'll be using the Menti platform once again to do a quick debrief. And we want to hear from you all. We'd like to hear one word to describe how you're feeling or maybe one takeaway from this seminar. So if you want to do a word or a short phrase, describe how you're feeling after today's presenters or certain takeaways you have from today's sessions. Now, I know that's a big ask because we've had 5 different speakers, over 5 hours of training, and a wide variety of topics. So there's a lot to choose from, but try to keep it brief And you can either scan the QR code as seen above, or you can go on menti.com and enter the user code, which is 16787766. So throw your one-word responses or at least short phrases to your takeaways and your feelings at the moment. And I'll give another moment here, and I'll zoom in a bit so we can kind of see the responses. So getting a wide range: informed, affirmed, inspired, educated, exhausted. It is a long day. So thank you for going through the whole seminar with us. Prepared, educationally sound, moderately more competent. You know, if there's anything we can try to strive for, moderate more competency. Updated, refreshed, tired. It has been a long day. Well, thank you all for submitting your responses. Before we break for the day, we do have a couple more things. And what I'd like to do, before I joined this role as communications director with the commission, I did have a background working with youth, so I'd like to throw in little icebreakers and stuff like that. So I just want to get a temperature check, everybody outside of our reflection here. For the folks in person, if you can just show me through your hands, 1 through 5, how are you feeling right now? 5 is feeling amazing, incredible. 1 is I'm dead tired. It's a long day. Let's get home. And then for folks online, if you could throw it to the presenters, you could throw a 1 through 5 in the chat. But can I just see everybody just share by show of hands where you're at, 1 through 5. How are you feeling today? Okay, seeing some 3s, seeing some 4s, couple 5s. Surprised I haven't seen so many 2s and 1s. So maybe folks that are who aren't raising their hands are feeling that way. Okay, yeah, a few down here. Well, I appreciate you all for being with us throughout today. It's been a long and informative day with some incredible speakers and experts in the fields of employment law and human resources. Now up, I would like to invite our General Counsel, Will Wade, for our closing words. Everybody, please give a warm round of applause. Will Wade.
Thank you for the photo, Jacob. I don't know if that was necessary. I know we're all eager to go home, so I'll be brief. On behalf of the commission, I want to thank all of y'all for attending. Whether you came in person or online, I hope the training you received today was valuable. With that said, I want to give a shout out to all our presenters who took a large amount of time out of their busy schedules to come here and provide us with very valuable information. So can we give a round of applause to all our presenters today? On behalf of the commission, I'd also like to thank the EEOC and DOHR. Without y'all's assistance, this event wouldn't be possible. So can we give a round of applause for our partners? And then I'd also like to thank Jacob and the ELS Planning Committee. They had dozens of meetings. There was a lot of thought to this, and truly without Jacob and the team, this also wouldn't be possible. All right, so before we wrap up, there's just a few items of housekeeping I want to take care of. One, evaluations. I think everyone that attended in person today should have an evaluation in your materials. If you would, we please ask that you fill it out. Those evaluations are invaluable. You can tell us what we did right and then maybe what we can do better next year. Second, and probably most importantly, let's talk about the accreditation. That's the reason we all came, for the CLEs and the HRCIs. So with that said, would you please review the form in your programs? CLE attestation forms can be turned in at the registration tables. And if you're here for HRCIs, those can be completed on their website using the activity ID code. So for our online attendees, please keep an eye out for an email featuring all this information and the links to the online evaluation and attestation forms. Lastly, please connect with the speakers, our fellow attendees, and review the resources shared in your materials, as they may be useful in our future endeavors. So with that in mind, thank you all for joining us. I hope you have a great evening, and the 2024 ELS is adjourned.